Right, if we are all ready, I declare open this meeting of the Education and Employment Legislation Committee on Wednesday the 27th of October 2021. The Senate has referred to the committee the particulars of proposed expenditure for the 2021-22 budget and certain other documents for employment and industrial relations matters within the Attorney-General's portfolio and the education, skills and employment portfolio. The committee may also examine the annual reports of departments and agencies appearing before it. The committee has decided that answers to questions on notice will be required to be returned by close of business on Friday, 10th of December. The committee has resolved that written questions on notice should be received from senators by close of business on Thursday, 11th of November. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has resolved that resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on a matter of policy and shall be given reasonable opportunity to refer questions asked of the officer to the superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I draw the attention of witnesses to an order of the Senate of 13th May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. An officer called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones. Mobile phones should be switched to silent. Senators, departments and agencies have been provided with the advice on the arrangements in place to ensure the Supplementary Budget Estimates 2021-22 hearings are conducted in a COVID-safe environment. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. Today, the committee's focus will be on industrial relations matters under the responsibility of the Attorney-General's Department. I welcome the Minister for Industrial Relations, Senator the Honourable Michaelia Cash. And I would also like to welcome representatives from the Attorney-General's Department, including Mr Ian Anderson. No, he's not here, so my script is wrong, but I do welcome.
That was yesterday, that's
I
all right.
do welcome Ms Catherine Jones, and I welcome you, Mr Martin Eyre. Great to have you here. Mr Cash, do you wish to make an opening statement?
I don't, thank you, Chair.
Well, that's wrong, but Ms Jones or Mr Eyre, would you like to make an opening statement?
Yes, thank you, Chair. I won't make an opening statement, just noting this is my first time as Secretary appearing before this committee. Just noting that we have all our key senior personnel here to attend, but we've got people moving out from various places.
Yes,
so we'll orchestrate that as smoothly as we can for the committee.
We understand.
If it assists, if there is a block that you wanted to let us know of, that way we can ensure that otherwise it does take time to get people from the room.
Yes, I understand. And congratulations, Ms Jones. This is my first chair of this committee too. I believe we do have everything in a block here, really, don't we? So, look, if senators do have questions of individual areas, I suppose I'm happy to coordinate that and do that all in one go. So, but with that, I think we're going to hand to Senator Pratt.
Thank you, Ms Jones. Just at the outset, in terms of organising the committee today, I wondered if you were aware that Safe Work Australia, as one of your agencies, had said that they didn't consider that they'd been reassured enough that Parliament was a safe COVID workplace.
Thank you, Senator. I have been in conversation with Michelle Baxter, the CEO of that agency, and obviously that's a matter for her to raise with the Department of the Senate. I'm waiting to hear the outcome of the discussions in terms of her appearance today. She's obviously available to appear.
Yeah, no, we have resolved that we will allow, considering that the Safe Work Australia agency couldn't resolve it to their satisfaction before estimates today, we felt that we were in no other position other than to allow them to appear remotely. But it does raise questions for me as to why Safe Work Australia has questions, but it doesn't appear that any other agency has raised those same kinds of concerns. Have any other agencies in your portfolio raised those concerns?
Not that I'm aware of, although I think both Safe Work Australia and Comcare obviously have important interests in this space. I should note, I did contact the Secretary of the Department of Parliamentary Services this morning just to make sure that he was aware of this issue. Obviously, it's the Department of the Senate that's responsible for Senate committee hearings and the arrangements for supporting Senate committees. In terms of the general approach around COVID-safe arrangements, obviously it's a matter of doing an appropriate risk assessment in the circumstances, depending on the actual operation of the committee, the accommodation. What might be safe in one committee room could be challenging in another committee room.
I understand all of those. I
Yeah.
guess the question is, Safe Work Australia is the agency responsible for setting the protocols in relation to safe workplaces, and I'm somewhat confused that they have a different assessment to other agencies when other agencies are supposed to role model and learn from them. So I'm really trying to work out what kind of job Safe Work Australia is doing in this regard if other departments haven't asked the same questions, and this is the agency that's supposed to be showing leadership to the whole of Australia.
I think in terms of the advice we're receiving from Safe Work Australia and working with them, and I held a meeting with Safe Work Australia, Comcare and all the agencies in our portfolio last week, specifically to talk around COVID arrangements, getting advice around appropriate approaches to risk assessment. So we've certainly been consulting closely with Safe Work Australia to take on board their advice about what are the appropriate steps to take to assess what's appropriate in a particular department, in a particular space at any time.
Why have they come up with a different assessment to all the other departments here? Surely people should be following their lead.
Senator, if I may, it's Martin Hare, the Deputy Secretary for Industrial Relations Group. So one of the factors that has to occur in work health and safety assessments, you actually have to consider whether your team has vulnerabilities. So in that respect, everything is an individual assessment.
Yes, and we've been through that with the Safe Work Australia agency. We gave them leave not to send anyone with vulnerabilities. They, of course, said that they were worried about the chains of transmission. Should someone acquire an infection here and take it home to someone with one of those vulnerabilities, which is why universally they wanted to appear remotely, which really left me in the position of wondering, well, isn't every other person in this workplace in exactly the same position? I'm sure the chains of if COVID were here, which I'm pretty, there are good protocols here in this building, that there would be the same kind of vulnerabilities.
So not necessarily, Senator. So it's entirely possible, as with my family, that all members of my family are double vaccinated. So I'd be less concerned about that and less worried about the transmission. There may be people who have young children who have not yet had the opportunity to be vaccinated, and they might well be worried about those.
Right, so you're telling me
chains
that
of transmission.
every other department that's appeared in estimates has done that due diligence to check any vulnerability for chains of transmission in terms of elderly parents they might have contact with, children, people who are immune compromised, and that no one else has set foot in the building because Safe Work Australia is right.
So, Senator, I'm not saying that at all. What I'm saying is that it's the responsibility of the PCBUs to do that assessment. That's something that this department has been doing consistently. The Secretary has sent out a number of messages to our team about the return to work phase and identified that we're aware of those sensitivities where people are uncomfortable about transmission. So it's certainly an issue, and we are being, as a department, appropriately cautious in our return to work in relation to those things. But yes, it's the responsibility of the individual PCBUs to undertake that.
Just like it's the responsibility of every individual business in Australia that brings people to work to ask those same questions. Do you think Safe Work Australia has provided enough guidance to those businesses to work through those issues?
So, Senator, the Safe Work Australia website has provided sound guidance through the COVID pandemic, in our view. That may be a matter that'd be better put to Safe Work Australia when they arrive, but certainly the feedback that the department has got from working with unions, business peaks, and Safe Work Australia representative body has been that there's been a strong coordinated approach to the provision of information.
Information like promoting the COVID Safe app as a means of contact tracing. That's one of the examples they use. Do you encourage everyone to turn that on the way into work this morning? Is that part of your work protocols, or do you prefer to use the check-in app, which wasn't mentioned?
The codes for entry into the rooms and to the building are Check in Canberra, to my knowledge, so we use the Check in Canberra app.
Not the COVID Safe app as the Safe Work Australia suggests. I'm sure they're, you know...
I'm not saying that people aren't using that. What I'm saying is the codes are linked back to the Check in Canberra app, so there's no choice but to use the Check in Canberra app.
No,
whether
it's-
people are using the
And
other
that
apps
state
is up to them.
regulation has been very, and territory regulation right around the country has been very strong. I'll pass now to my...
Just giving you, just with indulgence, I'll just quickly point out that the committee has resolved that we do expect witnesses to appear in person because that is an essential part of, we believe, the democratic scrutiny provided by these estimates. As Senator Pratt has outlined, we are willing to provide an exemption this time, given the lateness of organising these estimates and putting together all these COVID-safe arrangements. But we do expect in the future for physical attendance, unless there is some kind of significant health or other issue involved. Appreciate I've spoken to Ms Baxter and appreciate her cooperation in that matter. We're going to Senator O'Neill, will we? Thank you.
I think Senator
You want
Sheldon
to
wants a
make comment?
clarifying.
Yes, go to Senator Sheldon.
Just a clarifying question. Has there been an outline from Safe Work Australia on what they would have needed to become here? Because that outline would then implicate the peak safe body and everybody else about whether we're meeting the appropriate requirements. Does that outline exist?
I'll ask Mr Hare to answer that, please.
Senator, so I've been following the correspondence between the Senate and the Safe Work Australia. My understanding, one of the concerns is the consultation, and certainly we've been engaged with, as a department, with the Senate committee, and we've made assessment of these arrangements. But Ms Baxter,
COVID.
and the first estimates where we've been required to attend, where there's community transmission, which is the main concern raised by Safe Work Australia here in Canberra. My understanding is that Safe Work Australia would like to be consulted as to the detail of the safe work arrangements.
And so if they're not reassured of that, why would any other agency have been reassured of that detail if they are the experts?
So, Senator, you'll have to ask Ms Baxter, as the PCBU for Safe Work Australia, why she felt that the consultation wasn't sufficient to assure her.
Mr Jones, obviously, arriving around COVID, insecure work, there's a whole series of mental health pressures that are applying to people across the country. There is a large number of staff that come in here to these estimates, and we've received advice that the arrangements that have been made are appropriate, and they've been properly negotiated with both other agencies, other governments, the ACT Territory government. Why, just to assure everyone else that's here, why aren't they? Why shouldn't they be concerned if there's too many people sitting in this room? I'm not suggesting anyone should leave, but I can tell you what there will be some people who will be concerned about that.
Sorry, you were saying what?
So I'm
staff
trying to get to the
concerned,
point of what's the detail, because people here should know, the staff should know, what is Safe Work Australia saying is the problem here, because they might be putting themselves at risk as far as Safe Work Australia is concerned, which means they may be equally concerned as well.
So Senator, that's my understanding, and as I said, this is best put to Ms Baxter, is that Safe Work Australia were concerned about the consultation requirements and that they hadn't been personally consulted with that. They're not saying it isn't safe, they are saying that they can't, and again, Ms Baxter will walk you through this, that they would that they believe they should have been consulted in this.
How could
Well,
any
Mr.
other
Higg-
agency assure themselves it's safe if Safe
Can I just
Work
ask whether
can't?
Safe Work Australia has asked other agencies and other governments and employer associations and individual employers, certainly the large ones to start off with, that means that their safe work plans may not be sufficient. As far as Safe Work Australia is concerned, because they haven't been consulted.
No. So Safe Work Australia's request for consultation relates to the fact that they would be an other person in this facility. It doesn't go to a broad requirement for, or any broad requirement for Safe Work Australia to be consulted. There isn't a broad requirement for them to be consulted. It goes to the particular provisions which require consultation with other persons who are going to be in the workplace. In this case, this committee room.
So, Mr Hare, in that context, Safe Work Australia has seen fit to say they haven't had the opportunity to be consulted. Do you think, therefore, that they would know the issues that they're looking at about the risks that they think are here or are not here? And why, therefore, given this is their own statutory responsibility to uphold workplace safety for their own employees, why, and every other agency that has appeared has the same responsibility, why did they not all come to similar conclusions?
The requirement is for the person conducting the business or undertaking to reach their decision. So,
and so Safe Work
in this
Australia might
case,
have a higher standard for consultation and safety than other agencies. I
I'm-
don't quite understand.
I am not in a position to speak for Ms Baxter in terms of how she reached her decision on the basis of her responsibility as the person conducting a business or undertaking.
Chair,
That
and
should
to
be put to
fair,
Ms
I mean, you will
Baxter.
have Ms Baxter, I was going to say you will have her here today. You will have Ms Baxter at around 4 p.m. today, and I assume you'll put all of those questions to her.
Thanks, Mr. And that's fair comment, because we will raise a number of these issues, but there are other staff that are working for other departments in this building right now and in this room that are now aware that Safe Work Australia have not ticked off what the safe arrangements are here. That's why they won't turn up. Wouldn't it be an idea that somebody gets on the phone really quickly and gets them to do an assessment?
So, Senator, my understanding is that Safe Work Australia weren't going to do it. We're looking for consultation on the arrangements, not necessarily an assessment as such. My understanding is that Comcare have been up and had a look around as the workplace regulator, and I haven't been advised that they've found any issues of concern at this point. So given that Comcare have been here, I think staff can be assured that the regulator has looked at it. But from my perspective, each individual PCBU has to take the responsibility of looking at the matter and determining whether they feel that they're in a position to identify the workplace as being safe.
Surely, Mr Hare, it can't be their dissatisfaction just with the consultation arrangements. It's that due to those consultation arrangements, they haven't been able to satisfy themselves of the safety.
So,
Otherwise, they'd be here.
Again...
And I don't understand how any other agency could have satisfied itself if they're supposed to be the lead agency for workplace health and safety and they're not
If I
satisfied.
can just add, just from the perspective of the Attorney-General's Department, the committee secretariat engaged with us in the lead-up to these hearings. There was quite a lot of discussion back and forth. They provided us with the protocol for witnesses and other staff appearing. We assessed that. We felt it was appropriate. I think in terms of any concerns from Safe Work Australia, as the attorney has pointed out, we probably need to hear from them later today.
Thank you.
It does beg the question, though. Who knows best? The Secretary of the Department or Comcare or Safe Work Australia? If it's that much of a mess with all the resources of government, think about the challenges facing small businesses across the country right now. This is just a sign of, a failure, I think, by the government to actually manage this workplace in a way that is model for the rest of the country. And that concerns me. I feel pretty safe to be in the building myself. I'm going to trust Comcare over Safe Work today, but I'm surprised that that matter wasn't resolved by the department.
And it is equally concerning with Safe Work, in previous questions and estimates, that they said that they were preparing guidelines for various industries about dealing with COVID, and they can't do a guideline for the Parliament of this country. So I'm deeply concerned that what's going on structurally there, and also deeply concerned about why they haven't been required to do that appropriate step.
Thanks, Chair. I'll move on to another topic.
That's okay. Look, I was going to go a 15 minutes block, but we'll give you guys another 15 minutes and then we'll rotate.
Just to get a crack open. Thank
Yep.
you very much. So, Senator Cash, I'd like to ask some questions about the Respect at Work legislation. And I do note, and this was part of the conversation in the chamber, recommendations by the Respect at Work report for amendments to the Fair Work Act were not part of the legislation that was put before Parliament. Specifically, I refer to recommendation 28. Now, that is to clarify that sexual harassment be expressly prohibited in the Fair Work Act. And that seems a pretty straightforward recommendation. Why was that provision not included in the bill put before Parliament?
I will just get the relevant officer to come to that. Just so you also know, we did actually canvass this in detail yesterday, but I understand you're looking at the Fair Work aspects.
I am,
of it.
Senator Cash.
Yeah, that's fine as well. I'll get the
and
relevant officer to take you through it.
I prefer to have a response from you. My question was to you, Minister.
And I'm happy for the officer to take you through the detail.
So, Chair, can we get a clarification? My understanding is that I get to direct the questions to whom I wish to have
And
them
I'm able to
directed.
direct it to the relevant officer if appropriate, and if there's anything else to add, I will add it. So I'll get the relevant officer in the first instance to take you through it.
Chair, what's your ruling on that?
Sorry, I just missed
Well,
that.
it's pretty clear in the standing orders that that's correct. So it's not a matter for a chair to rule, it's the standing orders.
Chair, can I ask you to check and come back to me? I'll take the answer from the Secretary, sorry, Miss Matthews.
Thank you, Senator. Alexandra Matthews, First Assistant Secretary, Employment Conditions Division. Senator, the government did accept that recommendation in principle and noted that they would review once the first tranche of amendments were made to the Fair Work Act and the Sex Discrimination Act. As you'd be aware, there were amendments that were included to the Fair Work Act in the first tranche. Specifically to enhance the stop bullying jurisdiction of the Fair Work Commission to include sexual harassment, and also to make clear that sexual harassment can be considered serious misconduct for the purposes of the unfair dismissal provisions.
Thank you, Ms Matthews. I really don't want to cut across you, but I did ask, and you clearly have a very deep and helpful knowledge. Thank you. So when we get to that part, and I want to ask the detailed questions, but this is a question really that I don't know that you can answer because it's about a decision. That's why I directed it to the Minister, which is why was that provision not included in the bill that
Chair,
was
to
put
be
before
fair, that's
Parliament?
exactly what the official was actually explaining. What we had said in the roadmap was is that we were committed to consider implementing recommendation 28, which, as you said, is to review the Fair Work Act to expressly prohibit sexual harassment. But we said we would do that once recommendation 16, which was a number of legislative changes or amendments to the Sex Discrimination Act, have been implemented, and we can actually then assess the impact of that. And yesterday in the Attorney-General's Department, under this relevant section, we went through the work plan in terms of the consultation that is going to be underway in relation to all of this.
So I want to be assured by your comments there, Senator Cash, and I am at a disadvantage in that I haven't, I wasn't watching your exchange yesterday. But as I understand it, the question that I'm asking is really with the express prohibition, and so recommendation 16 has nothing to do with the express prohibition. So can I just put it again to you? Specifically, I refer to recommendation 28, which is to clarify that sexual harassment be expressly prohibited in the Fair Work Act. And I think I have read the entire 900 pages of the Respect at Work report. I think it's an amazing document that voices women's concerns. Right at the heart of it is that sexual harassment should be expressly prohibited. And when the government stands up and says, we support all the recommendations in principle, and then determines, as it brings its first tranche of legislation, not to put in the express prohibition, my question goes to why was that core fundamental requirement not embedded in the legislation?
And Chair, I think I did just answer that question directly. We have not rejected this recommendation. We have said that it requires further consideration, and that's what we are doing. We are looking at the impact of the changes to the Sex Discrimination Act, noting that you'd be aware that we did make some changes to the Fair Work framework, including amendments made separately to the bill, to the Fair Work regulations, and in particular clarifying that sexual harassment can constitute serious misconduct, and that allegations of sexual harassment can be raised under the existing stop bullying jurisdiction. But as I said, we are going to review the Fair Work Act review it once the other changes have been assessed. That was it.
I don't understand how it could be so hard for the government to actually commence its first tranche of legislation with an express prohibition of sexual harassment, because that is the fundamental issue that confronts particularly women in the country. So you've made a choice that would be delayed.
No, we said we were committed to considering recommendation 28, which, as you've said, is to make the change to the Fair Work Act,
Yes.
once we've assessed the impact of the other changes.
So it's a decision of government not to do that, and I still
Chair,
haven't got an understanding.
I am being verbaled. That is not what I said.
Well, not to do that at the time that you brought forward the first tranche of legislation.
That is correct, and I was very upfront about that. There were certain changes that were proposed that we needed to understand the impact of other changes that were made.
Was it your advice that the recommendation not be implemented via the legislation
Well, it
as
was
per
a
the
decision of
Respect
the
at Work
Cabinet, and I
report?
can't go into Cabinet deliberations. It was a decision of the Cabinet.
I want to think that you're unhappy that that got overturned by Cabinet, that of all of the recommendations that the government expressed in principle support, that you would have fought for recommendation 28 to be right at the forefront.
Senator O'Neill, when I was appointed the Attorney-General, within days I had settled the response to respect at work. Within months, we had drafted legislation and gone to consultation. Around 6 months after we released our response, a package of legislation was put through the department. If you would now like the department to take you through exactly where we are on all of the recommendations, because we are making outstanding progress, I am more than happy for them to do that. I am very pleased with the progress that the government has made.
Thanks, Senator Cash, for the offer, and I might do that once I finish my line of questioning.
We can go through each recommendation for you.
I don't know that we'll have time for all of that at this stage, but what I want to understand is, with regard to recommendation 28, why did you refuse Labor's amendments in the bill when you knew it would have easily passed and might have actually helped prevent workplace harassment?
Well,
there was an
again,
opportunity to get this job done at that time.
A substantial package of legislation to the Parliament. I'm very pleased that the Parliament did choose to support that package of legislation. And in relation to that particular recommendation, again, to review the Fair Work Act to explicitly prohibit sexual harassment, as I've stated, once recommendation 16, and that is being a range of amendments to the Sex Discrimination Act, has been implemented and its impact can be assessed, we can then consider what we will do with recommendation 28.
So
it is important, though, that you actually do consider the impact of other changes.
look, I'm sure that you can explain that in terms of a job of work for you, but the reality is that this critical recommendation was a preventative one, and right now there isn't prevention, despite your best endeavours to bring something to the Parliament, and I will acknowledge that was done in a more timely fashion than your predecessor.
Thank you.
However, it's not going to prevent sexual and sex-based harassment because it's not been undertaken, despite the fact that it could have happened. Neither of the two legislative recommendations that would actually help achieve that were not included in the bill. And I'm referring, of course, to the positive duty in the Sex Discrimination Act, which, of course, belongs to another portfolio. But importantly, an express prohibition in the Fair Work Act. Why is that?
Thank you, Mr Hare.
Senator, I just want to clarify. So we do need to recognise that the Fair Work Commission has actually made a number of decisions around sexual harassment and finding that behaviour inappropriate in the workplace. So the decision to delay was taken with the understanding that the Fair Work Commission had already made a number of decisions clearly recognising that that behaviour was not appropriate in the workplace. And the clarification around making it clear for the anti-bullying area that even one instance of sexual harassment constituted bullying will help change that dynamic. So certainly from the actual operation of the Act, it's clear the Fair Work Commission is reading that behaviour appropriately as inappropriate.
Mr Hare, I just want to be clear, is that the answer you just gave, you're saying that when this inquiry was carried out into Respect at Work, that they did not take into consideration the decisions from the Fair Work Commission?
I'm not saying that at all. I'm saying that was the
That's
government's
okay.
consideration.
Thank you. Can I ask a question? Look, I'm trying to understand what happened here. Your department advised the Respect at Work Council that it's developing a work plan for implementation of the remaining 6 legislative reforms.
That is correct.
From the Respect at Work as a priority, including consideration of how a new positive duty would interact with WHS obligations. Is this the plan to which you were referring earlier, Senator Cash?
That was discussed yesterday.
Yes, okay. So perhaps for this committee it is important to get it on the record.
And that's exactly.
So what is the plan for the implementation of the remaining 6 legislative reforms from Respect at Work? And that is recommendation 16A and C.
Yep. I'll get the relevant
17,
officer to come to the table
18, 19, 23, 25 and 28. And if you could, in addressing those, indicate what budget has been allocated either as a job lot to the whole lot or if it's separated out, provide that detail. and the timelines. Thanks.
Just, Senator O'Neill, we might make this the last question, if that's okay. before
Yeah, that's
we
a
rotate
natural
the call,
break.
'cause
Thank
it sounds
you,
like this
Chair.
might be a lengthy answer.
Senator, while our colleague is just finding the correct information, but also note that Commissioner Kate Jenkins appeared at yesterday's hearing, the Legal and Constitutional Committee, and talked about her role as chairing the Respect at Work Council, which is playing an oversight role in terms of the implementation of all these recommendations, and talk to the progress that was happening against implementation across all 55 of the recommendations, some of which are directed at the federal government, some of which are state and territory, some of which are business.
Yeah.
So she gave a good overview of progress there as well.
And I'll look forward to reading that, Ms Jones, but these are particularly with regard to the legislative reforms that were indicated for. So if we can confine it to those ones in the answer, 16A, C, 17, 18, 19, 23, 25 and 28. And Ms Huender, is it?
Yes. Sharon Hunder, Assistant
Hunder.
Secretary, Industrial Relations Strategy Branch. I would say that my area has responsibility for the Respect at Work recommendations that relate to the Fair Work Act. We do have the task force, which were here yesterday, who look after the broader Respect at Work response, but I'll take you through the broad consultation plan for those remaining legislative responses. So the Attorney-General's Department will do public consultation on the remaining legislative recommendations, so 16C, 17, 18, 19, 23 and 25, commencing in December of this year and going until February of next year.
Can I just clarify there that excised from my list are 16A. Are you doing any work on 16A? You said-
16A is on my list, but I will confirm.
Because you've got, I think you said 16C, 17, 18, 19, 23 and 25, is that correct?
That I did
So
say that, Senator.
16A is missing and 28 is missing, is that correct?
28 I'll get to a bit
Thank
later,
you.
but certainly in terms of the initial ones, and I'll confirm around 16A. So public consultation on those recommendations from December until February 2022. The department will prepare or consider the stakeholder views and prepare advice for the attorney in March and April of next year, and then the government will agree on the next steps following that. In relation to...
So to be clear, given that these are the sort of the end days of this particular administration up to May, potentially, if the government seeks a re-election at that point of time, what legislative action can be taken between now and the election with regard to the Respect at Work further amendments that are required?
I think that's a little unfair for the official, because you've put to the official that the government may or may not call an election at a particular point in time. The official has outlined what the plan is in terms of consultation. I will be given that advice and then I will look at what we can do.
So when do
Senator
you...
O'Neill, we might rotate the call, if that's all right. We can come back.
I haven't had an answer to that. Can I just ask...
Well, this is absolute last question.
Yeah,
You've
so
been over the
this is a
15
clarifying question. If I heard your timeline correct, and it is a matter of fact that we are going to an election as a country, a federal election, up to as late as May next year, what legislative action is possible for the government? What timing is possible for the government to actually do what they
That
said?
decision for government, Senator O'Neill, at the time.
Did I mishear that December 22 is the date at which the consultation completes?
It completes at the end of February, during February 22, and we would provide advice to the government, and the government would consider its decisions from March 22 onwards.
Thank you, Senator
sorry,
O'Neill. We
you
can
said
come
sorry.
back.
I
We
did.
can-
Yes,
we can-
so
you've had a
it says
good run.
December.
Confused
Yeah.
myself, sorry.
Thank you.
Let's, yes.
You've
Thank
had a
you.
good run. I'll go to Senator Small.
Thanks, Chair. Minister, we were focused earlier on the first tranche of amendments with respect to the Respect at Work reforms. Can you outline actually what were included in those first tranche?
Thank you very much, Senator Small. And yes, I can. In the first instance, in terms of the legislative changes that the Parliament did support, we clarified that in addition to the elimination of discrimination and harassment, and this was very much in terms of the objects of the Sex Discrimination Act, The Sex Discrimination Act aims to achieve, so far as practicable, equality of opportunity between men and women. We also clarified that sex-based harassment is prohibited in the Sex Discrimination Act, and we did this by an express prohibition. We also removed the current exemption for state public servants in relation to sexual harassment and discrimination in the workplace under the Sex Discrimination Act to ensure that they are also protected from such conduct. We also clarified that the Sex Discrimination Act applies to members of Parliament, to ministerial staff and to judges. That was actually a government initiative. We ensured the scope of sexual harassment prohibitions in the Sex Discrimination Act covers all forms of workers. We ensured that a person who causes, instructs, induces, aids or permits someone else to engage in sexual harassment under the Sex Discrimination Act can also be found to have engaged in the unlawful conduct under the existing ancillary liability provision. We clarified that victimisation can form the basis of a civil action under the Sex Discrimination Act. We clarified that the Fair Work Commission can make an order to stop sexual harassment in the workplace. We confirmed that sexual harassment can be conduct amounting to a valid reason for dismissal under the Fair Work Act. And we also, and this was also a government initiative, but it was something that was welcomed widely by the Parliament, we enabled an employee to take compassionate leave if they or their current spouse or de facto partner has a miscarriage.
Thanks, Minister. And maybe one for you, Mr Hare. The Respect at Work report concluded that there was a positive duty on employers to eliminate or minimise risks to health and safety as a result of sexual harassment in the workplace, but I think conceded that the existing framework was not particularly well equipped to deal with those very complex issues. So can you please advise what work is being undertaken, not only within the department and government, but also within agencies such as Comcare and Safe Work Australia, to strengthen the workplace health and safety framework to better deal with psychosocial injuries generally and matters related to sexual harassment more specifically?
Thank you, Senator. Yes, so the report was clear that there are existing arrangements in place and did indeed raise a number of concerns about how effectively that positive duty was being implemented. But I might ask Ms Anderson to work you through the detail, but it is important to note that the Boland review of the Work Health and Safety Act specifically looked at a number of those issues and made a number of recommendations. The Attorney chaired a meeting of Work Health and Safety Ministers which went through the recommendations of the Boland review, and there was unanimous agreement around the majority of those recommendations, particularly recommendations that looked at substantially improving guidance for WorkSafe agencies and for businesses in terms of how to address sexual harassment in the workplace. But I might pass to Ms Anderson.
Jodie Anderson, First Assistant Secretary of the Safety and Industry Policy Division. As Mr Hare just mentioned, there is an existing positive duty under the Work Health and Safety laws where employers and PCBUs basically already have a positive duty to ensure that all persons in the workplace, including workers, are not exposed to health and safety risks. However, given that that is the case at the moment, but as Mr Hare said, ministers overwhelmingly agreed back in May of this year that regulation should be amended to put that beyond any doubt. So Safe Work Australia are currently well advanced in terms of an amendment to those regulations to amend the Model Work Health and Safety regulations to deal with psychological risks, including sexual harassment. And so that ticks off a recommendation from both the Boland review into the Model Work Health and Safety laws and also recommendation 35 of the Respect at Work report. In addition to that, Safe Work Australia has already taken steps to support businesses and workers to understand their rights and obligations by developing and publishing national guidance material on preventing workplace sexual harassment under the Model Work Health and Safety laws. The guidance provides detailed information for PCBUs on practical ways to prevent sexual harassment at work and how they respond to cases of harassment, and includes specific information sheets as well to assist small businesses and workers to meet their work health and safety duties as it relates to sexual harassment. In addition to this, as part of the 2021-22 budget, the government also made a commitment for Comcare, the Commonwealth Work Health and Safety Regulator, to deliver national forums for Commonwealth, state and territory work health and safety inspectors on sexual harassment. They're also looking at delivering training for employers and managers covered by the Commonwealth Work Health and Safety laws to better understand and meet their obligations in relation to sexual harassment under the laws. And also Comcare, in addition to the Safe Work Australia material, has also published guidance within our own jurisdiction around supporting employers and managers meeting their responsibilities in relation to sexual harassment. In terms of that national forum, that's being undertaken for 2 days on the 11th and 12th of November, so shortly. The first day is open to the broader community, and then the second day is really targeted at work health and safety inspectors to build that confidence and knowledge base in work health and safety inspectors around the sexual harassment and psychosocial duties. So obviously we acknowledge that the Jenkins report did highlight some concerns around inspectors' abilities to deal with some of these issues, but this training is really targeted at some of those concerns.
Thanks for that detail, Ms Anderson, and I think in light of that meaningful progress and ongoing consultation, can I perhaps return to you, Minister? And I think it'd be helpful to understand, with respect to all of the Respect at Work recommendations, how many have either been fully implemented or at least fully funded, and what's the status of the remaining recommendations that government's working through?
Thank you very much, Senator Small. In terms of the status update, 41 of the 55 recommendations have either been fully implemented or fully funded. Work is underway on all remaining recommendations, and as I'd previously stated, no recommendations had been rejected. As we've already gone through, we've already implemented key legislative recommendations as part of the Respect at Work legislation that passed in September 2021, and you've just heard the officer go through in relation to the 6 remaining legislative recommendations that were not included in the Respect at Work legislation that has recently passed the Parliament. They require, as I said, further policy consideration and consultation to ensure that the reforms are fit for purpose and don't increase the complexity for those that are seeking to utilise those protections. And as you've also heard, the Department will now commence the public consultation on those remaining legislative recommendations. In terms of many of the other remaining recommendations, they were actually directed to state and territory governments, to independent agencies, to regulators and the private sector. And obviously, when you read the report and you read what Kate Jenkins had said, it was very much about recognising the whole of community approach required for real change to occur. But additionally, in terms of the recommendations, we'd already undertaken a significant body of work, as you'd be aware, in terms of implementing key recommendations of the Kate Jenkins Respect at Work report. And they included establishing the Respect at Work Council, which was all about improving coordination, consistency and clarity across the legal and regulatory frameworks. We're progressing work on recommendations requiring joint action, because I said some of them were actually to the Commonwealth, to the state and to the territories. So, for example, through intergovernmental meetings at National Cabinet, the meetings of Attorneys General, the Women's Safety Task Force, and, as you've just heard Mr Hare refer to, the work of the Occupational Health and Safety Ministers. We also committed, you'd be aware, in the budget, $64 million, or over $64 million actually, to implement the roadmap for respect. And we've talked about, obviously, the legislative changes that went through. But in terms of either fully funded or fully implemented, it is now 41 out of the 55 recommendations. Work is underway on all remaining recommendations. And I'm happy for the officer to take you through anything further that may be required.
I doubt that there was much left to left for the department after that answer, Minister. I'm happy with that, Chair.
I might just finish.
Mr Hare does have
going to
something.
Oh, sorry.
clarify. Senator O'Neill asked about recommendation 16A. My notes say that that was actually passed.
So that was a note I had as well. I'm glad you've brought that up. I was trying to check on that myself for you.
So that was included in the legislation that was passed.
16A.
Yeah.
Thank you, Mr Hare.
Well, I think Senator Small, you're finished. Senator O'Neill, we'll go over to Senator
We
O'Neill.
can go back to working our way through 16C, 17, 18, 19, 23 and 25. And then we'll come to 28.
So we've gone through the government's approach to recommendations up to recommendation 25, and then recommendation 28, as the attorney's already outlined, was one where the government was going to consider the impact of the amendments that were just made through the Amendment Act and make any and adjust as necessary following the assessment of those changes.
So can I just clarify what's the budget allocation for
the
next steps, for 16C through to 25, as we've discussed?
Senator, I'm not aware that there is a specific budget allocation for the
In
consultation.
terms of the work around the legislative proposals, that is the work of the department. We've created a task force and have put senior officers there to progress that work. But it's part of the core business of the department to progress the legislative amendments.
So no funding allocation but core business. How big is the task force?
Can I take that on notice in terms of the specifics?
And can I might get Mr Hare to take, we actually did allocate in the budget the $64 million to implement the roadmap for respect. There might be an officer here that can take you through,
This
as I said in response to
legislative-
Senator Small.
Yeah. I was listening to that. Do we know, Mr Hare?
I'm just going to have to check. So that actually sits with the Deputy Secretary, Sarah Chidgey.
So that was yesterday.
So that's dealt with there.
So we can actually get that, we can refer it back to Attorneys General and get that responded to by the Attorney General side of the portfolio. That's where the actual Respect at Work main body of work is sitting.
Okay, so if I could be clear, could you give me a sense of the task force, how many people are working
Are you
on
happy
it,
for us to
at
take
what
that on
levels?
notice and refer it back to-
It seems that we're going to have
Yeah.
to. I mean, you might be able to get back to me today. It might be a relatively simple question.
I'll look into that and come back if I can today.
Thank you.
Senator.
And the other part of that, in addition to the staffing and the staffing allocation, is the timeline and the proposal for the job of work to be done. The timelines?
So the roadmap basically.
Yes.
Yep.
Yes, thank you very much. Okay. If I could go to recommendation 47 of the Respect at Work report, and it supports the development of industry and profession-wide initiatives to address sexual harassment. And I do note the comments of the officer who was here just a little while ago. Sorry, was it Sarah? So I didn't write the name down, the lady sitting behind you, Miss Gwenda.
Jodie Anderson.
Jodie Anderson.
Miss Anderson. And the government has said and reiterated this morning that it accepts the recommendation, but it's simply referred to initiatives already underway, such as matters such as the SDA, the Shop Distributive Allied Union, the Union for Retail Workers, and it says the No One Deserves a Serve campaign, which has been running for several consecutive years now and is really very important in trying to change the culture of exploitation and harassment in the workplace for people who've been on the front line of retail. As I understand it, and you might correct this, there's no new funding committed to support future industry collaborations to prevent sexual harassment.
Well, Senator O'Neill, if I'm Looking at recommendation 47, this was actually one that was directed towards key industry and professional groups themselves. So we noted that the government welcomes any initiatives to support the prevention of sexual harassment across the private sector and strongly encourages the sector to engage with the Respect at Work Council. But that was a recommendation, and I think I took Senator Small through. Not all of the recommendations of the report were actually to the Commonwealth Government. Some were to the Commonwealth Government, some were to the Commonwealth, state and territory governments, some were to industry bodies, some were to the private sector. This is one, recommendation 47, and I'll just read it out, Chair, just for the Hansard record. Key industry and professional groups, unions, employer associations, employers and other industry bodies collaborate to establish industry and profession-wide initiatives to address sexual harassment for Australian workplaces of all sizes. Initiatives may include industry-wide prevalence surveys, awareness-raising campaigns on industry-specific issues, or the development of industry-specific policies or accreditation requirements. So that is for the private sector, obviously, to implement. And in fact, one of the examples that I was given was the Minerals Council of Australia. They themselves released an industry code on eliminating sexual harassment on the 7th of July 2021. And then the Law Council of Australia released its National Action Plan to reduce sexual harassment in the legal profession on the 23rd of December 2020. Science in Australia, Gender Equity is actually collaborating with the Sex Discrimination Commissioner to convene national key leader roundtables on sexual harassment and incorporate Respect at Work recommendations actually into their accreditation pathways. And I think you yourself just referred to the SDA, the Shop Distributive and Allied Employees Association. They themselves have partnered with the Australian Human Rights Commission to tackle sexual harassment experienced by retail and fast food workers. And I think it was back now in October 2019 that the SDA launched the No One Deserves a Serve campaign, I think, which is what you were referring to.
It's been running for several years.
Just on the Respect at Work Council as well, though, that's progressing a number of recommendations in consultation with the private sector. And I don't know if we've got someone here who can talk to the work of the Respect at Work Council itself. You'd be aware, obviously, Michelle O'Neill, President of the ACTU, is a member of the Respect at Work Council. And I have to say, I think the Respect at Work Council, unions, employers, industry groups are working very well together in terms of the collaborative approach. But recommendation 47 is for the private sector to implement. But I might just see if any further information can be provided.
It would need to be referred to the task force in the department in relation
We
to
can
the
refer it to the
Respect at Work
task force in the department
So if you
and
could provide more
further
information
to you.
on notice, that would be helpful. But if I can just indicate, Senator Cash, that earlier on you indicated the seamless connection of this right across, so across all parts of the public and the private sector. My question goes to such initiatives can be written up, documents can be created, that costs money for those industry groups just to do that. But the implementation of change, the support of change, costs money to implement. Now, my question goes to, has any funding been committed to recommendation, the implementation of recommendation 47, to assist the groups that you've just been talking about? Because that work is the prevention of sexual harassment at work. And that seems to me the main thing that we want to achieve, not a retrospective correction of harassment that's already happened, as much as that work's important. It's the prevention that really is at the heart of the Respect at Work.
It's all incredibly important. It's
of course,
from the
but prevention is better than cure, I think, in this situation, Senator Cash.
We are going to get you the breakdown of the $64 million, but we've got to refer it back to the Attorney General's side of the portfolio. And as part of that breakdown, we'll be able to show you the work that the funding that we have provided to the Respect at Work Council, which has actually stood up last year, and that's where Michelle O'Neill herself sits, along with other private sector and industry bodies, and they are the ones that are working with the private sector in terms of putting together responses, so we can get you that breakdown as well. But
So
very much for
is it
this
your
one-
belief at this point, Senator Cash, that there is a funding allocation through Respect at Work, the Respect at Work Council, to support the implementation of Recommendation 47? Is that what you're telling me?
What I'm saying is this, that we provided $64.4 million in the budget, in addition to the $2.1 million provided in the 2020-21 budget to implement the roadmap. We also gave, I believe, $1.4 million to the Australian Human Rights Commission to progress 10 recommendations, including the development of practical tools and resources to support greater education and awareness of how to address sexual harassment in the workplace. And again, I'd have to refer it back, unfortunately or fortunately, to the Attorney General's Department to get you further information on that, because those tools are currently being tested with stakeholders. So I will get you a further body of work, but it has to go back to the Attorney General's Department.
Right. You may or may not be able to help me with this one. My understanding is that Recommendation 48, Minister, over the Respect at Work, is aimed at helping workplaces tackle sexual harassment by leading a new collaboration with unions, employers and employer associations to deliver information, education resources for workers and employers through an online platform.
Yes.
My understanding, and I just seek for clarification, if that's separate from what you've been talking about in terms of the work of Respect at Work Council's mandate, is that a separate initiative, Mr Hare? You're nodding. Mr Hare, do you want to take that question?
Sorry,
No, I was going to say, we provided funding through the 2020 Women's Economic and Security Statement to establish the Respect at Work online platform. And we provided funding to the Australian Human Rights Commission to lead this work. So it's fully funded and the work is underway.
Right, so is it fully funded to the tune of $70,000? Is that the allocation of funding? Because it doesn't sound like a lot of money to do that
I'm happy
job.
for the officials to confirm this. I've got the government has provided $265,510 in funding to the Australian Human Rights Commission to develop the Respect at Work website.
So, let's be clear about what we're talking about. So I'm asking about the
Recommendation
online...
48? Recommendation
48. What's the budget allocation to Recommendation 48?
I just want to make sure we're on the same... So, to support all workplaces to address sexual harassment, the Workplace Sexual Harassment Council will lead a new collaboration by unions, employers and employer associations called Respect at Work, which will deliver information, education and resources for workers and employers through an online platform. That's Recommendation 48.
Okay.
That's confirming that is the one that you're
that's what I'm
looking
talking
at.
about.
Excellent.
Which affects how many millions of Australians, Senator Cash? How many people work in Australia?
Obviously, this issue affects every Australian.
So, and in workplaces, millions of Australians.
And the government provided funding, as I've stated, through the 2021 Women's Economic and Security Statement to establish the Respect at Work online platform.
And how much was allocated to that task for millions of Australians?
I'll get Mr Hare to confirm the response I provided.
So my notes confirm the Minister's figures, which is $265,510 in funding to the AHRC to develop the Respect at Work website.
So $265,000 allocated for the education of millions of Australians.
Senator, it's to develop the Respect at Work website. The work undertaken for the material will be done separately and is part of AHRC's work.
And is there expected to be a further allocation, or is that it? Job done once, ticked off?
Well, again, we're going to get you the breakdown of the $64 million that we've actually provided via the budget to fund the roadmap to Respect. So this is but one part. You asked how much had been provided in relation to the development of the online platform. That is for the development of the online platform.
Thank you. I'll look for
And you
more
thought it was
information
70,000, so I thought you
I
might acknowledge that it was 265,510.
Well, I was a bit shocked when I was of the opinion that it was as low as 70,000. I'm glad to hear that it's 265. It's better than nothing. But I just wonder, what is the plan for the government to actually make sure that that is, further developed, available, rolled out? Because these things don't happen
No, the Respect at
for
Work
$0,
website.
and the problem and the scale of the problem is so big
No,
that it
so
needs
I
a
can add
significant
some more
investment.
information for you in relation to that then. So the Australian Human Rights Commission has engaged a project officer to lead this work. They have actually, the information I have to date, held 5 consultation sessions with the Respect at Work Council, industry and employer groups, union and advocacy organisations, government and legal, academic and policy experts to inform the development of resources for the website, because obviously it is a significant body of work, and as you've stated, Senator O'Neill, it affects all Australians. And the Respect at Work website is expected to be launched in April 2022.
Right,
So a significant body of work is underway by the Australian Human Rights Commission.
Okay, and they are auspicing that money, are they? And they're engaged in consultations? Because I just know from experience, I'm just thinking back to the GP shortage on the Central Coast, and there was an announcement by the local member about of $100,000 to bring in new GPs, and a very small amount of that money was expended for meeting fees for people to meet about the issue, and there was no increase in the GPs. So I'm really keen to make sure that this is a commitment to create a platform. The problem is not happening in the past. The problem is live and happening right now, and every day of delay is a problem. So, but $265,000 to do this really, we know that social media is a huge part of how we bring about information movement around our community. And $265,000 by comparison to some of the numbers that we've heard about, management of COVID and app development there, makes me really worried about whether this is just, window dressing. We're creating an online platform, and it's not actually fit for purpose.
That is really an unfair characterisation of all of the evidence that has been presented to the committee this morning in relation to the status update on Respect at Work. You are focusing now on one recommendation. One recommendation that is
critical
part
to
of
prevention.
A suite of recommendations, and as I've already said, in response to questions raised by Senator Small, 41 out of 55 of the recommendations are either fully funded or fully implemented, and in relation to the remaining recommendations, work is underway on all remaining recommendations. And as I also said to you, a number of the recommendations, they're actually not directed at the Commonwealth Government. They were directed at industry bodies, employer groups, the private sector, name them as you wish. But 41 out of the 55 have been fully funded or fully implemented, and work is underway on all remaining recommendations.
And, I think the report was a seminal moment for, the truth-telling about what's going on in Australia. And if no one who reads that report can come away untouched. My goal is about prevention, and this is critical to it. So I will look forward to see what the budget allocation for absolutely outstanding resources and engagement for the prevention of harm in the workplace.
Can
Final
I just ask on
question.
that, Senator O'Neill, and I do understand your concern here.
It's
So
timeliness.
when you talk about prevention of sexual harassment and you've asked for budgetary allocations, would you like us to look across portfolios? Because obviously there's significant bodies of work being done, not just in the Attorney-General's Department, but obviously Senator Anne Ruston, Senator Maurice Payne. So what we give you would only be in relation to Respect at Work. We can also, and I can seek this from other departments, so you do have that full picture of everything the government is doing, and in particular when it comes to preventative measures on sexual harassment. Would that assist you further?
Well, Senator Cash, I'm never going to say no to more information.
No, that's
so
what I
I
mean.
appreciate
Would
the
that-
offer.
because-
But if it can be separated out so that it's very clear, which
Understood.
for the answer to the questions that I've asked.
Because obviously we also, as the Attorney-General's Department, and again, we did canvass this yesterday, there's significant funding, as you know, that's actually been provided to the states and territories via legal services, the $129 million that we have provided. I can break all of that down for you as well, if that assists.
Thank you.
Yep. Okay.
My last question, I think, and then Senator Shelton has some questions.
Okay, I think Ms Jones.
Sorry,
might have
Ms
just had
Jones.
a-
Yeah.
Senator, I just wanted, I undertook to come back to you in terms of the numbers of the task force within
Yes,
the
thank you.
department. So we have 13 officers dedicated to working across the breadth of the Respect at Work recommendations.
Thank you. And
to
do you have
drive their implementation.
Sorry to interrupt you there. Do you have an outline of the SES level of those officers?
There's one SES officer leading that work, and then there's a range of officers underneath that team.
Thank you very much. I appreciate that. The Respect at Work report found that there's no specific Australian government gender equality strategy, and it recommended that all Australian governments, including the Commonwealth, develop gender equality strategies that address sexual harassment and that recognise sexual harassment is driven by gender inequality and is in fact a form of gender-based violence. Now that is recommendation 6, Senator Cash. I see you sort of diving into the documents there.
I do, and unfortunately it's not in numerical order, which always makes it a little more difficult.
But it's interesting when recommendations might be organised alphabetically when they're numbered.
I do.
Anyway, what is the plan for progressing this recommendation at a national level, including, surprise, surprise, timelines and budget?
So this was recommendation 6
Yes.
that you were referring to. So all Australian governments have gender equality strategies that address sexual harassment and that recognise sexual harassment is driven by gender inequality and is a form of gender-based violence. As this was one of the ones that was a recommendation to all state and territory governments, we agreed to recommendation 6, and we said that the government will consider with state and territory governments the development of specific gender equality strategies.
Yes.
The action required, we're finalising the national plan, which, as you know, is the shared plan by all Australian governments. That's where they include the gender equality strategies. Just in terms of an update, and I can go back to Senator Payne and Senator Ruston's department on this work. It was addressing sexual harassment and sexual violence was a theme, and you were probably online, I think, like most people were, at the National Summit on Women's Safety on the 6th and the 7th of September.
Yes.
So you probably followed all the work that was being done there.
I won't say that I was online. I believe I had other commitments that
No,
day.
that's
but
just so you know. I thought you might be telling
considerable
me something you
interest.
already knew. No, that's
Yeah.
okay. And they actually had a dedicated roundtable and a panel, and so that was a discussion there because it is done in consultation with the states and territories. We already have a number of targeted strategies that support gender equality focused on, as you know, women's safety, economic security and leadership. I'd need again to go back to Senator Payne and Senator Ruston's departments to get you the further information on that. One of the other things that the Prime Minister did, he has also led discussions, I think it was in July of this year, at National Cabinet to develop nationally consistent objectives for women's economic security by the end of 2021. So that was something that the Prime Minister himself took to the National Cabinet, and the National Cabinet themselves agreed that they would develop the nationally consistent objectives for women's economic security by the end of 2021. So there's a number of bodies of work underway in relation to that.
So I think I hear that you reported on discrete and separate events where this has come up. My question was really, what is the strategic plan?
Yeah, and
What
I think
is-
I said that was finalising the national plan as a plan shared by all Australian
But
governments.
that doesn't yet exist.
That includes
Is it finalised or is it still to be finalised, Senator Cash?
the national. Well, I think Senator Ruston's working with the states and territories to finalise it,
So,
which is the appropriate way to do it.
okay, states and territories plus the federal government.
Yes.
In unity.
The national plan.
Right, and that work is underway. How many consultations have been undertaken as
I'd
part
have
of
to
that?
refer that back now. We can go back to Senator Ruston's department and get
Okay.
and Senator Payne. They work together. I shouldn't say what they
And-
work together. Senator Payne and Senator Ruston.
So when that process, I'm trying to just discern because there was a lot of information, it was all discrete things.
Yeah.
So my question really goes to this particular recommendation, a plan the timelines and the budget.
And so we can get that for you, but it will be via another department.
Okay,
Hence why I'll need to take that on notice
What's the
for you.
end? Did you indicate an end date to the timeline is the end of this year? Did I hear that? Or
No,
not?
that was in relation to the Prime Minister led discussions at July National Cabinet to develop nationally consistent objectives for women's economic security by the end
Right,
of 2021.
okay, so that is not what I'm asking about, although it is of interest. So my question is, could you provide, if you can't do it now, on notice?
It'll be on notice, yeah.
Yeah, the plan for progressing the recommendation 6 at a national level and the budgets and the timeline.
So we'll refer it to another department, but we can do that.
Thank you. Thanks, Chair.
Okay, so are we, Senator Sheldon, there's be about 5 minutes left for this block, or do you want us to rotate the call now?
Yeah, I've got to go now, see how we go.
Okay, go for it. The call.
Just want to ask some questions about the recommendation 15, the ratification of the ILO Convention 190.
One moment. We'll just get the officer to the table for you.
Just while that's happening, I just want to maybe describe, because the ratification by the International Labour Convention concerning the elimination of violence and harassment in the world of work, ILO Convention 190, for those that aren't aware, I know the Minister is aware in the department, for those that aren't aware that are listening, that's where world governments and world employers and world unions come together to thrash out a consensus on issues that affect people right across the economy and right across our communities. This ILO convention, the Respect at Work, notes that the Australian government and employer groups voted in favour of the adoption of the new ILO convention. And I understand there is some, I just want to find out, what is the plan including budget and timelines for the implementation of recommendation 15 of Respect at Work, the ratification, that is, of course, the ILO convention?
Understood.
Thank you, Senator. So consideration of that convention is underway. As you'd be aware, treaties aren't self-executing in Australia, so we do need to make sure prior to ratifying treaties that our law is compliant, including state and territory legislation. The Office of International Law is currently undertaking that assessment to determine whether the legislation is such that the government could ratify the convention, and we will provide advice to government following that.
So, sorry, just so I'm clear, so legislation hasn't been prepared, is what you're saying?
We're still considering, Senator, whether legislation would be required. We're currently doing an assessment of whether the existing legislation across the Commonwealth and states and territories is sufficient to be able to ratify the convention.
And what's the timeline for that?
So as I mentioned, currently the legal advice is being prepared, and we would expect that we'd be able to provide advice to government by early next year.
And and what's the budget that's allocated to that?
Presently, no specific budget for that item.
It's work in accordance with the normal treaty process.
Yeah. So what is the current status of the law and practice review? Just so I'm clear on that.
Yes, Senator. So it's currently underway. We would hope to receive that by the end of this year, and we'll advise government shortly thereafter.
That's done, if I'm right, in consultation with states and territories.
Exactly,
Yep.
yes.
Mr Hare?
I was just going to say, once that process is followed, then government would need to refer it to the parliamentary committee
So
that
it
deals
go to
with
the
it.
Joint Standing Committee on Treaties, just as per the normal treaties process that governments of all persuasions follow.
Thank you, Minister. Thank you, Mr. Hare. Just picking up on the point you made before, has the law and practice review found that Australia's law and policy is compliant with the convention? You mentioned that you're considering whether there's some gaps. Are there gaps that have been identified yet?
I'm not sure yet, Senator. We haven't
our
identified
laws?
any.
Sorry?
So that assessment is underway, and we haven't received the results of that back yet.
This was raised in October 2019 by the then Minister, seeking views of parties on the 2nd of October. and we still haven't got anywhere. I haven't got a clear timeline from what you've said about outcomes. I haven't got what is the current status of the gaps in our laws, which are critical if you're going to pass. We're going to move on legislation in this front.
So Senator,
Why so long?
So it is a very long and complicated process. So the laws in relation to that convention cover a wide range of areas. So it's not just considering a single piece of legislation in each of the states and territories, it's considering multiple pieces of legislation in each of the states and territories. So it does unfortunately take some time. As Ms Matthews indicated, we believe we should be in a position to advise government early next year on the outcome of the review, including whether there are any gaps. If there are gaps in the state and territory legislation, we'll then need to work with those states and territories to actually see whether they can then amend their laws to address those gaps. So it does unfortunately take some time. In best case circumstances.
It's a very valiant answer to the question I asked, and yes, properly investigating any matter takes some time, but I'm talking about the 2nd of October 2019 on a critical convention about violence and harassment in the world of work, which the government had, and the ILO convention was supported by world governments, world employers and world unions, and now we're over 2 years later, we still haven't even found out where the gaps are, because you can't report them to me.
Yes, Senator, it does take some time. There's a variety of legislation across anti-discrimination, industrial relations, workplace health and safety and criminal legislation, and as part of the process it does take some time. There are still relatively few ratifications of that convention internationally. There's only 8 so far. Of course it's a priority, but it does take some time to assess our legislation.
Sorry, I can't see your name.
Sorry.
Sorry, apologies. Ms Matthews. But isn't there I appreciate again this question about some time. Everything takes time. Getting up in the morning takes time. What I want to just go to is that isn't there a question that there is a number of gaps you can't tell me that where they exist in various laws, and you can't. I'd have some confidence that we're progressing if you told me here's all the investigations we've done, here's all the information we've got at hand at the moment, and here's what's the outcome that we need to further investigate.
Senator, I can take on notice to provide whatever information I can. We haven't received the law and practice assessment as yet, so I don't know if there are any gaps, but I can certainly take on notice to provide more information about the process to date and whatever further information we can.
Could I just, that would be done by another department?
No, it would be us.
You could be able to do it?
Yes,
Okay,
the Office
your
of International Law
department,
within our department.
Yep.
Yeah, if you can do that, that would be helpful. It doesn't detract from my concern. It's October 2019. We're over 2 years later. An important piece of legislation still hasn't been near completion, let alone, from the sounds of it, has been given the priorities that it needs. When will unions be consulted?
Senator Shorten, to be fair, that was not the evidence that was given. This is part
That
of the
was my assessment.
Thank you.
Of the
I
evidence.
just don't want a reflection on.
Yeah, no, Minister, it
Thank
was my
you.
assessment. When will unions be consulted on the law and practice review?
I'm sorry, Senator.
When will unions be consulted on the law and practice review?
I'll just, apologies, Senator. So there is a standing forum where we do consult with social partners, including unions and employers, and we would anticipate doing that after the law and practice assessment is received early next year.
I understand that since March this year there's been that a meeting with the Attorney-General's Department since the convention of the International Labour Advisory Committee, that the last question that was raised regarding that was certainly by the ACTU, which have been raising it with the Attorney-General's Department. And I understand that the most recent discussion that's taken place is the 1st of March of this year. It's still many months ago, isn't it?
So, I mean, I'll just check that. I thought we had an ILAC meeting quite recently, Senator. I'll just check that.
Thank you, Mr. Heer.
Yes, Senator. Actually, it was that committee met recently last week.
And did it discuss the progress of the law and practice review?
I don't think that was specifically discussed, Senator, because we haven't received it yet.
Has there been consultation? I might just move to this next question. Does the government intend to ratify the ILO Convention? Minister?
Well, we need to go through the normal treaty process, as is the way any convention is looked at. There's a process that goes through, and I think what you've just heard is, or the response in terms of recommendation 15, the Australian government ratify ILO Convention 190. The government will consider this recommendation as part of the usual. The government will consider this recommendation as part of the usual treaty processes. And what you've just heard by way of the evidence is we're awaiting the complete law and practice assessment in consultation with the states and territories, and then it goes through the normal treaty processes via the Joint Standing Committee on Treaties.
Are you
Minister,
hoping
I just understand with the, I understand what you've just said to me, and thank you for that. But what I'm asking is something different. Is it the intent? I appreciate there is a document that needs to be looked at, and I appreciate the document hasn't been prepared for 2 years. But does the government intend to ratify the ILO Convention 190?
So, as I've stated, in accordance with the usual treaty processes, the Commonwealth Government, we are currently assessing, as you've heard by way of the evidence, Australia's legal and policy frameworks with a view to determining the extent to which those existing frameworks give effect to the Convention. So at this point in time, we're at a certain part of the process.
Senator Sheldon, we might rotate the calls. So did you have any
Yeah, I might just
questions
do
on
a
this topic?
quick follow-up on that, and I've got some other questions when you come back to me.
Would be appreciated.
There may be a misunderstanding what I'm actually asking. I'm asking whether the government has an intention to make sure that the ILO Convention they've signed off with weld employers, with unions from around the world, from employers around the world, including, of course, Australia, that voted for it, and so did the employers and so did the unions.
No, I understand all of that.
What I'm asking is not about process. I'm asking there is a desire to make sure that convention is implemented in Australia.
Yes, and what we need to do in the first instance, though, is to complete the law and practice assessments to understand the extent to which those existing frameworks already give effect to the convention. And I'm happy for Mr Hare to take you further through the process. It's the normal Joint Standing Committee on Treaties process.
It's okay. But thank you. Thank you, Minister.
Okay, thank you, Chair. Senator Davey.
Thank you very much. I want to just change the focus for a moment. I note in the budget there's 10 million that's been invested in regulatory technology solutions for modern award obligations. Can you explain more about this project for the committee and what benefits that expenditure will bring?
Thanks, Senator. We'll get the right person to come up to the table. This is a significant initiative in the department, and Ms Hender will be able to take you through in a bit more detail.
Thank you, Senator. So you just wanted a bit more explanation?
Bit of an explanation what the project will actually deliver and how it will provide benefit.
Okay. I'll start by talking about regulatory technologies, the use of technology to improve regulatory objectives. It can support the improved targeting of regulation, reduction of costs and administration and compliance. The government provided $9.9 million over 4 years to develop the RegTech solutions to support employers meet their modern award obligations. The package includes $5.2 million to develop a secure gateway for the Fair Work Commission, data to be directly integrated into existing and new payroll and business software. The funding will allow third parties, including payroll and business software developers, to integrate in real time data on modern awards pay and conditions directly from the Fair Work Commission's modern awards pay database into their existing payroll products at a lower cost than is currently the case. The Fair Work Commission is currently engaging software engineering company to develop the gateway, and it's expected to be completed by mid-2022. I understand in readiness for this year's annual wage review announcement, so we're hoping to see some benefits from that one in the new year. There was also $2.3 million for the Attorney General's Department to support and drive the development and the uptake of regulatory technology solutions through proactive engagement with payroll companies in the sector. And we also had a small component of that was $400 million to administer a small grants round with the Department of Industry to develop a challenge for software developers in this space to encourage innovation. So that will happen also in 2022. And there was, that was for us to facilitate that. There was $2.5 million for the actual challenge. So that will be innovative ideas that maximise government investment and deliver lower cost solutions to address market gaps in payroll solutions. And then we have an overarching roadmap which guides the development of these products.
So for the end user, for the small business, what's the practical outcomes? Will it make my life easier? Or
and that is exactly the intention, Senator, rather than small businesses in particular having to navigate complex awards. It will allow them, through their payroll companies, for example, Xero and MYOB, to be able to know what they should be paying their employees, so to improve their capacity to be compliant and to reduce the costs with which they have to investigate, so they don't need to dedicate their own time to navigating awards. The solution should provide that.
So there'll be time savings for businesses, so they can focus on the business. So how much is this going to cost a business? Will it be cheaper, or will it in the longer term, or will it actually increase the costs of doing business?
Our view is that this is a deregulatory measure, that it will reduce the cost to business, both in terms of the actual time, but also the opportunity cost in terms of the time that they can spend better on other things. While there may, and this is why the government is making the investment, to reduce the costs of these products, which at the moment, to the extent that they're used, they're generally aimed at the big end of town rather than at smaller businesses in particular.
You mentioned the roadmap as well. So can you just explain a bit more about what future reforms may be on the roadmap and what they might entail?
So in the 2021 MyEFO, the department was provided with some funding to engage in developing a roadmap for regulatory technology type solutions, and that roadmap developed both short, medium and longer term options. Some of the short term options are the ones that I've gone through today. Some of the longer term, the medium term options are considering how we might use the Fair Work Ombudsman's pay and conditions tool, and whether there are options we have there which might make some of the work that they have in their database more widely available, to the longer term options which are potentially using rules as code, so codifying modern awards so that that they can be translated immediately into a digital product rather than software developers having to navigate that themselves. That's very much in the 5 to 10 years, but it also canvassed the idea of a pilot in that space.
We hear often from small business about the complexities of the modern award system, how many layers there are and how difficult it is to follow up, particularly if people go from one sort of role in an organisation to another that has a slightly different award. Is this roadmap and the medium and longer term potential changes that we make, will that help businesses navigate that and be more compliant?
It will help businesses to navigate that. Some of those decisions about whether you make somebody, what somebody should be classified under an award, we're certainly not at that stage yet through these regulatory technology solutions. But the government's also invested in an employer advisory service to provide directly to small businesses who ask advice on issues such as those, to address that short to medium term need there for small businesses.
And for the roadmap and for the medium and longer term objectives, can you take me through the co-design progress? What stakeholders have you had discussions with? What sort of consultations have been there? How businesses fed back into what's needed?
So in terms of developing the roadmap, we did do a co-design process with unions, employer associations, software developers, quite a variety of stakeholders in that respect. Just having a look. So we engaged with, yes, a diverse range of employer associations, unions. We also engaged with various agencies across the Commonwealth as well. So the Fair Work Commission, the Fair Work Ombudsman, the ATO, who are already doing a lot of work in this space, as BEFIO and CSIRO Data 61. We're continuing to engage with those, certainly with the payroll sector. We're setting up a user group with them, so we can really understand what their needs are and what our agencies can do to meet those needs. As I said earlier, really to generate innovation in the payroll sector to see what they can do. I should also say, while I focused on small business, it does have application for employees and for other purposes. So we've engaged with academics who have been developing software solutions that go to the use in community legal centres to make it easier for them to do their job. I'm aware of unions developing solutions which assist their employees, their members, to know that they're being paid right as well.
And I'm sorry, I think you did say it, but when is this? When's the first tranche of work expected to be fully implemented?
The first tranche of work, so the Fair Work Commission API or gateway into their database of pay points is probably the most significant piece, and that will be implemented by 1 July this year or mid-year. And we're also doing the innovation round with the Department of Industry will be also completed, I understand, by 1 July.
Great. Thank you very much. I have nothing.
Thank you, Senator Davey. Senator Sheldon.
Good, thank you. Just getting back to this question about the ILO Convention 190. Minister, just so I'm clear, before, did you publicly commit to the ratification just before on the previous question? The government is committed to the ratification.
We need to complete the law and practice assessment in consultation with the states and territories. Then we'll consider ratification of ILO C190 as part of the usual treaty process. That's the usual treaty process.
And your intent is to ratify the Convention 190?
Well, again, as I've said...
Within the context you've just explained to me?
That will be dependent on the usual treaty process. We need to understand at this point in time, as I said, we're currently assessing Australia's legal and policy frameworks with a view to determining the extent to which those existing frameworks give effect to the Convention. You then go through the normal process for the Joint Standing Committee on Treaties, and they will then do their analysis. That's the process that goes through. So that's the evidence that I give.
Well, can you just ask then, what's the government's position to be taking to that Joint Treaties Committee meeting?
Well,
is there, again, I appreciate that
No, I understand. So we have to await, as the official said.
Various issues that you want to be considering, which is now 2 years down the track by the government.
Which is not unusual in terms of undertaking a law and practice assessment when you're dealing with the states and territories and looking across, as the official said.
There's a complex range of legislation that does need to be looked at. I mean, I'm happy for the official to take you further through that. But we will go through the normal process in relation to the Joint Standing Committee on Treaties. But the next step is to actually get complete the law and practice assessment in consultation with the states and territories.
Thank you, Minister. Senator Pratt, through you, Chair.
Thank you very much, Chair. I've now got some questions in relation to appointments to the Fair Work Commission. When was Deputy President Melanie Bennett appointed to the Fair Work Commission?
We'll have to get the... here we go. Relevant officer.
Is it Binet or Binet? Does anyone know?
I believe it's Binet.
Okay.
Thank you.
Benet was appointed on the 1st of February 2016.
Sorry, I didn't hear that.
It's a little bit soft there, Mr.
Sorry. Deputy President Benet was appointed on the 1st of February 2016.
Appointed? I thought it was announced in a bit earlier than that, but in any case, we've got the detail for that now. So Ms Benet was appointed by you, Minister Cash, during...
It was actually, it's a cabinet appointment.
A cabinet appointment. And who put Ms Benet's name forward?
I would have as the relevant minister, but it is a cabinet decision.
And how did you find Ms Benet? How did you go about looking for her?
That will be some
appointment?
time ago, Senator Pratt. Did we say 5 or 6 years ago now? I would need to take that on notice.
Okay, did you know Ms Benet before her appointment?
I had met her, I had worked with her 20 or 15 years previously.
15 years.
Oh, well, let me take it on notice to get you actual dates.
And how did you know of her interest in the position?
Well, again, I'll
when
have
the
to take that on
vacancy
notice.
came up? Where is Ms Benet based?
Deputy President Benet is based in Western Australia, Senator.
Okay, and so you would have worked with her in Western Australia, Minister?
That is correct.
Cash? Have there been any workplace complaints levelled against Ms Benet during her 5 years
Chair,
in the job that you're aware of?
You'd need to ask that to the Fair Work Commission this afternoon.
Yeah, so they are on this afternoon. That probably would be more suitable for them.
Okay, can I ask in the context of whether any legal costs associated with any possible complaints, have they been managed within the Fair Work Commission, or have any of those come to the department?
They would have been managed within the Fair Work Commission if there were any, Senator. I'm certainly not aware, but we can take on notice too, Chair. We don't believe there are any costs. We will certainly confirm that.
And you can put that to the Fair Work Commission when they're here this afternoon, and they may well be listening in now.
Okay, are you with us, Minister Cash, when the Fair Work Commission appears this afternoon? I haven't checked the schedule.
I do have a cabinet appointment, but I understand I should be.
Okay. Thank you. Now, in relation to, I'm just going to the other pages. So in terms of other appointments to the Fair Work Commission, by the way, how is Mr Boyce? I'm going to turn now to Deputy President Lyndall Dean. How long's Ms Dean been a member of the Commission?
Anne Sheehan, First Assistant Secretary, Industrial Relations, Legal. Deputy President Dean was appointed on the 30th of May 2016.
Similar timeline to before. Minister Cash, did you appoint Ms Dean?
It was a cabinet appointment again.
Okay, was it a nomination from yourself?
I believe it would have been at the time. If I was the relevant minister, it would have been.
And how did Ms
Again, I'd
Dean
need
put
to
a...
take that on notice. Senator Pratt, it was a number of years ago.
Okay, did you work with Ms Dean as
No.
you... You appointed Ms Dean 4 days before the Turnbull government went into caretaker mode, is that correct?
Well, Cabinet made... Well, I'd need to take that on notice.
So we have here another employer-backed appointment to the Commission. As celebrated at the time by the Australian Mines and Metals Association, are you able to reflect on what the basis of your decision to appoint Ms Dean to the Commission was?
Well, as I said, it would have been a cabinet decision, but again, this was a number of years ago. I would need to take that on notice, Senator Pratt.
At the time you said, Ms Dean is a highly regarded workplace... Sorry, I have a little tickle in my throat. Workplace relations lawyer and brings high-level analytical negotiation and conflict resolution skills to this role, as well as a demonstrated capacity for complex decision-making. Do you stand by your glowing support for Ms Dean?
Well, again, if Cabinet determined that she was an appropriate appointment, she would have met the criteria for appointment.
Well, I've never been in Cabinet, but I know a little bit how it works. You know, you've got to rely on the work of your Cabinet ministers in terms of the recommendations they make to Cabinet.
The Fair Work Act itself sets out the statutory requirements for appointments to the Fair Work Commission, so the person does have to meet the Fair Work Act requirements.
Do those statutory requirements include medical qualifications?
I don't have them in front of me. If you want me to put, or I can get... yes, sorry,
Right,
I have
look,
an
it's
official
a
here.
somewhat, it's a somewhat facetious question. Does Ms Dean have any medical qualifications? I can't expect that the Fair Work Commission asks for medical qualifications specifically, although perhaps it would be relevant noting some of the statements Ms Dean has made.
Senator, the statutory qualifications in the Act require the Minister to be satisfied that the nominee for a Deputy President role is or has been a judge of a court created by the Parliament or a state or territory court, or has a high level of experience in workplace relations.
Ms Dean has, in a recent dissenting decision, and I'll draw your attention to it, in the matter of Jennifer Kimber versus Sapphire Coast Community Aged Care. Are you aware, Minister, of the case to which I'm referring?
Was that Kimber via Sapphire Coast Community Aged Care?
That's right, Minister.
Yes.
Referring specifically to Ms Dean's remarks in her dissenting judgment relating to COVID vaccinations, where she said all Australians should vigorously oppose the introduction of a system of medical apartheid and segregation in Australia. This is in her dissenting remarks as a Commissioner. Do you agree with the views expressed by Ms Dean?
Well, to be very clear, the Deputy President was actually the minority in the matter. So in the Deputy President's view, as you've said, the aged care worker in this matter had been unfairly dismissed, but it was the majority view, as should be the case, that prevailed, and that was not the prevailing view. You'd also be aware that the comments that were made by Ms Dean, or Deputy President Dean, to give her proper title, they have been criticised by a judge of the New South Wales Supreme Court in a separate matter. I would note, though, that the Fair Work Commission is an independent tribunal and that decisions are made at arm's length from government. You obviously may want to pursue this with whoever's appearing this afternoon. But in terms of, there is a robust framework for adjudication by the Fair Work Commission. And again, I would state she was in the minority and you obviously rely on the majority decision.
Deputy President Dean, I'm sorry for getting her title wrong, I apologise. So I take from that you distance yourself from the views expressed by Deputy President
She was
Dean.
in the minority.
But you haven't told me, you know, you're the Industrial Relations Minister. You make these appointments. You've got to have confidence, I presume, in the decisions that are made. Do you agree with the views expressed by Ms Dean?
Well, again, it's not whether or not I agree or disagree. A majority of the Fair Work Commission did not hold the views that Ms Dean holds.
If Ms Dean had been in the majority, clearly that would have caused you some concern.
Well, that's a hypothetical.
Well, it
because
is a
she
hypothetical
wasn't,
question.
In the majority, she was in the minority.
It might have been a different outcome if there were more of your stacks on the commission. Can I ask, do you feel that in the current environment that views like these as expressed by a person of Deputy President Dean's high position and authority, that it undermines the government's own work in encouraging as many Australians as possible to be vaccinated?
Well, the government's position in relation to encouraging Australians to be vaccinated, I think it is very, very clear. Vaccination in Australia, it is voluntary, subject to, obviously, for example, state and territory health orders. And we certainly in Western Australia, Premier McGowan has announced a huge mandate in relation to vaccination within the workplace.
Exactly.
But the government's position is very clear. Vaccination is voluntary, but we would encourage, and I am so pleased, wrong department, otherwise I would take you actually through the statistics in relation to vaccination, but I believe that's happening in the health department. But in terms of the Fair Work Commission itself and decisions that are made, it is an independent tribunal. Decisions are made at arm's length from the government. In terms of the President has a responsibility to consider these matters, and I assume, I don't know if the President's actually appearing, the President doesn't normally appear, no, but there will be someone here this afternoon that you can put those questions to.
Do you have confidence in her appointment, or do you believe you've created a problem for the Fair Work Commission?
Well, again,
manage?
it is the President's responsibility to consider these matters. The President of the Fair Work Commission themselves, they have a statutory responsibility to ensure that the Fair Work Commission performs its functions and exercises its powers in a manner that serves the needs of both the employers and the employees. And again, albeit the President won't be appearing before the committee, there will be people here from the Fair Work Commission. The President himself or herself, currently himself, may also take measures to maintain public confidence in the Commission if the President deems that fit.
So do you believe that these kinds of statements are a problem for the Commission?
Well, that I would not comment on what is an independent body, but that is for the Fair Work President to determine whether or not he needs to take measures to maintain public confidence as a result of this decision.
Do you have confidence in this Commissioner?
Well, again, she was in the minority. She is entitled to her views, but I will make it very clear, she was in the minority and the majority prevailed.
So do you believe that it's frankly then a good thing to put such divergent views into the Commission and see how it comes up the other side? You support the idea of an anti-vaxxer going into the Commission?
Well, I think you are so far removed now from the appointment process. This is a case in which a Deputy President was in the minority and made certain comments. They were in the minority. The majority decision prevailed. The government's position in relation to vaccination, and again, wrong committee, if I was in health, I would take you through the vaccination statistics, is very, very clear. Vaccination in Australia is voluntary. However, and the good news is, I think in Canberra now, the vaccination rates double dose are...
Double dose, actually I do have it here.
There you go, we can actually bring it up on an app.
It's going to go over 100 soon.
88.9% for double dose and 98.89%
Whoa,
for first
98,
dose.
so congratulations to not Canberrans, but Canberrans.
Okay.
I spent the entire weekend driving around trying to work out why Canberran was being told to stay safe. till someone
Well, we'll
pointed
see what
out to
Safe
me
Work
yesterday.
Australia has to say.
Ken
about
Berens
that.
understood who Ken Berens was.
May I ask, in the context of Supreme Court Justice Robert Beech-Jones's remarks, and they're lengthy, given the very different jurisdictions being exercised in this court, I would not ordinarily address the reasoning in their decisions, and I doubt they would address the reasoning in mine. So already it's a fairly extraordinary length for a Supreme Court judge to go to. As the Henry plaintiff sought to rely on the reasoning, it is necessary to record why that judgment is of no assistance. First, the relevant parts of the decision relied on by the Henry plaintiffs do not address the case law concerning consent to a medical treatment. The passages relied on and passages to a similar effect throughout the judgment appear to contain assertions about the efficacy and safety of COVID-19 vaccines and other aspects of public health response to COVID-19 that were not reflected in the evidence that I found to be found persuasive in this case, and as far as I can ascertain, were not the subject of evidence in this case. Third, elsewhere in her reasons, the Deputy President considered it necessary to opine on matters affecting either the validity or the appropriateness of making the aged care order under the Public Health Act. The function of determining its validity is for this court to discharge, and the function of determining whether it should have been made is for the political process. The Fair Work Commission has neither function. The Deputy President's judgment concludes with a number of clarion calls imploring all Australians to do things such as vigorously oppose the introduction of a system of medical apartheid and segregation, and vigorously oppose the ongoing censorship of any views that question the current policies regarding COVID. Political pamphlets have their place, but I doubt that the Fair Work Commission is one of them. These are not authorities for legal propositions. Now, Minister, can you really just characterise this as an example of the Fair Work Commission, balancing out the process in a majority and minority process? These are extraordinary. This is an extraordinary lashing from a judge.
The comments you are reading are the New South Wales Court comments.
That's correct.
So they're obviously the comments for the New South Wales Court. As I've said, Deputy President Dean was in the minority in this matter, just so people understand. In her view, the aged care worker in the matter had been unfairly dismissed. But again, this was not the prevailing view of the majority, and in fact, the majority of the full bench dismissed the appeal and found that this aged care worker was validly dismissed as she did not have a medical contraindication for the influenza vaccine, and without being vaccinated, she could not perform the inherent duties of her position. That was the position of the majority in the Fair Work Commission case.
So do you have...
Senator Pratt, just keeping in mind that we've got a...
And you probably also need to go upstairs, Senator Pratt. We've all got to go and have COVID tests.
we do have...
You're a Western
Oh,
Australian.
we do. We don't have to
get back into WA.
To do that. Is it morning tea?
Oh, in a minute.
All right, let's do, and I'll come back to this. Thank you.
Can I just ask a question about... I asked you to give consideration to my request for the Minister to answer my question earlier. Eventually she did come and answer it. My question was about the choice of the government to advance or not advance a particular recommendation in respect at work. Can I get your clarification on the appropriateness of that question?
So the advice I've received on that, Senator O'Neill, is that, of course, the Senator's right to put a question to any individual official or witness, but it is also the Minister's prerogative to, if or she chooses to answer the question instead of that
Which I did in
witness.
both circumstances. The official was able to provide you some
Exactly.
information,
Eventually
and then I
we got
came
there.
back, as I said I would,
Yep.
and
So-
provide you with any further information that was required.
In addition to that, you actually did answer my question after
Correct,
it
but the
became
official
clear,
did
but
actually have some
I
relevant
wanted
information for
clarification
you.
on the
Yep,
ruling.
no.
And can I also point that Senator Pratt asked a question which was considered to be hypothetical and was ruled out of order. Can I just point out, my understanding is that Standing Order number 73 regarding questions does not apply in estimates, and hypothetical questions are in order in this context because we are considering the impact on Australian people. in a different way here. So can you just...
You are correct, Senator O'Neill. There is no standing prohibition on a hypothetical question. Of course, there will, of course, be circumstances where certain hypothetical questions may not be able to be answered by a minister because of it's not reasonable to have the information of a counterfactual. But so that has to be judged on a case-by-case basis. With that, we might
Thank you,
break
Chair.
for morning tea.
Thank you.
And nip upstairs.
Chair. Just returning to this matter, Minister, have you personally raised this issue with the President of the Fair Work Commission?
No, I have not.
Are you
It is an
proposing
independent
to take
commission.
any action in relation to Ms Deputy President Dean's assertions in her role?
Well, again, she was in the minority, the majority prevailed. The Independent Commission is an the Fair Work Commission is an independent body. It is the purview of the President should he wish to take action.
The government's criticised decisions from the Commission, hasn't there been?
You'd need to bring them to my attention, Senator Sheldon.
I'd have to go through the lockstep and date of each one of those, but it's also quite not unusual for this government to have made criticisms of decisions from the Fair Work Commission.
Well, and in this case, we're talking about a minority finding.
minority.
Will you overtly criticise that position, or are you just still saying that this is the proper process to balance
I think,
out?
as I've stated to you, the government's position in relation to vaccination is very, very clear. In Australia, the government's position is vaccination is voluntary, but we encourage all Australians to get vaccinated. And that is, of course, though, subject to whether or not there are any relevant state public health orders in place. And if there are, you do need to comply with the state public health order.
You've spoken at length about how you, the Commission came to a majority decision, and that do you therefore distance yourself from the remarks of Ms Dean, or is it just part of the proper process that she said made those remarks and findings in the
Again,
case?
Senator Pratt, I've made the position of the government very, very clear. Vaccination in Australia, should I say, vaccination for COVID-19 in Australia is voluntary. However, we encourage all Australians to get vaccinated. But where there is a state public health order in place, and it's been properly made, and we've got them in Western Australia, a number of states and territories, obviously, via the National Cabinet made them, you do need to comply with the state public health order.
Do you distance yourself from Ms Dean's remarks?
Chair.
Well, again, as I think, Chair, I can't be clearer in terms of what the
I
government's
don't
position is.
understand why you simply wouldn't do that.
This is dangerously close to repetitious questioning, which is, of course, disorderly under the standing orders. So I just draw your attention to that, Senator Pratt.
Well, look, this question has been asked a number of times. I'll let Senator Pratt continue for now, but would, in the interests of time here, that we do at some point move on. Thank you,
So the
Senator
Commonwealth's not planning to intervene, you'll leave that to the Fair Work Commission?
So
Pratt.
intervene
Nothing
in
to
what?
intervene on.
Ms Dean's behaviour?
Again, Chair, I think I've answered that question.
Well, okay, well, I'll return to some of her other behaviour. Ms Dean commented on a post on social media site LinkedIn that likened Australia's public health response to COVID to Chinese-style totalitarianism and to the Jewish Holocaust. Are you aware of that?
No, I'm not.
The post by Tanya de Jong says the Western world has responded to COVID by adopting all the trappings of totalitarianism fueled by irrationality and fear. It goes on to say, we have imported far more from China than the virus. We've imported Chinese-style totalitarian social control mechanisms based upon very selective science. It quotes from Hungarian Jews about the rise of the Nazis and then the Holocaust, and concludes, now we are on the precipice of another global tragedy fanned by the ideology of health for the majority. Do they seem like credible views to you?
Well, again, Senator Pratt, I haven't seen those comments. I don't know what you're reading, where you're reading it from.
If I read that as my comment, you would distance yourself?
Senator Pratt,
Okay,
now you're in a
I'm telling you.
hypothetical. I'm not going to deal in hypotheticals.
Senator Cash, I'll ask you, are we on the
did or
precipice
did
of another
not-
global tragedy fanned by the ideology of health for the majority?
Again, Senator Pratt, I haven't seen those comments. You've put to me that certain comments have been apparently Facebooked, I think you said?
LinkedIn.
Facebooked? LinkedIn?
Senator Pratt, I think
I
it's...
would need to see the post, but again, the government's
I've read you the
position
post.
is very, very clear. That is it, full stop. That is the government's position.
Senator Pratt, I think it would help if the question's couched in terms of back to government policy or the funding operations of government, so it's relevant to this committee, asking the minister's opinion on various statements that might be made on different matters is probably not that relevant to here. It needs to be linked back to the operations of this department or the government policy.
And just to reconfirm though...
Just a point of order, Chair. This matter is something that, regarding COVID, affects workplaces, as you're aware, all
I
over
am
the
not.
country.
I'm sure this question.
So there is a definite relationship.
Yeah, and I'm sure the questions can be couched in terms that are relevant to the department's operations and the government policy. I just think it would be helpful if it's made in those terms. Thank you. Thank you, Senator Pratt.
Senator Cash, Ms Dean commented on the post about the public health response being comparable to the Holocaust and said, I fully agree.
Senator Pratt, you've put something to me. I need to see it. I need to have it
Why
verified.
can't you just simply distance yourself from those remarks up front?
You're putting them would you at least table them so that I could actually see them? But to be very, very clear, my understanding is, and again you can put it to the Fair Work Commission this afternoon, the President, or the Fair Work Commission should I say, has a code of practice in place in relation to social media, and at all times I would expect any member of the Fair Work Commission to abide by that code of practice, and if they did not, the consequences will be what the consequences are. If you are saying to me, and again I would have to take you at your word, I don't know if she did make those remarks, but if they are her remarks, and again I qualify it by saying I don't have them in front of me, they are a matter for her, but I would not agree with those views. But again, I'm taking you at your word.
Thank you. So in the context of those views being a matter for her, are they also a matter for the Fair Work Commission?
Well, that is obviously, I think I've just stated that. There is a code of practice in place. It is for the President to consider whether or not that code of practice has been breached. And if it has, the President will then take whatever actions he deems fit.
Are you aware that she used her title as Deputy President of the Fair Work Commission? Have you made inquiries as to whether
So you
the
need
President
to qualify that. I don't understand the question. Am I aware that she's used her... She is a Deputy
Well, when you're on
President.
LinkedIn and you comment on a post, you do it in your professional capacity, which would have been the Deputy President.
Again, no,
as
I'm
the
not.
Fair
I
Work
didn't.
Commission.
I do not know about her LinkedIn account.
Yeah.
Can I just quickly, is there any possibility of tabling any of this, Senator Pratt, that might assist?
There is Senator Pratt, I am taking you on your word.
No, that's...
And
I'm sure we can
I don't
find
have the benefit
potentially
of
a
any of
link
this
to
in
her.
front of me. If there was any way you could print it out and table it, it would assist the committee and it would certainly assist myself.
Okay, have you made inquiries with respect to any potential breaches of
Again, Senator Pratt,
the guidelines with
the evidence I gave
President?
was, this is the first time I'm hearing of this. I'm taking you at your word that these were indeed the comments. If they were, I disagree with them. I don't agree with the views that you have put to me on her behalf. My understanding is, and again you could put this to the Fair Work Commission this afternoon, they do have a code of practice in relation to the use of social media, and if that code of practice was breached, the President will take the appropriate action. without telling the President what to do, obviously. That would be a decision for the President.
Okay, so do you believe that if a Fair Work Commissioner were to relate COVID vaccination to being control like the Holocaust?
I don't agree with those remarks. Absolutely not.
Okay.
But again, I'm taking you.
I can
your
see
word.
that you don't
I
agree
do,
with those
I do not
remarks.
have them in front of me.
Would you be concerned that it's not only just a question of whether you agree or disagree, but do you think someone could see that and think it's the Fair Work Commission's position?
I assume it is a... look, I haven't got a LinkedIn page, Senator Pratt, so it's difficult for me to comment. But again, I don't agree with those remarks. There is a social media code in place. You can speak with the Fair Work Commission this afternoon in relation to what action, if any, is being taken. But if there has been a breach of the social media code, consequences flow. And that is for the President to determine.
Okay. I do have an attachment here. I apologise for not providing it to you.
As
before,
I said, I took you at your word that you were correctly quoting. And I would normally, as you know, it's dangerous to do that because... Context. And especially, yeah. So if you do have something that could verify the comments or the quotes that you've made...
Just while the Senator's going to that, I just want to clarify something from an earlier answer, Minister. Regarding the Deputy President, Benet, to the Fair Work Commission, which will be... you mentioned that matter is better off put to the department, to the Fair Work Commission.
Could I just confirm, was that in relation to whether or not any complaints had been made against her?
That's correct.
Yeah, I have no knowledge of that. That is something you'd need to put to the Fair Work Commission.
Does the department have any knowledge?
I would need to refer to the department.
So I've had broad discussions with Justice Ross, but I'm not aware of any detail.
So I just want to get some specifics then, Mr Mahir. Are they involving bullying complaints lodged by people working?
I don't have any detail, Senator.
Was the nature of the circumstances of all the complaints in any fashion given to you? It's just a
No,
phone
Senator.
call, got a problem with Benet, phone
No, we're
slammed
talking...
down, is it?
Senator, we're talking about a range of issues. I'd need to go back and check, but my recollection was it may have been after the first issue of Deputy President Boyce was raised, and President Ross said, working with independent statutory appointments can be challenging.
And then he mentioned Ms Benet, is that correct?
I'd need to check that, but it's certainly possible. I have a recollection of her name, but it may have been because of the recent matter as well, so I need to go back and check.
So just to clarify something, the recent matter?
Deputy President Benet has been dealing with the MUA issue in Fremantle.
I just want to go to the... wouldn't it be alarming if someone was telling you that there was bullying complaints? Or someone was raising that with you?
So as I said, the context was...
I mean, how you respond to it's a different thing, but wouldn't it be alarming?
So again, it's hypothetical. As I said, the context was the role of President of the Commission in working with independently appointed commissioners is challenging. The code of practice that's in place is a code of practice endorsed, but in effect, disciplinary matters are difficult, and the ultimate discipline for commissioners has to be dealt with by a joint sitting of the Parliament, is my understanding.
What would be,
That's why you've got to be careful with these appointments to start with.
did Ms Benet have an expectation from the Commission, has this been relayed to you, that legal costs with her staff dispute would be covered? Is the Attorney General's matter too, is it, or clarify that?
I am not aware of any detail in relation to any issues with Deputy President Benet.
To Ms Jones, are you aware, or anyone else aware, that that's in the department regarding this matter that we're discussing about Ms Benet?
Senator, no, I'm not aware. And I'm not aware of anyone else who would have any knowledge of that.
Thank you. Back to...
Pratt going to table.
That is happening now.
Thank you. I wasn't
It's,
sure. I
it's
thought we
just
can have a
being
look at them.
arranged
Thank you
by the
very much.
committee minister. So.
And if there are any issues with the sourcing of those documents, because some of them are just cut and paste, then I will get them to you. So, Minister Cash, you've confirmed that any action will be a matter for the President of the Commission.
Well, the President himself has a statutory responsibility to ensure the Fair Work Commission performs its functions and exercises its powers in a manner that serves both employers and employees.
Yeah.
And the President himself may take actions, or should I say measures, to maintain public confidence in the Commission.
What powers does the President have at his disposal should he choose to take disciplinary or other actions?
And I will get the official to take you through that.
Thank you. As the Minister noted, the President may deal with complaints about the performance of a member's duty and take measures. That is quite a wide-ranging power to be able to investigate the complaint, to generally handle it in terms of actions that might be considered. There are a number of examples. It might be training that is that the President requires.
Does the President actually have any powers to direct the behaviour of a Commissioner in a certain direction?
The President would have powers to, to not allocate particular types of matters to a Commissioner. It would depend what the President considered was appropriate in the circumstances. The President would also have power to require the Commissioner to undertake certain training if the President considered that appropriate.
And what if that training didn't change the Commissioner's behaviour? What recourse is there then?
Then the President would need to consider whether further action is required to be taken.
And what kind of further action is available to them?
The President can, if he considers that the requirements in the Act have been met, refer a complaint to the Minister.
So that's back to Senator Cash, yep.
So after dealing with a complaint, the President can refer a matter to the Minister if satisfied that one or more of the circumstances that gave rise to the complaint have been substantiated, and if satisfied that Parliament should consider whether to call for the termination of the appointment of the member.
Whether to recall the... Can you repeat that last part?
Whether the President is satisfied that Parliament should consider whether to call for the termination of the appointment. So the President would need to consider whether that threshold has been met before determining whether to refer. But the President could take a broad range of action himself in terms of whether that's allocating particular matters to the member, particular training requirements, etc.
Minister Cash, will you seek some advice from the President of the Commission as to whether these issues are manageable internally and whether this kind of behaviour that I have alleged here can be successfully managed, or whether...
Yes, I will be doing that. And just in relation to the LinkedIn pages, again, I'm prepared to say to you, based on what you said to me, I disagree with the comments. Unfortunately, with what you've provided, there is no name on it.
I understand that.
Oh, hold on, there might be. There is on one of them. Again, though, with what you put to me, I disagree with the comments. But again, I'm taking you at your word.
And thank you for doing that, Senator Cash. I appreciate that, so that we can have an in-depth inquiry into these issues. You will see on one of those pages, Lyndall Dean, Deputy President of the Fair Work Commission, saying, "I fully agree, Tanya."
I agree with you. Again, all of the other posts are not named, so I'm taking you at your word.
Yeah.
Based on what you've said, I disagree.
So in that context, you'll seek some advice from the Commissioner as
Yes.
to the President, as to the extent to which these issues can be successfully managed. And what support will you give the President if there are further issues
That will
raised?
depend on the outcome of the discussions.
And you're aware of the powers that you have?
Correct.
Has it been raised with you or the department, these matters that have been highlighted now on any previous occasion?
Certainly we're aware of the decision. Certainly I'm aware of the New South Wales Supreme Court commentary. This is the first I've seen of the social media posts.
And what steps did you take? Did you contact the Minister's office? I might ask also, did you contact the Minister's office regarding Ms Benet as well?
No, there's nothing. In relation to Deputy President Benet, there was no detail, no issues. It was a broad comment around managing independently appointed statutory officers. So, no, I didn't comment or raise any concerns with that. That's up to the President of the Fair Work Commission to manage. In relation to this, the media was out, so yes, it was something that we made sure the office was aware that there was media in Workplace Express, I think it was, in relation to the decisions.
And what advice did you give to the Minister's office?
That there was media in relation to a dissenting decision.
There's no other further concerns raised, or the matter should be handed on to the President for consideration?
It's quite clear that the President had responsibility for looking at this issue, so I certainly don't recall advising the office of that, but I would expect the office would know that.
So the department didn't advise. Minister, did your office advise the President's office of this concern?
Of his concern?
No, of the concern regarding the comments that would be made by Ms Dean?
Are you now talking, sorry, we've had a number of comments that have been put to me.
I think Senator Cash indicated she was not aware of those comments until today.
Those comments.
And I know
This is
Apart
the
from
first
the
time
judgment,
that I've heard of them.
You were,
and I've
however,
said I will
aware of
raise
the
it
judgment that
with
was
the
made.
President.
just to round it off, Ms Jones, are you aware of this matter regarding Ms Dean?
No, no, Senator, I wasn't previously aware of it until today.
Can I ask, are you aware that Gerard Boyce was counselled over his social media use? And so I ask, why are Deputy Presidents still making these sorts of posts? And I'm sure that you will be able to ask you'll be able to ask well, we won't have the President here. We will ask the Commission.
Correct.
But you will ask the President as to why the Deputy President's Liberal Party appointees are still making these sorts of posts.
Again, I'll take that as a political comment, but I have said I will raise it with the President.
Okay, but in that context, there's a history here where Gerard Boyce was counselled, and yet there still seems to be this kind of behaviour taking place. I think now, Chair, we're in a position to move on to, yeah.
I might just, you mind if I'll just rotate a little there? I won't be long, and then I'll go back to you guys. Are you moving on to a different topic? Yeah. Okay, all right, well, thank you. Just got some questions around casual employment over the last couple of decades. We have covered this in another inquiry, but it was a while ago, and it'd be good to get on the record while we're all here, face to face. I wanted to ask about the percentage of casual employees in the economy over the last couple of decades, and particularly how does the percentage of casual employees compare today and or prior to COVID, because I think there's been a bit of a shuffle there, and back in the late 1980s, so for the last 30 years.
Thank you, Senator. So the proportion of casual employees relative to all employees has been fairly stable over the last 2 decades. But in terms of the current proportion of all employees, in 2021, as at August 2021, it was 22.5%. The proportion before COVID hit, so if we look at 2019, it was 24.2% of all employees. And what was the third part?
Well, whatever figure you've got for around late 1989, 1990, have you got a figure that far back?
The earliest year that we have on record was 1988, when it was 18.2%. In 1999, 24.9%, 2004, 25.5%, and 2010, 24.2%.
I just missed the 88 figure, sorry, what was that?
Oh, sorry, the 1988 figure was 18.2%.
18.2. So basically there was an increase over the 1990s, roughly, or some period over the 1990s, there was an increase, seemingly, a sort of almost structural increase in casual employment.
Yes,
and
that's
then
correct.
since that date, last couple of decades, it stayed at about a fifth to a quarter or so. Is that about right?
That's correct, Senator.
Okay. I mean, it wouldn't be true to say then that the rate of casualisation in the workforce is increasing. That wouldn't be...
It's been stable over certainly the last decade.
Do you have figures for female employees as well?
Yes.
Could you give those same sort of figures for those time ranges, those years?
So for 2021, the proportion of all females employees for casuals was 24.2%. Are there particular years that you... Same
year, so if you've got them, if you've got those years,
okay.
so 19...
Yep, so 1988, 28.4%, 2000, 31.1%, 2005, 29.1%. And
what was it before COVID, 2019?
Before COVID, 2019, it was 26%.
Okay. So there's been a slight reduction there over time in female casualisation, is that roughly correct? A few percentage points, perhaps?
It's certainly down now from a peak of 31%.
Right, okay. So again, not increasing at least. I just going to the reforms,
yes.
And I'm not sure if we've had you in the Job Security Committee since then. The reforms have gone through the National Employment Standards. Could you just take us through how are they working now, and is there any early evidence of firms taking them up, that this is the right to convert from casual to permanent employment?
So, Senator, the Fair Work Amendment supporting Australia's Jobs and Economic Recovery Act of this year had 3 elements. One was to provide a statutory definition of casual employee. The second was to create a new National Employment Standards entitlement for casual conversion. And then the third aspect was a statutory rule in relation to offsets. In relation to the casual conversion, we don't yet have comprehensive data, there is intended to be a statutory review of the provisions, which will commence as soon as practicable after the 27th of March next year.
Will you get, or will we be able to see data on the number of people requesting the conversion?
Certainly the statutory review would be able to assist in terms of how the measure is going. There is a fairly low level of disputes that we're seeing at the moment, but we don't have comprehensive data in terms of the uptake.
Okay. I think, and one thing that's come up during that other inquiry is part-time employment has increased over time, I believe. If that is incorrect, let me know. So separate from casual employment. But what is the evidence? Do you have any evidence on whether or not part-time employees want or prefer more hours compared to full-time employees? That is, I'm trying to get to the bottom of it. Is it are part-time employees choosing that work status, or is there evidence that actually they'd like to work full-time, there's just not a job available? Might be another official there wanting to assist there, Ms Matthews.
I think I do have that, Senator. Yeah, what was the date? Yes, thank you. So as at February 21, 2021, the latest ABS data shows that 75.1% of part-time workers preferred not to work more hours.
Okay. All right, thank you for that. And just look finally, do you have any evidence on the change in other types of employment arrangements over those similar time periods over the last couple of decades? That is, independent contractors, those on fixed-term contracts, labour hire workers or gig economy workers. Do you have any of that? Did you get that? Sorry, thought I'd just rush through all those quickly, so we're not here all day.
By way of summary,
Yeah.
so the incidence of putting aside gig workers for the moment, the incidence of those types of workers has been broadly stable.
Right.
So for independent contractors at around 8 to 9%, labour hire employees is less than 2%, and fixed-term contractors at around 4%. It's been broadly stable.
Okay.
Gig workers aren't defined as such,
So you don't have-
and they would be captured under those other broader categories.
Well, thank you very much for that, Ms Matthews. Senator Sheldon?
I might just to assist on that line of questioning. Are you aware that Uber is the second largest employer in the country with over 100,000 people working for them as contractors?
I wasn't aware, Senator, but I'll accept that.
So you haven't taken those figures into account, able to give those figures about the gig work? Is that what I understand?
If I may, Senator, so as Ms Matthews indicated earlier, the gig workers aren't yet identified separately. Most of the labour force data actually picks up people's first job or primary job. It's my understanding is that it's often the case that people doing gig work are doing it as a secondary or supplementary income. We do, and I think we've discussed this before, Senator, in my EFO last
So it's not important?
year. No, Senator, it is important, which is the point I'm getting to. Funding was provided to the ABS for them to actually undertake work to collect data. That process is underway in terms of actually trying to define gig economy, and then the data collection will follow. So, yeah, we do see it as a very important matter, but to actually get good data is also very important, so that's why we're working with the ABS.
There were some examples in the previous questions, and you gave some answers to this. It's been asked in this context regarding insecure work. Do you have an evaluation of insecure work? So that means you don't have it for gig, including the second largest employer in the country. That's not included, I gather. Where's the other insecure work that you have? So for part-time workers that we've received in another inquiry, substantial evidence regarding casualisation, part-time work, particular part-time work, with 0 hours guarantee, which is insecure work or expressed as insecure work from the evidence that we've received. Does that get included in insecure work, or you don't have an insecure work assessment?
Senator, insecure work isn't defined generally, but for the purposes of the ABS data. But those categories of employers that you've mentioned would be captured, perhaps under independent contractors or otherwise employees if they're casuals or part-time.
Yeah. I was trying more to get to the question of, and thank you for telling me that you don't keep records of, there isn't a way that you keep records of insecure work. That's what I was actually getting to the heart of, because as I said before, the second largest employer is Uber in the country, and they consider all those workers as subcontractors.
So, Senator, as I said, we certainly do regard the identification and classification of workers as important. It's why there has been funding provided to the ABS to undertake further work. That will take some time to get defined and then start to see data over an extended period, but we certainly do regard the collection of data around types of employment.
Senator Shaw, so the types of data we would have, or the department would have, and it probably is not quite what you're looking for, casual, part-time, independent contractor, that is actually labour hire, so you've got another sort of subset, and then obviously fixed-term contract and permanent. So you do have the independent contractor and the labour hire as part of the data that is collected.
All right, what's that total figure of the percentage of the workforce?
If I went, are you happy to go through the figures? Yep.
Yes, I am. So I think Ms Matthews said labour hire is less than 2%, but normally it's about
1.1% of employees in August 2020, and it's released every 2 years, so 1.1%.
Of that total pool?
Of the total, so 1.1% of employees in August 2020.
Sorry, because I can't do the maths. What is that in numbers of real people?
We will get that to you. Hold on for one moment. And in terms of independent contractors, it was 8.2% of employed persons, and I'll get the math to you, persons in August 2020. Just on labour hire, it actually peaked it was actually November 2011 at 1.5, so it's actually gone down to 1.1% in August 2020. In terms of independent contractors, high 9.8% in November 2010. The low was 8% in August 2018. The latest figures are 8.2% in August 2020. And we'll just translate that for total number of workers for you.
Thank you. As you can see from the figures, the percentages that Senator out, these percentages are relatively stable. Perhaps declining slightly, and they've been stable for 10 to 20 years as well.
Thank you. I know there's a lot of conflicting views about the size of insecure work and about its growth, and also, as you'd be aware, that there's a deep concern across the community about insecure work, whether the individual suffering it or a family member. I just want to go to a different line of questions.
Senator Sheldon, I think Senator Small just had some follow-up questions on this topic, if that's okay. I didn't take too long before. He won't be long, he's assured me, and then we'll come back to you. Senator Small.
Yeah, thanks. And maybe, Mr Hare, if you can help me with this. I guess accepting for a moment Senator Sheldon's characterisation of anything other than permanent full-time work effectively as insecure work, can I ask, in broad terms, why employers in the Australian economy would choose to use the sorts of arrangements that fall outside that, i.e. permanent part-time, casual, labour hire, fixed-term contract, etc.?
So if we have a look at the part-time work, I think Ms Matthews, to start with, Ms Matthews identified that 75% of employees who work part-time don't want additional hours. To go further than that, I think it's in the order of 5% of people who work part-time actually want close to full-time hours. So there's still a very large group of people who are looking for a small amount of additional hours but still want to be part-time. So
5% do.
Hold on,
Okay,
I think
sorry,
I'm interested
sorry,
in...
Senator Pratt.
I'm happy to clarify that.
I'm happy for you to ask questions after Senator Small, but there hasn't been many interjections this morning, so we could keep respect of each other. That would
So, as I said, approximately only 5% of people want full-time work, of part-time workers actually want full-time work and are looking for that work at the moment. So that leaves about approximately 20% who are still happy or aren't looking for full-time work or are happy to work part-time but looking for more hours. So part-time work is absolutely a valid option. It's sought after by a large proportion of people to meet their needs. For employers, it meets their needs in terms of they may have periods of peak work where it might be from their business is relatively slow in the morning, but they might need additional staff for the afternoon, and therefore they seek to have people there rather than having them on for the full day. That's an important flexibility for both employers and employees.
So if I can, I guess, just play that back. Effectively, this is an arrangement that's desired by a large number of employees in Australia and suits the needs of a lot of Australian employers, in a nutshell.
That's certainly what the figures would indicate.
Yeah, okay. Because I guess it's interesting then that those exact arrangements are in fact used very broadly in the Australian economy, including by the Australian union movement. For instance, the CFMMEU has recently been advertising for an industrial officer or organiser in Victoria who's a high calibre individual with leadership potential and looking to pursue a rewarding career. And yet the position is a 12-month fixed-term contract with the potential, indeed, for a permanent employment to be reviewed at the end of the fixed term. I guess, interestingly, the NTEU also after a 6-month contract for a union organiser, but most interestingly to me, given the comments we've heard in both this committee and the Job Security Committee on the precarious insecurity of the gig economy, is the fact that the TWU is advertising for a part-time, 10 to 20 hours per week role on a 3-month fixed-term contract to recruit food delivery workers into the union and identify and develop leaders within the workforce. Now, I don't for a moment suggest that there's anything improper about that, but I guess I'm interested in your view as to the appropriateness of these arrangements as they exist in the Australian economy and used extensively by the Australian union movement.
Certainly the appropriateness of those employment types is well accepted. The Fair Work Act allows for them. So I don't think there's anything in either the legislation nor in practice that would say that these aren't acceptable forms of work.
Indeed. So where a job ad included a generous salary of $127,000 a year plus super, plus 12 RDOs, plus 5 weeks annual leave and a Christmas shutdown, would you accept that that is a generous arrangement in excess of the NES on face value?
I'm not sure of what the arrangements would be in terms of what the award conditions underlying it. I can think of at least one award where they've got a very significant pay rate. I think the pilot's pay rate's very high, but on the face of it, that would seem to be above award for a lot. But again, couldn't make a determination on that without actually knowing the circumstances of the employment.
No, I just thought it was interesting that, such a big deal was made about all this extra leave and the Christmas shutdown being covered, and yet the position is a full-time contract only until the 23rd of December 2022, which effectively means that the professional officer working for the New South Wales Nurses and Midwifery Association would be terminated just before the Christmas shutdown.
That is what the ad says.
Indeed.
That is what the ad says.
So I guess I just wanted to draw your attention to this very extensive use of these arrangements in the Australian economy.
We don't need commentary across the table.
Sure.
I think you're finished, Senator Small.
Thank you, Chair.
Senator Sheldon.
I just, after the series of Dorothy Dixes,
I'm happy to table it if you like, Senator Sheldon.
and after the series of Dorothy Dixes from Senator Small, Can I just ask then, is the minister see that there is a problem with insecure work in this country or not?
Oh, I think you need to look at the key facts and figures, and when you look at the key facts and figures, and in particular in relation to labour hire, actually a high of 1.5%, ironically given your questions, under the former Labor government, 1.1%, it's actually at a low under the Morrison government in August 2020. When you look at independent contractors, a low under us of 8%, ironically, given your questions, a
Ms. Grace,
high
just interrupt you there for a
under
moment.
the former
Gig economy
Labor
workers, I
government.
understand. Just sorry, Minister, to interrupt, so you only got a train of things you're saying to me, but I just want to ask that particular point. But we've just received evidence that gig workers aren't included necessarily in that group, and that there needs to be further ABS stats. So you're relying on stats that don't exist.
No, these stats do exist there. I think
Right, so the stats that don't exist, which are the ones that we're trying to find and the department is looking for. And I understand from Mr here that he said there has been a resources allocated to try to deal with this question of gig workers. So they're not in the stats yet.
I don't quite understand your question.
I'm not sure. I think
Gig workers.
From the data you have before you, including gig workers.
If I may, when I talked about the data, the ABS predominantly uses primary job. So, and while it collects data on a secondary job, I'm not sure it collects it in terms of the way that in which particular industry or type. So the information provided tends to relate to the primary work. In relation to labour hire, that figure's been very consistent for quite a period of time. In terms of independent contractors, which I think Senator Sheldon, you identified that a lot of the gig workers are classified as independent contractors. That figure as a proportion of the total employees is actually declining. So whether it stays declining or not, I'm not sure whether that will be the case, but recognising that within that classification of independent contractors, the gig workers are likely to be within there, subject to them having identified themselves as being independent contractors.
Can I just ask a quick clarification question here? Putting aside sampling error or other procedural problems, when the ABS surveys people about what type of employment they have, if they call an Uber driver, and that's their only job, so they don't have the primary job issue, what would typically they get classified with? Will they be classified as one of these categories? And if so, do we know what would it more likely be?
So the question would more relate to, are you an employee or are you an independent contractor?
Right.
And there's a series of sub-questions underneath that. So the question would be, if, and my understanding is Uber classifies its drivers as independent contractors, then they would be putting themselves down as an independent contractor.
So it's really up to the respondee, but they're only given a multiple choice sort of list of questions, are they?
I need to check the form
they can't
of it,
come and say, I'm a gig economy worker. They've got
No,
the classifications that exist currently, and they choose the one that's best suits
at
their
this point in
arrangement.
time.
At this point in time, okay. Thanks, that helps a lot. Thank you, Senator Sheldon.
Good, thanks. I have got some other questions on insecure work, but I'll go to those at another time. So I just want to move to another matter regarding WorkPac and Rosata. Last night, I understand Senator Watt put the department on notice that we would be asking about the cost of the former Attorney-General and Minister for Industrial Relations, Christian Porter's decision to intervene in the WorkPac versus Rosata case in the High Court. So,
No, you are correct. That was...
What was the total cost to the Commonwealth of its participation in the Rosata case?
The total cost for the High Court matter is $389,907.87.
Well, can you break it down for me? What was the total cost to the Commonwealth of the services provided by Council in relationship to this matter?
The total cost for council fees was $258,209.57.
What was the total cost to the Commonwealth of the thank you for that. What was the total cost to the Commonwealth of the services provided by external solicitors in relationship to this matter?
Solicitors, professional fees for solicitors was $127,256.60.
And what external solicitors did the former Attorney General use?
I believe it was Minter Ellison.
And what was the total cost to the Commonwealth of travel in relationship to the matter?
Pardon me, was that for travel?
What was the cost, the total cost to the Commonwealth of travel in relationship to this matter?
I think travel for either solicitors or counsel would be incorporated within the costs that I've just outlined. There was also for other disbursements, $4,414.70.
Thank you. And what was the total cost to the Commonwealth of accommodation in relationship to this matter?
That would be included in the costs I've outlined.
What was it? So just want to be clear. What was the total cost to the Commonwealth of food and beverages in relationship to this matter? Food and beverages.
I don't have a separate cost for those, to the extent that travel or per diem rates were included, and I'd probably have to double check that they would be included in the figures that I've provided.
How many individual barristers were retained by the Commonwealth on this matter?
I believe over the course of the matter there were 4 barristers involved.
Wow.
At different points in time. So there were 2 barristers at any one point in time on the High Court matter.
Thank you. Minter Ellison is a national law firm. What office of Minter Ellison did the former Attorney General engage?
Sorry, can you repeat that?
What office of the Minter Ellison did the former Attorney General engage?
I don't have that information.
So you don't know if it's the Sydney office or the Melbourne office?
I'd have to check.
Would somebody else here know?
Someone might be able to find.
If you could find that today, that would be very helpful, and who the person was. On what date exactly did Mr Porter make the decision to intervene in the Rosado case?
I think I would just have to look up that date, so that might just take me a few minutes, but I can find that. So that was the date of decision to intervene.
And what date did Mr Porter make the decision to engage Minter Ellison as his solicitors on this matter?
I don't have that information to hand.
Would you be able to get that for us today?
I'll see if I can find that.
Thank you, I appreciate that. And just to confirm, that decision is made by Mr Porter. He was the intervener as Minister for Industrial Relations after all? So the decision was made by Mr Porter, wasn't it?
So the decision to intervene is indeed a matter for the relevant minister. We'll just need to check in terms of the engagement of particular counsel. So there is a panel arrangement. So I'll just need to check and see. And certainly my recollection is that Minter Ellison are on that panel, but I'll just need to check to see whether that was a department decision.
Thank you. Now, thank you for that, Mr. Here. So Mr Porter and the Minister had final responsibility. Mr Porter reportedly engaged Minter Ellison in relationship to private defamation matters between October 2020 and March 2021. Do you know if Mr Porter received free legal advice from the Minters, or was it at a discount?
I'm not aware of any free advice provided.
Have you looked at any potential conflicts of interest?
Can you go back? Sorry, Senator, can I just get you to ask the first part of the question again?
Mr Porter reportedly engaged Minter Ellison in relationship to private defamation matters between October 2020 and March 2021. Do you know if Mr Porter received free legal advice from Minters?
So the question is in relation to whether the former attorney received free legal advice after we had already engaged and paid Minter Ellison. I have no knowledge of that.
No, it was specific. Yeah.
Say, in the context of any advice that the former Attorney General received around a private defamation matter, that would not be something that we would be engaged on.
So you wouldn't ask whether he got free, whether that advice was free?
Not if it's a matter for his private purposes.
And it wasn't raised when it was clear that Minters were doing it, that there was any potential conflicts of interest between the Minister and the Minister's office and him engaging this firm?
I'd need to take that on notice and see if there was any understanding of that from the department's perspective.
So in his capacity as Minister for Industrial Relations, Mr Porter decided not to use the Australian Government solicitor on the Rosada matter, instead gave the very lucrative work to Minters. And at the same time, in his private capacity, it looks like Mr Porter was receiving free or discounted legal advice from the same law firm. Is that what's happened here?
Senator, the Industrial Relations Group within the Attorney General's Department has historically used a wide range of legal advisors. We certainly do use AGS and we certainly do use other private firms. There's nothing unusual in IR Group engaging a firm of private solicitors.
Yeah, thank you for that question. I'm really going to the point of we've got a minister engaging a law firm for free on a defamation case, which had, from my observation in the media, would have had some substantial legal advice being given. That was all for free. Then you've got a contract that's has been awarded to the same firm through the Minister's office. Doesn't that raise some concerns for you?
Senator, as I said, my recollection of the engagement of Minter Ellison is that occurred by and I've taken on notice whether it was done by the department or by the office, is the before the free advice. There's nothing, as I said, there's nothing unusual in IR Group engaging private legal advice, nor is it unusual for us to engage with the AGS for their advice. The Secretary's already taken on notice whether there were any issues of concern that arose at the time that the former Attorney General received advice in relation to his private defamation matter, which my understanding was subsequent to these contracts being let. So
Can I just put you this, Mr. here, and Ms. Jones, I respect the fact that you're looking for further information, but it would seem that there's a matter of potential conflict of a minister that senior people within the department would be aware that that's a matter that's being considered, wouldn't they?
Well, again, I think the evidence of Mr Hare is, and the Secretary said she would take it on notice, that there is a process that is gone through in relation to, there's a panel, and my understanding of the evidence is that it is more likely than not that it was actually a departmental decision to engage a particular firm on the panel. A number of firms are actually represented on the panel, and if I also understand Mr Hare's evidence, but again to be confirmed by the Secretary in taking the question on notice, is that the decision in relation to Rosato was taken before Mr Porter made a decision in relation to what is a private matter. They are two quite distinct events, and based on my understanding, in all likelihood it is the department who engaged the relevant legal firm from a panel via a process.
But I'm sorry, if we received evidence from Mr. here, sorry, you want to say something?
I think there was some additional evidence that could be given to you.
Sorry, thank you.
I was just going to add that Minter Ellison were engaged for the federal court matter as well. So in terms of timing, that would have kind of well preceded the dates that you're mentioning. That would have been throughout I think the latter half of 2019 and 2020, early parts of 2020.
So I just want to get back to this point then. So the Minister, and just Mr here said before that the Minister had responsibility for the appointment, not
No, that wasn't the evidence, sorry.
The Minister's
that
office.
wasn't the
I
evidence.
noticed, Senator, that I believed it was probably the department who engaged
That was the
Alison,
evidence.
but I'd take that on notice.
Thank you.
Thank you. I've got no further questions on that subject.
Can I ask in relation to wage theft, the status of the wage theft legislation that your government promised to introduce 2 years ago?
Do you mean as part of the omnibus bill?
Well, there was a commitment to introduce wage theft laws.
Again, I'm asking you, is that in relation to the omnibus bill?
Well, I understand, I know the history of why the government put forward a version of wage theft laws that weren't as good as some other jurisdictions, and that you wanted your national laws to override those jurisdictions, and the Senate refused to agree with that. So therefore, we are still without wage theft laws. What is the status now of wage theft legislation that the government promised?
To take you through.
So yes, there were within the amendments to Fair Work Act, there were provisions within that dealt with
I'm aware of the
wage
history.
theft.
Are there any further plans, or is it done and dusted? Have you?
Well, I've always maintained that if the Labor Party were to give the support to the remaining parts of the omnibus bill,
Okay, so
I would
the only
more
way
than
we will
happily bring it
get
into
wage
Parliament.
theft legislation that covers the whole country is if jurisdictions that have better wage theft laws than what you offered, if the Senate is prepared to knock out those laws.
Senator, I might ask Mr Manning to deal with some of the detail, but the question of whether there are better laws in place in jurisdictions is interesting, given that those, in particular jurisdictions like Victoria, have largely referred their powers to the Commonwealth. So I'm not sure about their constitutional basis for a large proportion of their wage theft laws. So if
we'll get Mr.
there's
Manning
a genuine
to take.
question there.
So Greg Manning, First Assistant Secretary, Employment Entitlement Safeguard and Policy Division. Senator, as the minister said that a decision on whether or not to reintroduce potential Commonwealth laws is a matter for the government.
Mm-hmm.
And as Mr Hare has said, one or two jurisdictions have introduced wage theft laws, and they are on their statute book. But as Mr Hare indicated, there would be issues there, which isn't really for us to canvass, given that they're not our laws, about the interaction between those laws and the Fair Work Act, which we would imagine would be raised in the event of a prosecution when the facts are presented, Senator.
But in that context, Minister, you've been in the portfolio now for some months. Are you going to introduce new wage theft legislation? Are you pushing this issue along?
Can I, again, my understanding is, I think it was around February the 23rd of this year that I brought on the omnibus bill that included, I think it was, if I'm correct, Schedule 5, compliance and enforcement reforms of the IR bill. If I recall, you did not vote for it. I have always said, if you are prepared to support the balance of the omnibus bill, I will bring it back on. You give me that support today, I'll
If you can
introduce
lift,
it on the first Monday
if you can
back.
lift the standard of the
I'll
legislation.
introduce it on the first Monday back.
Nevertheless, there's still a promise that you haven't fulfilled, in large part because it was the
we fulfilled
assessment
it
of the
because if I
Senate that the
recall, there
laws
was a
weren't
division
good
in the
enough.
chamber, and we were on the side of actually supporting Schedule 5. You were on the side of not supporting Schedule 5. So the voting record of the Labor Party shows that despite your claims,
very
you don't
convenient.
take it seriously.
Minister, let's move on because we wait for you to have another go at bringing those laws in a form that's acceptable to the Senate. Do migrant workers yet have access to the Fair Entitlements Guarantee?
I'll get the relevant officer. Oh, Mr Manning.
No, Senator, they don't. I mean, that was a recommendation of the Migrant Workers Task Force, as was criminalising the most egregious and systemic forms of wage theft, which we just touched on. And the department's consulted on both of those recommendations. The department's undertaken quite a bit of consultation with relevant agencies. You may recall that the Migrant Worker Task Force recommended that access be granted after consideration be given as to the practicalities of doing that in relation to taxation, compliance with taxation obligations, for example. So we've consulted with a number of agencies about those practical matters. For example, Home Affairs in relation to visa compliance, tax in relation to taxation compliance, any other
Did it come up with any issues?
It did. I think we've given evidence at this committee before that...
How are those issues any different to the normal payment of wages that they otherwise would have been entitled to?
Well, I suppose there's two aspects of it. You might be getting to the fact that under the Fair Entitlements Guarantee, if an assessment is done in relation to unpaid entitlements, then we would take tax out of that and advance that amount of taxation to the tax office in the usual course of event. But that is part of taxation compliance. For example, someone could have been working cash in hand and not being paid tax in a different job, or they might indeed have a tax debt.
I don't quite understand how that's any different to if they were being paid ordinary wages, they would pay tax.
Well, the difference, Senator, I think rests in relation to the link to the country, in the sense that if you're an Australian citizen and you have a tax debt, then you're normally in the jurisdiction and more able to be subject to ATO compliance action. If you were in the country, ran up a tax debt and then left, it's very unlikely that you'd be able to be subject to taxation compliance efforts then. So the problem we're looking at is how we should balance that approval in principle.
Doesn't seem like a reasonable
Task Force recommendation with that taxation compliance.
It doesn't sound like a good enough reason to oppose or go slow on implementing that recommendation. When will it be implemented?
Senator, in the government's response to the Migrant Worker Task Force, it accepted that recommendation in principle and said it would undertake that consultation. It undertook, in fact, it did it twice. We did it twice, Senator. We undertook it, and then there was a break in the work when the pandemic first broke out, and we've revisited the issue with the tax office. And the exact timing of any decision on whether to extend Fair Entitlements Guarantee to migrant workers is a matter for the government.
Will they have retrospective access, Minister Cash, if they work for businesses?
I think, as Mr Manning has already set out quite articulately, there are a number of complex issues to be considered before a decision is made.
So there's no... I'm sorry, I had thought you supported this recommendation of the task force to get the job done.
And there's a number of complex issues that are still being worked through, as Mr Manning articulated.
So you're reneging on that commitment to implement it?
Chair, I think yet again I'm being verbal.
I know there are complex issues to work through.
Issues to be considered before a final decision is made, as Mr Manning has articulated.
Okay. You asked some questions in the budget estimates about Avato. In the annual report, the case began in 2019, was concluded in 21. Some workers waited 18 months to be paid their entitlements. Is that correct?
Senator, I don't believe anyone waited 18 months in Avato from the time they made a FEG claim to receive their payment.
Okay, so they had to, of course, that you attribute the delays in getting the payment to making the application for payment.
I'm not aware of the individual circumstances in terms of the time it took, but people have 12 months in which to make an eligible claim, and then we assess it. We have KPIs in terms of our processing of claims, which we're under and have been under for a number of years.
Okay, well, I'm asking these questions for a reason. So if you can take on notice, please, whether there were any... I think there's an officer with some information.
Oh, Ms Saunders? Oh, yeah. So in Avato, I said I was going to make the general point that the other circumstance in which a claim can take some time to be finalised is if review is sought. Is it possible you're thinking about other other cases other than Abato, Senator? I'm not aware of it being an issue in that case, but I can take it on notice if you'd like and confirm the
Well,
timeline.
perhaps if you can take on notice the length of time it's taking on to process FEG claims and the circumstances that might...
But I can say, Senator, in the
that.
Abato matter, we have received 204 claims and we have finalised 204 claims. 17 claimants sought a formal internal review and we finalised those
Okay, and
internal
how long did
reviews.
those reviews take?
One's gone to the Administrative Appeals Tribunal where it sits at the moment, Senator.
Okay, if you can take on notice the time
Will do,
that
Senator.
took. In terms of the issue of family and domestic violence... Yep. Deb, if you want to...
So, if I can, this is an issue that exercises the minds of far too many Australians.
we're moving on.
To domestic violence
And
family
domestic violence leave.
So, I'm assuming that, like all of us here, that you would consider family and domestic violence to be an extremely serious issue.
Clearly, I assume we would all think
And-
that, and certainly, Senator O'Neill, I think the actions that the government is taking in relation to family and domestic violence, and in particular, if I recall, when I was the Minister for Women, it was the first time that we had actually ever, across governments, $100 million women's safety package. It was the largest package I think that's ever been given purely within the Minister for Women's portfolio. Obviously, subsequently, we've been able to build on that. But certainly that dates back to around 2015. So I think our commitment towards, a zero tolerance for violence against women and children is a well-known commitment.
So it's not just for one government, though. It's for all levels of government to do what they can to
No.
prevent
And it's
family
actually,
violence and
glad
family
you raised
domestic
that because that
violence.
actually goes to what we had actually discussed earlier this morning in relation to respect at work and some of the recommendations, and we actually referred to the national plan. And as you and I were discussing, there were a number of recommendations that are actually made to Commonwealth, state and territory governments, given the significant nature of the issues, and obviously the national plan to reduce violence against women and children is something that we all work together on collectively as governments.
And there is considerable interest in this. I'm sure that you'd be very committed to the prevention of family and domestic violence happening in the first place, but also to do everything we can to assist people who mainly are women, not always exclusively, but predominantly women, and their children who are impacted by the violence. And I don't think it's a secret, and I'm sure you're aware of the cost, that it's quite a costly and time-consuming process for a woman to flee domestic violence.
Just on that, Chair, could I just, the answer to your question is I am familiar with all of that, and in particular as the former Minister for Women, but you actually raised the cost to women of leaving a violent relationship. And it's just because very recently, from the 19th of October of this year, so a few days ago, the government, or the Morrison government, will provide women leaving a violent relationship access to a one-off payment of up to $5,000 to help them establish a life free of violence. And through, it's referred to as the Escaping Violence Payment Program. It is estimated that 12,000 women each year will be able to access financial assistance. It's up to $1,500 in a direct cash payment, with the remaining $3,500 available for goods, services and others to support establish a safe home. The other thing that I would note, given you did raise the cost to women of escaping a violent relationship, is the escaping violence payment is not considered taxable or reportable income, and as such, as you would know, will not impact on any other social security payments a recipient may be receiving. So that is in sort of direct answer to your question in terms of the cost. We have announced the new escaping violence payment.
Are you aware of the ACTU and unions representing the frontline family and domestic violence workers who have estimated that it's not $5,000, whether that's tax-free or not, is another matter for discussion, but they've indicated that to find a new and safe place can cost up to $20,000 and more than 140 hours. And I'm sure that you would agree that trying to keep existing employment is also vital in assisting somebody dealing with family and domestic violence. So I ask you this question in that context. Do you believe that someone fleeing an abusive or violent relationship should lose pay while they're doing that?
And I'm assuming you're going towards Labor's paid domestic or family and domestic violence leave proposal.
Well, I am, because, and I'm glad that you know about that. It is a point of distinction, but it's not just Labor's policy. The BCA backs this in now as well. So,
and
you're
certainly,
looking like a bit lonely out there, Senator Cash.
From the BCA's perspective, they are the Business Council of Australia.
They know a bit
they
about
represent
business.
a certain type of employer. And of course, we would say to the BCA that they should therefore be encouraging their members. They remain free to provide entitlements that suit their workplaces. And I certainly commend the initiatives of large employers in providing paid domestic violence leave. You'd also be aware, though, that I think it was in 2018, it was the coalition government that passed the historic legislation enshrining 5 days of unpaid family and domestic violence leave in the Fair Work Act's national employment standards. And just in terms of the escaping violence payment, the information that I have is the payment of up to $5,000 is actually greater than the average value of 10 days of paid family and domestic violence leave, which I understand is worth approximately $2,500 for an average daily net income for permanent full-time female employees. So certainly the escaping violence payment, and in particular in the way that it's actually been drawn up in terms of some of it in cash, but others of it in goods and services and other supports to help establish a safe home, it will provide valuable support.
So,
Can I just quickly just ask an indication of timing? We have Senator Small, it's another 5 minutes. It would be good to try and wrap up before lunch if we can. Where are we
I
at?
still have
She's got 5 more minutes. And
Sorry?
Still have some
Okay,
questions.
great, fantastic.
So if
Thank you,
I
Senator.
can get to the reality that you would be aware, I mean, I'm going to assume that as a woman, Senator Cash, you would not think that people should be losing their pay while they're fleeing domestic violence, and you've come up with a particular package that doesn't meet the ACTU and unions' representations on it. Neither does it meet the reality of workplaces, where 1 in 3 workplaces have already paid family leave and domestic violence leave, supported by the Business Council, and declared their support for 10 days paid domestic family and violence leave. Do you think it's fair that a person's access to such an important entitlement, supported so widely now by the community and at odds with the government stance, should rely on the goodwill of an individual employer? Do you think that it's leaving it in the hands of an individual employer is satisfactory in these days, Senator Cash?
Senator O'Neill, you'd also be aware then that the Fair Work Commission itself is currently reviewing the family and domestic violence leave clause in modern awards, and further consideration of the issue of paid leave will be appropriately informed, by the Commission's revisit of the issue. And just in terms of the Business Council of Australia, as I've already stated to you, and I'm sure the Business Council will be saying to their members, employers, and in particular large employers, remain free to provide entitlements that suit their particular workplaces. And as a member of the government, I commend initiatives, in particular from the large employers, in providing paid domestic violence leave.
So,
but as
Senator
I've
Cash,
said, we
I've
are
got limited
actually
time
providing the
and a number of
$5,000 via the escaping
Yes,
violence payment.
I do know you've given that evidence, but I have continuing concerns where 1/3 of the workplaces have advanced to accepting that family paid and domestic violence leave of 10 days should be delivered. And your government is still stubbornly and, in my view, cruelly refusing to provide all workers with this important entitlement. And I say this as somebody representing regional and rural New South Wales in particular, where there are many employers who are not big employers, and you're saying, well, the big employers can do it, the small employers shouldn't be doing it. It's many small employers who are actually doing it because they're intimately engaged with people that they live in community with, and they're taking on the cost of this. And the government is not supporting them. So,
Can I confirm, Minister, you won't be legislating for 10 days paid family domestic violence leave?
Well, I think that the position of the government is clear. In terms of the review by the Fair Work Commission, further consideration of the issue of paid leave will be appropriately informed by the Commission's revisit of the issue.
So it won't be a commitment before the next election?
In 2018, it was actually the coalition government that passed the historic legislation in relation to enshrining 5 days unpaid family and domestic violence leave in the Fair Work Act's National Employment Standards. But you appear to also be dismissing the escaping violence payment,
We've got
which is a very important payment of
Yes.
up to the $5,000.
We've got limited time, but I'm
So
just
it's pretty
confirming
clear.
that's a no.
That's a no?
The Fair Work
I've said I've
Commission
the
process
position of the
doesn't
coalition
conclude
government.
until late next year, so on that basis there won't be any legislation until after that point in time. Can I just quickly ask, do you have a commitment to fund working women's centres, recommendation
This was
49?
something that was gone through, Chair, in detail yesterday in the respected work section of the Attorney General's and Senator McAllister and...
Okay. All right.
Like detailed questions. It would be the same questions, I'm assuming, so if I just refer you to that Hansard, perhaps.
Thank you. It was specifically in relation to recommendation 49 and wet. Okay,
So,
I'll
yeah,
look
Senator
at that,
McAllister did just...
Hansard.
you may have other questions.
Thank you, Chair.
Thank you, Senator Pratt. Senator Small.
Thank you very much. And if I can return back to the IR Omnibus Bill, please, which I think, as the Minister previously mentioned, we successfully legislated in February this year, even though Labor and the Greens voted against it. But I understand that as part of that legislative change, a double-dip liability was absolved for Australian businesses. Can I ask, how big was that liability estimated to be?
I could probably answer that, Senator Small, because I certainly referred to it during the debate. The potential financial liability was up to $39 billion through Australian businesses through double dipping. I think you'd understand that better than anybody here, given your background. You're a small business owner.
Well,
in addition to being a working senator, you're also a very successful small business owner.
Well, indeed, Minister, and that was my next question was this a liability faced by certain types of businesses or all Australian businesses who employ Australians, from
That
small
is exactly
to large?
right. It could have been faced by all Australian businesses through double dipping if you had a casual employee that was then determined to be not a casual employee but a more permanent style, and they would have been entitled to both the casual loadings and the entitlements of a more permanent form of employment.
Indeed.
I mean, you tell me. I'm going to ask you a question. I probably shouldn't do that, Chair. But would that cripple you financially as a small business owner I'm assuming you employ casuals, you've got a hospitality business?
Indeed. And so perhaps to be orderly, can I ask if anyone was aware of press coverage, for instance, in the Australian Financial Review, of a dry cleaning business owned by a husband and wife in Melbourne who faced an $80,000 liability that they assessed would have bankrupted them and their small business?
Well, I certainly am. And this is why, in particular, the Rosato case, I mean, what it found, as you know, was a casual employer... the High Court found that Mr Rosato was a casual employee and ultimately, in the Rosato decision, not entitled to payment for certain leave entitlements under the National Employment Standards. But for that decision, but obviously but for the government stepping in and legislating to provide that certainty, the dry cleaner may have gone under.
So on the 4th of August this year, Mr Tony Burke criticised that Rosato decision and committed, that is in the High Court, the Rosato decision, and committed Labor to reintroducing the confusion and uncertainty that was facing all Australian businesses, large and small, saying that a Labor government will overturn the government's scheme. Can you please walk me through what that would mean for Australian businesses, especially Australian small business owners?
Yep, I'll get Mr Hare to take you through that.
So it probably helps to understand some of the dynamics there. So when we did the calculation of that amount, we looked at the number of employees that had been casual for an extended period, and we used some of the ABS data to determine that. And with that, we did that only over 6 years. We didn't go back further than that. And recognising that there's, in a typical year, there's approximately about 1 million casuals who've been working for the same employer for a year or more. So there certainly would have been the possibility right across businesses in Australia, those who use casual employment, for them to have quite large back payments in place, particularly if they've had casuals who've been with them for a year and had a steady rate of income as part of that.
Because effectively, I guess the proposition here is that those businesses are paying the casual employees a 25% loading in lieu of the leave entitlements that would otherwise be applicable to them, and that then even having paid that 25% loading, they would then also need to pay out the leave entitlements as well. Is that what Mr Burke's Labor Party policy would mean for Australian business?
That was the implication of the full federal court decision, yes. It's why the matter was appealed to the High Court. But the implication of the full federal court decision was that people would have to be paid in addition to any loading if that loading hadn't been in addition to any loading.
Thank you, Chair. Nothing further.
Thank you, Senator Smalley. Senator Pratt has a quick question.
Just before we move on from working women's centres, the Northern Territory Centre's at risk of closure and discussions are currently underway. Have you intervened in any way to prevent the risk of closure for that centre?
Well, that is why at the last budget I intervened to actually get them the funding for this financial year, and obviously there are ongoing discussions, and in particular with the states and territories, because they are funded by both, in their circumstance, I can't remember if it's the Northern Territory or the Queensland Government, and the Commonwealth Government. The states, there's only three, so yeah. Queensland, the Northern Territory and South Australia, and they receive funding from both the relevant state or territory government and the Commonwealth Government.
So you're aware there are current discussions about an office closing?
I'm aware that there's discussions in relation to also the states and territories and the Commonwealth as to how they should be sustainably funded going forward.
So do you expect that any of them will close? Any of the three existing ones will close, or have their services reduced?
Well, that's why I stepped in to get them the additional funding.
And will you step in again now?
Well, that will be our decision via the budget process.
Thank you. Thank you, Chair.
Okay. Thank you, Senator Pratt. We will break for lunch, but before we do, just let the department know that I believe we have no more questions for industrial. Oh, you do have more. Sorry.
You haven't been following the thread. I said condition.
Breakdown in communication.
1 o'clock, Chair.
So how long have you got?
My apologies,
That's
Chair.
okay.
Could we work through to 1 o'clock, Tony? And
Sorry?
Could you work
How long
through
have you
to, say,
got?
1 and finish them
I
off, so
keep.
Well, it won't take... Oh,
is that,
we could possibly do it in 15 minutes.
yep, brilliant.
Okay, we'll just check with the
easier.
hands. They've got the thumbs up.
Yep.
So Senator Sheldon, over
Thank
to
you,
you.
Chair.
Just want to go to the casual conversion provisions passed by the Parliament in March this year, and are now fully in force, are they not?
What was that?
So
fully
they're
enforced.
enforced now. Yep. And how many casual conversion provisions in numerous modern awards have been weakened in line with the legislative changes?
Senator, if I may, so as you be aware, the Fair Work Commission undertook a review and they reached a decision on balance in their view. They felt that the provisions within the Act were stronger, and accordingly they made a recommendation to them. But I might ask Ms Wang to work through the detail of that.
Mr. Hill, while she's going to answer that, just to be helpful, the Commission's working within the confines of the legislation, aren't they? Like straying out of the legislation is a rare beast, if ever.
So my understanding is the Commission looked at the legislation and looked at the existing provisions and made a decision. It is entirely possible for the Commission to provide for more generous benefits than in the legislation. It's not uncommon in the NES, for example, for provisions in the awards to be better than the minimum standards set in the National Employment Standards. So it might be helpful if Ms Wang takes you through the process, the detail of the process that the Commission followed.
What would be helpful of just this, because I'm mindful of now 12 minutes. Do you know how many casual conversion clauses that were moved in modern awards that have been weakened in line with this new legislative changes? And of course, weren't there certain awards with conversion rights of after 6 months? So I'm asking that question.
Lace Wong, Assistant
Thank you.
Secretary of the Safety Net Branch. Yes, as Mr Hare said, the Commission made decisions and the National Employment Standards casual conversion are beneficial than all the conversions in the awards. Yes, you're right. There are some, the casual conversion clause in the modern awards, they do vary. And specifically, there are some awards have long-standing conversion clauses.
After 6 months?
Yeah, that's after 6 months, and as versus of the 12 months and employment with 6 months of regular work and regular patterns. But the Commission still of the views these national minimum employment standards are more beneficial in terms of employees for a number of reasons. One of them is none of the conversion clauses in the modern awards require employer to make an offer, which is enhancement in the statutory obligations.
That's a matter of perception. The fact is they don't have to make an offer because the person has a right. So if you're saying an improvement is that the employer can make the decision, I don't see that as an improvement.
So the Commission
I was accused
also,
of being illogical yesterday. I'm probably going to accuse that again today.
Senator, just quoting the Commission's decisions, outlined the reasoning they made in their decisions. One of them is from their opinions. In their decisions, the employer's obligation to offer make the statutory conversion requirement is stronger than what's already in the award. Secondly, they considered the National Employment Standards provide the residual right for the employees to request, which is ongoing, and in comparisons, the award is a once-off right as opposed to an ongoing right. So the Commission does make the decision is quite, as you all expect, and the Commission's decision is very long and also addressed to 122 awards. But what I outlined is the key consideration I would I take away from their decisions.
Right. In light of there's a legislative frame that's put forward, which has been put forward, which we've confirmed, and it's in practice, can you answer the question I asked? How many wards where the conversion rights were that had previously been 6 months, where the individual could claim for a permanent job, how many of those have been changed?
I have to take on notice in terms of the total numbers, but I am aware of a number of decisions might have that particularly contentious in terms of their existing clauses in the awards. One of them is the manufacturing award. But I have taken on notice is how many awards and in total they have. But my recollection is I have to take on notice to confirm, but my recollection is below 10, fewer than 10.
Thank you, Ms Wang. Mr Hare, was there a look at what the effect was on how, and on the 10, I'm just going with 10 at the moment, on how many workers are actually in those 10 industries and how many were affected?
I'd need to check the detail of the decision, Senator. Certainly I'm aware that, as Ms Wang outlined, the Commission felt on balance that the legislative provisions were more generous for the reasons outlined, but I can take on notice whether they looked at the number of employees likely to be covered or relying on those awards.
Well, I'm asking a slightly different question. Did you do can you, if you can't give us an assessment or that assessment wasn't made on the impact on Australian workers that lost their 6 months conversion?
So, Senator,
conversion they could ask for and could have a right to, not a conversion the employer can either give or not give.
Senator, as you are aware, the Fair Work Commission takes the evidence put by the parties. In this case, both employers and employees were well represented and able to make fully the arguments around it. As I said, I can check the record of the decision to see whether those factors were articulated.
Just moving to another question. Thank you for that, if you can do that. How are employees informed of the new measure?
I would say, Senator, all the employees are required to receive the casual employment and new casual employment information statement, which includes the statutory measure.
My apologies, Ms Wang. What I was asking was, or maybe I wasn't clear, how were employers informed of the new measure?
The employers was informed, sorry, I start again. The Fair Work Ombudsman is the institutions in the Fair Work and framework responsible for education and communicating those obligations and the rights into the employers and the employees, they will appear, I think, shortly after us, and they can provide further details. But I'm aware they have had undertaken a range of communication strategies using their existing channels they have with the employers and employees.
As the overarching department, I gather you're happy with what's happened with the information that's been passed on to employers?
I think it's...
It's not a trick question.
No.
You're going to produce something.
So we're comfortable that the Fair Work Ombudsman has the role and they've undertaken it. As with many aspects of communication across a large number of employers, it's always a difficult exercise. So yes, but we are comfortable that they've undertaken it.
So I want to go to the question of actually oversighting the effect of, we don't know what the numbers are for people that have lost a 6 months right to convert, not just an employer right given or not given after 12 months. We don't know the number of workers that are actually involved in the industry, so we don't know what the impact is on working people. Well, the government doesn't know what the impact is on the legislation that they implemented. I might just go to another question about impact. How do you know whether all employers captured by this new provision actually informed their employees of the offer of permanency?
So, Senator, we have, at this point in time, we don't have the ability to measure that. The casual employee information statement does actually clearly communicate to employees what they should expect, and there are dispute resolution processes also included with that enable both individual employees but also unions to go to the Fair Work Commission or otherwise the Federal Court to dispute.
But we're fully aware that workers are constrained from turning around and because of the way the legislation is written, because the employers have the superior say on whether somebody is casual or not and whether they should become permanent, even if they're doing permanent hours, which is the heart of the Rosado case. And I just want to ask again, so there's no measure now of how many employees have had an offer of permanency. What enforcement measures are in place to ensure employers are compliant with the legislation? This is new legislation. I know that additional resources have been put in.
Yeah, so certainly the Fair Work Ombudsman's process around communication is an important part of that. There are anti-avoidance provisions within the legislation as well, which again are largely the responsibility of the independent agencies, and there is also the process, as I talked about before, where dispute resolution can be involved. But again, those matters are better put to the individual agencies.
Thank you, Mr. Hare. Is it not the case that 2 or 3 weeks ago, TAFE New South Wales let all of its 7,700 eligible casual staff know that they weren't getting permanent work? Not a single person. These are workers doing exactly the same job as their permanent colleagues and have done that and has been done by so many.
I'm not aware of that individual matter. That would be a matter for TAFE New South Wales, if that's the body that
So
you said.
you're saying the issue isn't the impact of the legislation and about, so you're not reviewing the impact of the legislation
Senator,
and its success or not? Look, just while Senator Small's interrupting, if you're doing an assessment of the legislation and its effect and its compliance, which is generally under the remit, but you can't tell me 7,700 people that are eligible casual staff
And
were told that they weren't
that
they were going to become permanent.
So, Senator,
Same thing happened to the 1,100 casual staff at Western Sydney Uni. They all got a letter saying that none of them are eligible. It clearly shows that there hasn't been a case-by-case assessment of the individual circumstances of each employee, which is exactly what we said would happen when this legislation was debated.
So,
And are you concerned about these stories?
Senator, I'd be very... these are matters that are appropriately dealt with in the Fair Work Commission, where they do have the power to deal with disputes. Certainly if those employees or their representative unions are concerned, I'd absolutely encourage them to go to the Fair Work Commission. That process was included in the legislation for that exact
based on
purpose.
your legislative changes.
Senator, until we actually see how it works through the dispute resolution process,
well, we know how it works through, because we've just given you two examples.
Senator Sheldon, my understanding
We know
is
how it works through. We've given you two examples of where
they are able to challenge that decision, and my sorry, Senator Sheldon, they are able to challenge that decision, so they can actually apply to the Fair Work Commission to challenge that decision. My understanding is that to date, and the department can confirm this, that in terms of applications that have been made to the Fair Work Commission challenging a decision by an employer under the government's new casual conversion laws, there are actually only approximately 4 that have been made. So in relation to the letters that you say were sent out, they can challenge that.
They absolutely can challenge. There are specific dispute resolution procedures included within the legislation that enable that to happen. Certainly my recollection is that if they're represented by a union, that union has standing to bring that matter forward. And indeed, if they've got particular dispute resolution clauses within their employment instrument, then that can be a binding ruling by the Fair Work Commission. So there's, as I said, once we actually see whether people object to that decision, whether they ask the Union for Sport or decide to take it to the Fair Work Commission for themselves and then see what the final decision is, we won't know what the actual impact is on those employees.
So,
Thank you.
I'll finish up because you just said quick. I'll finish up on this.
Okay, that'd be great. Thank you.
So, New South Wales Government through TAFE New South Wales, Western Sydney University, 1,100 casual staff, TAFE New South Wales, 7,700 eligible casuals, all got told that they could not turn around and become permanent. Now, what I can say is when you do not have a conversion clause, where there's an automatic right, and it's up to the employer. This is exactly what we said would happen. And what my concern is that these workers that are able to take cases up are confined by the lack of rights that they previously had in many conversion clauses across various awards.
Senator, if one is correct, one of the evidence I provided, and I just got advice, I think it's around 12 awards in that group. And also, if I may add, the eligibility, if I understand the case correctly, is these workers may be found ineligible for the casual conversions. And as I indicated, the employers are required to make an offer, but if the employees are found ineligible or in our employers' opinions, they are not eligible, and they certainly, as Mr. Hare said, they can start a dispute resolution process and to challenge that decision. But also, if they were not eligible at that point of time, once they become eligible, and the right to request will remain because it's ongoing and a residual right.
Yep.
So you aren't able to tell us of the amount of people yet that were affected by these now 12 awards?
No, sorry, I don't have that information yet, and we will go through the Fair Work Commission's decisions, whether that has been evidence provided by the parties, but we will take a notice, and at least we be able to estimate how many people covered by those awards, but not saying the people covered by the awards will be relevant to this particular clause.
Can I just put this hypothesis, finally, put this hypothesis to you, that, Minister, that if you're an individual casual worker and your employer says there is not ongoing work for 12 months, or you're one of 7,700 workers at TAFE, or one of 1,100 casuals at Western Sydney University, that an individual worker has to make the complaint. So there's not an automatic duty of responsibility on the, in each case stands on its own merits in the confines of the legislation, which says significant powers are given to the employer.
So I just want to clarify, the dispute resolutions could vary depending on what instrument covers them. So I'm not particularly familiar for example, the employees in TAFE with the New South Wales government, but my recollection is most of universities would have an enterprise agreement under the federal systems, and almost all of them would have dispute resolutions provisions in their enterprise agreement, and we can
Ms.
also
Wang,
check.
if you don't mind, that's very helpful information, but it doesn't help very much those workers at Western Sydney University, does it?
Ms. Wang was making was they have the opportunity to challenge the decision.
We can follow up with the
We've
Fair
gone.
Work Commission later.
Yes, that's true.
And they're confined by the legislation, that's correct.
Thank you for your indulgence,
That's
Chair.
all right. Thank you,
Thank you, Chair.
Senators. Thank you
Thanks,
to the
Chair.
Industrial Relations Group. There are no more questions for them. I'll also, before breaking for lunch, announce that the Asbestos Safety and Eradication Agency, there are no questions for them. That was scheduled at 10:30 tonight.
10:30 tonight.
They don't have to wait around. And we will suspend and come back at 2 p.m.
2 p.m.
Yep. Thank you. Okay, I reopen
It's funny, isn't it?
the committee. If we could just have a bit of quiet, sorry, especially you, Minister. You'll have to stay behind. I now call representatives from the Australian Building and Construction Commission. I think it's Mr McBurney or any others. Would you wish to make an opening statement?
Yes, thank you, Chair. Stephen McBurney, ABC Commissioner. I understand a copy of my opening statement has been provided and will be tabled, and I'll take that as read. And I will just highlight a couple of brief items from my opening statement, if I could.
You've got the floor.
The ABC is committed to protecting victims of unlawful conduct and securing compensation where possible. Recent court outcomes bear this out, and I want to refer to four. Firstly, the ABCC secured $88,900 in unpaid wages, entitlements and superannuation for a migrant worker in court proceedings against his employer, Open Tiling Services and its director. Secondly, in the agency's first ever age discrimination case, the federal court ordered that a 70-year-old job applicant be compensated $14,500. We took legal action against both the labour hire company core staff and the potential employer Gamala Enterprises for refusing to hire a qualified 70-year-old grader because of his age. Thirdly, Chair, a subcontractor that was excluded from work because they did not have an ETU enterprise agreement will be paid $295,000 by the head contractor Consolidated Power Projects. That payment will be made pursuant to an enforceable undertaking entered into as part of court proceedings. And finally, in the Botany Cranes matter, which is, I note, subject to appeal, the federal court has ordered a female employee who had to run the gauntlet of an unlawful picket that she be paid $2,500 for the distress she suffered, and the victim company, Botany Cranes, that lost revenue as a result of the unlawful picket, will be paid $30,000. I'm happy to provide further information to the committee on any of these matters. And finally, I'll just indicate since my last appearance, I've accepted an invitation from the responsible minister to be appointed as an associate member of the respected Work Council. Thank you.
Thank you, Mr McBurney. So we'll go to questions. Senator Pratt.
The Kiama Aged Care case, as referenced, that there was an article appeared in Workplace Express on August 11. Clearly you're aware of that case. I note the article raised the fact that the federal court judge overseeing the case found the ABCC had been overzealous in its use of anti-picketing laws to continue its harassment of unions. According to the article, in considering the ABCC's claim that 3 officials organised or participated in an unlawful picket when disrupting a concrete pour over safety concerns, Justice Anna Katzman found the regulator, and I quote, too ambitious and described the case as misconceived. May I ask, Commissioner, what's your response to that?
Chair, in the first instance, sorry, Commissioner, are you quoting from an article, Senator Pratt? And if so, could you possibly table the article so that we could review it? And Commissioner, I don't know if you require a copy of the article so that you can see the quote in context.
Thank you, Minister. I'm aware of the case, I'm aware of the article.
Okay.
And I'm in a position to respond.
Okay, that's fine then. Okay.
And look, thank you for the question, Senator. And Kiama was a important case for us. And I'll ask the Deputy Commissioner Kelleher, who's our Deputy Commissioner Legal, address you on that court outcome and directly answer the question you've asked.
Thank you, Commissioner. Matt Kelleher, Deputy Commissioner Legal. Thank you, Senator. I'm aware of that judgment, a liability decision of Her Honour Justice Katzman. That proceeding currently remains before the court. It was substantially a successful outcome for the ABCC, whereby on the 10th of August this year, Justice Katzman delivered her judgment on liability, finding contraventions by CFWMEU official Mr Denalis and Mr Demetriou, as well as the CFWMEU as well. Mr Denalis was found to have contravened Section 500 of the Fair Work Act by intentionally obstructing concrete workers, and Her Honour said that the evidence firmly establishes that Mr Denalis's actions with respect to the driver of the truck interrupted the pour, causing the concrete to spill and the driver to leave, and that there was little room for doubt that Mr Denalis's actions were intentional. And Her Honour also found that on the 27th of November 2018, Mr Denalis contravened section 503 of the Fair Work Act, finding that he misrepresented that he was authorised to stop the concrete pour, prevent the concrete agitated.
Order case, I want to draw you to the words of Justice Anna Katzman, and I can see that you're talking about the other parts of the case that are related and linked, but my question related to her judgment that found the regulator too ambitious and described the case as misconceived. In citing all of that stuff back to the committee, are you rejecting that analysis, or can you accept that analysis in part of the judgment? I'm not quite sure of the relevance of what you're saying.
Senator, the relevance of what I was saying was findings made by Her Honour amounting to contraventions of Part 3(4) provisions of the Act being substantiated. We note the comments made there by Her Honour, but it would not be appropriate for me to talk further as to those, noting that it is before her for the determination of penalty in relation to the contraventions that were established on the 5th of November 2021. Penalty will be determined. And as for the remainder of the decision, as with any case where aspects are not substantiated to their fullest extent, we take the decision under consideration.
Okay, but if you had accepted those remarks, you could comment on, if you had accepted that finding, then that could be relevant to the judgment and the findings of penalties. So do I take from that that you reject that finding, or you just choose to remain silent on it and the judge will have to make up their own mind?
Senator, it's not a case of rejecting that finding. As I've said, the matter is still before the court.
Are you contesting that matter, therefore? You don't agree
Senator,
with the finding? What have you argued in the court in relation to that finding of the judge?
Senator, it is a matter that remains before the court for the determination of penalty. That remains what you put to me, a finding of the court, and it wouldn't be appropriate to comment further on it whilst it remains before the court.
I note that in the case it was the ABCC's contention that 3 union officials failed to show their work health and safety permits when conducting a safety inspection. During the course of the hearing, the ABCC's own key witness admitted that this was not the case, contradicting his own sworn evidence and the evidence of another ABCC witness. The key ABCC witness was then viewed by the judge as appearing to make this up, to quote, to make up his evidence as he went along. Is that correct? Why do you put such witnesses before the court?
Senator, as I've said, the matter remains before the court. Outside of the findings of fact that have been made, it's not appropriate for me to comment any further. The penalty hearing is listed for the 5th of November. The matter is under consideration. What I would say is that all matters that are put before the court are the subject of external legal advice that requires there to be an assessment of there being reasonable prospects of the proceeding succeeding. In this case, like all others.
I'm not asking you about the reasonable prospects of the outcome. I'm asking you, is what this witness said false, as the judge said in appearing to make this up, and why did you put them before the court?
Senator, I would simply restate what I've said. I don't wish to prejudice the outcome of the proceeding. That is still to be determined in respect of penalty.
Surely, though, if you know something's a lie before the court, that you are actually supposed to
Chair,
correct
I
that
think
evidence.
we need to be very, very careful, Senator
No,
Pratt.
I'm not asking...
No, but you've just stated a lie before
Well, I'm asking if the
court.
ABCC knows if it was true or not. I'm not asserting that it was a lie. I'm
I
simply
think
asserting
so.
what the judge says, which is that the witness appeared to make it up.
No,
Now,
and what the evidence, the official is trying to be clearly as helpful as possible, but he has clearly stated, as he is allowed to do so, the matter does remain before the court. My understanding is the evidence was the next time it will be looked at is on the 5th of November 2021, so very, very shortly. And the exact words the official just used was he does not want to prejudice. Well, we just do need to be very careful, Chair. I mean, the official is really trying to be helpful.
Senator Pratt, the Minister had expressed a view to me. I was a little concerned myself, but I was leaving it to the witness to provide as much information as he felt possible. But given this matter is before the court, I think it would be helpful if our commentary was somewhat restrained, so as not to.
okay, can I ask, will the
prejudge those
ABCC
judgments.
be correcting its evidence when it next comes to court on the 5th of November?
Senator, I have answered the questions that you have asked consistently that the matter is before the court. I don't wish to prejudice it. The evidence in the matter has been led. It now is a determination of penalty from here.
Why would the ABCC seek to prosecute the CFMEU using... let me put it this way. Why would the ABCC seek to prosecute the CFMEU if it didn't have any evidence to substantiate its case? What is the evidence that you've used to substantiate the case if, in this instance, key witnesses have admitted that their own sworn evidence is false?
I am happy. It is up to the officials to decide how much information they can provide, but I am getting a little uncomfortable of a matter before a court. This is not the place to prosecute or re-prosecute, in this case, the evidence of a matter before the court. But with that in mind, I will hand over to the officials.
I would note it would
provide
need
as much
a
information
public
as they can.
interest immunity claim
Well,
citing
upset.
those...
I accept that, but over to you, Mr. Kelleher.
Thank you, Chair. Senator, I don't wish to comment further in respect of the particular aspects of this case, noting as I have that it remains before the court. But in general terms, what I would say is that, as I outlined, the agency files proceedings only where external prospects of success have been provided to provide that reasonable prospects of succeeding in substantive case are open, and we would never file a case that did not have evidence to substantiate that.
Do you know if this particular piece of evidence is true or false? I'm not asking you for which one of that it is. I'm asking you, is it in your personal knowledge to know whether this piece of evidence is in fact true or false?
Senator, the Commissioner, if I could take the question, as is my right as Head of Agency. Mr Kelleher has explained that the matter is before the court. We're in a position that we are between a liability hearing and a penalty hearing. Our right to appeal arises when final orders are made by the court. All of those matters will be considered by our legal advisors, and we will be in a position to answer your questions when the matter is finalised, Your Honour, and we will come back to you and answer those questions for you.
Okay, thank you. In that context, can I also ask if the evidence is false, what will you do to correct those facts?
Well, Senator, I'm not going to speculate on a hypothetical question. We're going to await the outcome and the...
Well, therefore, Commissioner, is it hypothetical? Is it within your own personal knowledge to know whether these facts are true or false?
Well, Senator, I need to take legal advice on all aspects of the case, which we do once the court delivers.
You have an obligation to answer
Senator
a question
Pratt
that is
continues
within
to
your
talk
knowledge.
over the top of these witnesses
He's not
on very
answering
sensitive
my
matters.
question.
Yes, look, just on the point of order, I have already ruled or have already outlined that there is the prospect of a sub judice claim here. I think with that in mind, Mr McBurney has taken these matters on notice to get legal advice.
How would it be sub judice
Senator Pratt,
correct evidence
Senator
before
Pratt,
this committee?
Senator Pratt, I was about to also discuss the talking over witnesses, and you started talking over me. Mr McBurney has taken these matters on notice, which is his right to do, and seems entirely appropriate in this case. You're welcome to ask more questions, but you will be pushing up against repetitive questioning soon, and I accept the point of order that it would be best for all if we could not talk over witnesses as much as possible, although I accept that robust lines of questioning are welcome and appropriate. Over to you, Senator Pratt.
Thank you, Chair. According to our own procedures, if you know the answer to this question, you either have to tell us the answer or make a public interest immunity claim. And I'm unclear as to what kind of claim would serve the public interest for us not to know whether you in fact believe this evidence is true or false.
Senator, I'm not able to answer your question as to whether I believe the evidence is true or false. I wasn't at court, I wasn't privy to that evidence, but quite apart from that,
thank you.
The matter is between the liability and penalty phase, and I'll take that question on notice and any other questions relating to the case, and I'll seek to obtain legal advice on those and come back to you on it.
Can you please inform yourself as to whether Mr Kelleher knows whether the evidence is true or false, and on what basis the evidence was put forward? The ABCC's purported mission is to uphold the law and to act as a model litigant. What procedures do you have in place to ensure that its witnesses are telling the truth and that its evidence stacks up before it decides to prosecute?
Yes, thank you, Senator. We are required to comply with the model litigant principles, and I'll ask Deputy Commissioner Kelleher to address you on our internal procedures for ensuring that.
Okay,
occurs.
just in relation to the truth aspect of evidence, not all of the model litigant stuff. Thank you.
Thank you, Senator. The agency, as I have outlined in previous answers, files proceedings only where external legal advice advises that there are reasonable prospects of succeeding before a court. As part of that assessment, that will naturally involve an assessment of the available evidence. And if evidence was to be assessed as being unreliable or untruthful, then that would obviously have an impact on the advice that is to be given, and in addition to whether it would be in the public interest to proceed with filing proceedings or not. So the agency simply would not file proceedings absent both of those criterion being satisfied.
Okay, so you were satisfied that these witnesses were telling the truth at the time you decided to prosecute. What procedures did you go through to ensure that these witnesses were in fact telling the truth?
Again, in light of the fact that this particular matter is before the court, I do not wish to comment on the specifics of it. It is before the court. The findings of fact have been made by Her Honour. They are set out in the judgment, as well as a number of contraventions that have been substantiated. But as with all cases, this case was the subject of the same rigorous assessment internally and externally to ensure that there were reasonable prospects of being able to succeed at the trial. And I note that a number of contraventions did in fact succeed at the trial and have been found as such.
How much money has been spent by the ABCC in pursuing this case, please?
Senator. Senator, I will take that on notice.
Thank you. Over to my colleague.
You finished this line of questioning. Thank you, Senator Pratt. Senator Small.
Thanks very much, and good afternoon, folks. I just wanted to touch on a couple of matters with respect to litigation that the ABCC has undertaken in recent times, and one of them in particular was the case of Mr Craig Kelly and the AWU versus One Steel, where as a result of illegal industrial action, or unlawful industrial action I should say, the AWU and Mr Kelly had to pay One Steel $177,000. In handing down that decision, Justice Bromberg said that the respondents unlawfully imposed substantial economic pressure on One Steel, which of itself requires their conduct to be characterised as objectively serious. In addition, in relation to Mr Kelly's conduct, the court said that his conduct in organising the industrial action was nevertheless deliberate. I do not accept that Kelly did not appreciate that the industrial action taken on 31 October and 1 November was not unlawful. I guess in light of this sort of conduct, even with the presence of the ABCC as a tough cop on the beat, what would be the likely impact on employers were the ABCC to be abolished? Who would bring the sorts of enforcement action that has been outlined very clearly in this case in Australia?
Thank you for the question, Senator. This case was brought by the ABCC because it's clearly within our jurisdiction under the Building and Construction Industry Improving Productivity Act. We have jurisdiction to bring legal proceedings for contraventions of the Fair Work Act and the BCIIP Act. If our agency was abolished, there would not be a specific industry-specific regulator. It would then fall back to two options. Either the company would have to take the proceedings itself, or it would presumably fall back to the Fair Work Ombudsman, who has a more general jurisdiction under the Fair Work Act.
That's interesting testimony, given that the judge did find that this was deliberately unlawful action designed to exert pressure by exposing, in this instance, One Steel to loss or damage. So to continue with this, and I guess the litigation that is currently being undertaken by the ABCC in recent times, can you please update the committee on the Pattinson application, as I understand that leave was granted to the High Court? So what is the particular importance of this case?
Yes, thank you, Senator. Pattinson is listed to proceed before the High Court in December of this year, and I'll ask that Deputy Commissioner Kelleher address you on that.
Thank you, Senator. As the Commissioner has noted, that matter will be heard by the High Court on the 7th of December this year. The agency filed an application for special leave to appeal. Such special leave was granted. The underlying factual circumstances of that case concern freedom of association contraventions by the CFMMEU and its shop steward delegate. The case before the High Court will look at and have determined the level of penalty that can be imposed against an individual, such as this, a party such as the CFMMEU, in light of prior conduct engaged in by it, and whether the penalty, the maximum penalty itself, can act as a yardstick or not.
And certainly that's conduct that federal court justices have described as recidivist. What about the Adelaide Airport matter in South Australia?
Yes, Senator, the Adelaide Airport matter was recently handed down by the federal court. Penalties of $428,250 were imposed, which is the highest quantum of penalties imposed in any ABCC case in South Australia since the agency was re-established in 2016. It concerned the making of misrepresentations about the requirement to show entry permits, refusal to follow directions, and the acting in an improper manner by officials during the $165 million redevelopment of the Adelaide Airport. Two officials in that case were found by Justice White to have repeatedly verbally abused a construction company employee, and Justice White in that matter described the verbal abuse as statements that had a belittling, denigratory and bullying tenor, and described them as a form of abuse.
Belittling, bullying, denigratory and a form of abuse. Interesting. What about the Melbourne Metro Tunnel case in Victoria? Can you give the same sort of précis of that?
Yes, Senator, that was the decision handed down on the 28th of June. The federal court penalised the CFMME $85,000 and its shop steward $5,000. That penalty, the $5,000 penalty, was suspended for the taking of unlawful industrial action on the $11 billion Melbourne Metro Tunnel project in 2019. The judge in that case noted that, or observed that Mr Parker, the union representative, as there being no evidence of any expression of contrition for his conduct, but compared to the union, noted that unlike Mr Parker, the union had a gross history of prior offending against industrial legislation, and in relation to health and safety specifically, the judge said that what the union has done there is a modern acknowledgement of the moral of the boy who cried wolf, that too many such cries can lead to demands for safety measures being ignored, even when they may be fully justified and need to be instantly responded to. And in that matter, costs were payable to the agency to the tune of $7,000 as well.
So, Mr Kelleher, in large projects, in small projects, in big cases, in small ones, would it be fair to say that there seems to be a fairly consistent group acting in a particularly consistent fashion in a way that is problematic in the Australian industrial relations system?
Senator, yes, I do think that that's a fair observation. Those comments have been made by many judges of the federal court in a number of proceedings now in relation to the recidivism of the CFMMEU, and certainly they remain overrepresented in our litigation and continue to have substantial penalties imposed against them across a raft of contraventions of workplace laws, including coercion, right of entry, unlawful industrial action, and provisions under the Building and Construction Industry Improving Productivity Act, such as unlawful picketing, as was the case in the Botany Cranes matter that was referenced by the Commissioner in his opening.
So, Mr Kelleher, in upholding your obligations under those statutes, what has been the ABCC's litigation success rate?
Senator, the agency's success rate, if I must say, is remarkably high. Last financial year, we succeeded in 16 out of 17 finalised proceedings at a success rate of 94%, which in an area that is often quite contested, a very impressive success rate.
Indeed. A final question from me, given you mentioned entry permits in your earlier answer. I understand that there are a number of officials who have lost their entry permits or failed to obtain an entry permit. Are you able to expand on the circumstances surrounding that and the reasons why those individuals have been precluded from, either the grant or the maintenance of such a permit?
Yes, Senator. As matters stand presently, there is only one State Secretary of the CFWMU who holds an entry permit, Mr. Jason O'Meara in the ACT. The State Secretaries of each of the other divisions of the union, each of the other branches of the union no longer hold a permit. Mr. Rabbar in Queensland recently abandoned his application for an entry permit after the intervention of the ABCC to contend that he was no longer a fit and proper person to hold an entry permit under the Fair Work Act. Mr. Michael Greenfield in New South Wales, an Assistant Secretary there, also discontinued his application for an entry permit following the intervention of the Commissioner to argue that he was not a fit and proper person to hold an entry permit. That followed Mr. Greenfield's conduct found against him in the Botany Cranes matter. That was described as industrial bullying and shocking behaviour by the judge. Mr. Buchan in Western Australia no longer holds a permit. Mr. Stecker in Victoria no longer holds a permit, nor does Mr. Sutherland in South Australia. And more recently, Mr. Molina in Western Australia, previously a WA Division President, had his permit suspended. That suspension decision is under appeal.
So given that sort of conduct by, in particular CFMMEU officials, and the conduct of the union itself being described in the terms that the Federal Court justices have, would you think that it's a fair assessment that this is a union that simply refuses to modify its unlawful and thuggish behaviour on Australian construction sites?
Yes, Senator. As I indicated, comments to that effect have been made by the judiciary on a number of occasions now. Justice Reres in the Botany Cranes matter said that the union's conduct displayed utter contempt for the rule of law, that the union would only be deterred from further contraventions of the very serious nature of those that occurred in that case by a severe, if not drastic, penalty. Those higher penalties are what exist under the Building and Construction Industry Improving Productivity Act, but not under the Fair Work Act. And in many cases, comments to the effect of these penalties being nothing more than the cost of doing business have been made by judges of the court.
Indeed they have. Thanks very much for your time. Thank you, Chair.
Thank you, Senator Small. Going back to Senator Sheldon.
David, thanks. Thank you all for joining us. I just want to refer back to a matter that was raised before, ABC versus Parker. You are aware of that matter, aren't you, as you stated before?
Yes.
Yes.
So, Mr. McBurney, you're going to answer it. That'd be great.
I was just going to clarify which Parker matter you're referring to. We've had
the Metro Tunnel case.
Yes, thank you. If we are aware of that matter, Senator, and Mr. Kelleher can assist you with any questions you have in relation to that matter.
Thank you, Mr. McBurney. I may well have some questions to come back to you on regards to the matter as well. You've just given an outline of what you see as being the failings of particular parties, but you haven't actually talked about what is actually going on, because I note the criticism of the presiding judge in the matter, Justice Kerr, with the Metro Tunnel case. Justice Kerr criticised the APCC for over-egging its case and for being unresponsive to the judge's concerns about the manner in which it ran, the way it was ran, and likened it to a battleship in full steam, which had difficulty turning. In criticising the ABCC, Justice Kerr also said that the court was entitled to expect the proceedings will not be conducted as a blood sport on the part of the ABCC, and this attitude wastes the court's time. Now, those are direct quotes. Given these extremely serious comments in relationship to a government-funded body, can you outline what if any practical and material changes you have made to the way you conduct your litigation against parties so as to avoid wasting the courts and the parties' time given its obligation to act as a model litigant. Again, I just reiterate that I'm very mindful that those concerns haven't been addressed, which I think are extremely serious, that should have been addressed at the beginning of this hearing. Mr McBurney? Mr McBurney, you must be aware of these matters when they, or aren't you, because they're extremely serious.
Senator, I'm aware and have read the decision of Justice Kerr. This is a case where we were successful. This is a case where findings of contravention were made out. This is a case where penalties were imposed by Justice Kerr. The decision speaks for itself. Senator, I don't read the decision as making any findings against the ABCC of impropriety. The judge has made some comments about the manner in which the litigation was conducted. You've read out those comments. We take those comments on board, and we have considered the decision of the court. We accept the decision of the court, and we're not proposing to appeal the decision of the court. And Senator, I'm quite comfortable with the conduct not only of the ABCC in the case, but the ABCC's legal representatives. I must say we were caught by surprise by His Honour's comments in his judgment, because none of those matters, and Mr Kelleher will correct me if I'm wrong, but those matters were not put to our counsel in the course of closing submissions on the case. But I'll ask Mr Kelleher to elaborate on the answer I've provided you.
Thank you.
Thank you, Senator. As Mr McBurney alluded to, we accept the decision of the court. We note the comments that were made there. The comments were largely in the context of certain evidentiary objections that the agency made concerning material filed by the respondents, which was similar to other objections made by the ABCC in several other proceedings.
Mr Kelleher, that's not the question I asked, thank you. I asked you a question about, were you over-egging the case? Were you a battleship in full steam? And did you have difficulty turning? And further, were you entitled to expect that the proceedings will not be conducted as a blood sport on the part of the ABCC? They are comments, criticisms from from Justice Kerr regarding the ABCC's actions. What have you got to say to that? Do you agree that over-egging occurred? I'm trying to see what contrition we have.
Senator, we respectfully disagree with some of the remarks made. We, as in any proceeding before the court, will, as a model litigant, assist the court in as many ways as we can. We endeavour to do so in that proceeding, and we note that neither the respondents nor its counsel made any complaint about the conduct of the agency in the proceeding.
So Justice Kerr independently made an assessment on the things that you agree with regarding the penalties, but regards your performance as an organisation you don't agree with. So you don't agree with over-egging. Do you agree with a battleship in full steam, difficulty turning? Do you agree with those comments?
Senator, we acknowledge the comments. The matter has not been the subject of appeal. We would respectfully not characterise the conduct in that particular manner. And other than to reinforce my comment that we were entirely successful in the case with $90,000 in penalties plus costs being imposed, I wouldn't wish to comment any further other than to reiterate what I have noted.
Then I'll go for the last comment to see whether So you're saying to me that the over-egging is not something you consider as being accurate. Justice Kerr was inaccurate when he said a battleship in full steam with difficulty turning. I'll see whether we get the third one. Justice Kerr also said, entitled to expect that the proceedings will not be conducted as a blood sport referring to on the part of the ABCC. Do you agree with those words?
Senator, would you please direct me to the paragraph of the judgment?
I can't give you the actual section, but I can say it's entitled to expect that proceedings will not be conducted as a blood sport. I'm sure you'd be aware of that comment. So you're across the case?
Senator, I am aware of that comment, yes. And I do have the judgment in front of me if you're able to direct me to the particular paragraph, just to make sure that the context of the question is understood.
Oh, can I just clarify it then? I am asking you very clearly now on the third matter which has been raised by Justice Kerr, that in the case of Justice Kerr's comments in criticising the ABCC, he said the court was entitled to expect that proceedings will not be conducted as a blood sport, and I'm adding on behalf of, and referring to the ABCC. And this attitude wastes the court's time. So aren't those matters of concern to you? And have you changed? Is there contrition?
Senator, we consider that we conducted the case appropriately, did everything that we could to ensure that it was run as efficiently as possible. The agency was represented by experienced Queen's Counsel in the matter, and we consider that we acted entirely appropriately and in accordance with the legal services directions and our model living obligations throughout.
Yeah, and the criticism was of the ABCC and what instructions, in effect, what instructions were being given on this particular matter. That's in effect the way that I read it. But again, you don't read that there's any problem. You just disagree with Justice Kerr on every single matter, and there's no contrition. I'll now go to the next matter. Yes, by all means, answer it if you want to say something.
I understand the paragraph that you're referring to is paragraph 28 of the decision, and it does reference that the court accepts that the ABCC and the union are old foes and that the litigation as between them will always be hard fought, but the court is entitled to expect the proceedings will not be conducted as a blood sport. So in that context, I do think that His Honour was not specifically levelling that comment towards the agency.
Thank you. So it's not in contention regarding the blood sport comments that were made by the judge. You're just saying that you disagree and have shown no act of contrition, which is what I said before, and you've shown no act of contrition now in your response you just made to my comment earlier.
Senator, as I said, we did everything we could to assist the court as much as possible, and we maintain that that was the case, and we at all times conducted ourselves in accordance with our model litigant obligations. The three comments to which you referred, the specific ones, we were not afforded the opportunity to respond to, and we maintained that we conducted the case entirely appropriately.
Can I just interrupt you for a moment? We've just actually got quite a bit on. You've just given me the same answer you've given me before, so you're only repeating it. Unless you've got anything new you want to add, can you leave it there?
Yes, Senator.
Thank you. I refer to your annual report boasting of a proactive, Mr McBurney, I refer to your annual report boasting of a proactive audit program involving 154 employers, the result of which indicate that 70% of employers did not comply with Australia's workplace laws. Because this is shocking, and it's more shocking yet. The ABCC website indicates that there is only one current prosecution in this wave and pandemic of wage theft across this country in relationship to payment of wages and entitlements. By contrast, there are, according to the website, 25 other current court matters directed at workers and their unions. The 2020-21 annual report indicates that the ABCC recovered less money for less employees than the 2019-2020 year. Now, as noted in a previous question, the ABCC was described by Justice Kerr as engaging in blood sport when it comes to the CFMMEU. Why are you failing to take that same approach to underpaying rip-off merchants, employers that are unfairly competing with those that are doing the right thing, where 77% of them are not complying with basic wages and entitlements obligations? Mr McBurney.
Thank you, Senator. Firstly, I'll just indicate to you it's not 25 cases, it's 35 cases currently before the court. Of those 35 cases, 31 have the CFMMEU as a respondent. We have 5 cases where other unions are a respondent. AWU is a respondent in 1 case. The CEPU is a respondent in 4 cases. We have 2 cases currently before the court against employers. They are Coreform and Jake Gray, and we have 1 case currently where employees are respondents. The second thing I'll just take you to is Mr Kelleher touched on this, but I think it's important that the transcript reflect it. Justice Kerr said the court accepts that the ABCC and the union are old foes and that litigation as between them will always be hard fought, but the court is entitled to expect that proceedings will not be conducted as a blood sport where issues not genuinely in contention are not acknowledged unless strictly proven. So I just think it's important that the record reflect what he said about blood sport, and he linked that to litigation engaged in between ourselves, my agency and the CFMMEU. Then if I could go to the issue of the wage recoveries. Since 2 December 2016, Senator, when we assumed responsibility for this, we have recovered $3,455,502 for 5,971 employees. That's a really important outcome for each and every one of those workers. 5,971 employees have had their underpayments recovered and repaid in full in accordance with our calculations. Where that occurs, we do not take the matter to court where we are satisfied with the rectification undertaken. In all of these cases, we've received cooperation from the employer. And Senator, we accept nothing less than repayment in full. And can I say something else, Senator, about those 5,971 workers? Approximately 80% of them didn't even realise they'd been underpaid. They were the result of our own proactive audit campaigns where we conducted audits of pay records and we uncovered underpayments and we insisted that the employer make good on those underpayments, and the employers have made good on those underpayments. 259 employers, and that money has been repaid. So when, Senator, you asked me about the 70% non-compliance, the next step in our process as a responsible regulator is to address the non-compliance. And we address that non-compliance by requiring rectification of the non-compliance. That's occurred in the vast majority of cases. That's work we do in the wages space, and it corresponds to what the Fair Work Ombudsman does in similar circumstances.
So, Mr McBurney, you've described an industry that is putting along rather than one that has 77% of the workforce being ripped off, and you're not prosecuting anyone. I find that quite disturbing, and I find it not being a deterrent because, Mr McBurney, you would probably be aware that if quite often companies that in the wrong side of the tracks, those companies that unfairly compete with good companies, that they gain the system as part of their business model to carry out wage theft. And, quite clearly you're sending an indication to all those employers, it doesn't matter whether you're ripping people off or not. And I might add, regards your previous figure, I'm very aware that some groups of workers may be aware of the underpayments whilst others aren't aware of the details. That doesn't say that the underpayments have any less validity, or is that what you're putting to me?
No, quite the opposite, Senator. I'm putting that despite them not being aware of the underpayments, it was only through our audit action that they were uncovered, and it was only through our proactive enforcement action that they were rectified and fully paid. And can I just take issue, Senator, we don't put that 77% of the building and construction industry are not being paid their fair entitlements. That's a misreading of what's contained in our annual report. When we talk about non-compliance, it can cover a range of sins. It does not mean that there has been an underpayment of wages. It can be an issue with record keeping. It can be an issue with notification. And I can have my Executive Director Wages take you through the range of matters we classify as non-compliance if that would assist you. But it's wrong to say that 77% of workers have not been paid their correct entitlements.
Well, it's interesting because in another agency, ROC, they spend a great deal of time on making sure the I's and T's are crossed, and when they're found not to be crossed, they tend prosecution action against us, against unions, and certainly I've seen them do it on numerous occasions over the years. And so you're saying that even though there's 70% of employers, and you are right, that did not comply with Australia's workplace laws, that there is still not the prosecutions directly relate to that high percentage. Can you tell me what percentage of employers you have prosecuted?
Could I just ask that where are you getting the 70% figure from, Senator? What part?
I understand that the annual reports are boasting of a proactive audit program involving 154 employers, the result of which indicate that the 77% of employers do not comply with Australia's workplace laws. And you did quote back to me just a moment ago regarding the 77% and gave an explanation about what it meant.
Okay, so I'll ask that the Executive Director Wages, Madeline Jones, answer your question. What's referred to in the annual report is a specific audit campaign related to the apartment sector, and I'll ask Ms Jones to explain that to you, Senator.
No, I've actually asked about, that's not the question I've asked actually, Mr McBurney, in due respect. What I asked, what is the percentage of employers you have prosecuted for not complying with Australia's workplace laws when you find that 70% are not complying?
Well, Senator, I'll need to ask Ms Jones to advise you to explain to you.
You just dropped out, Mr McBurney. I missed the last 10 seconds. No. I'll go to Ms Jones then. Mr McBurney might want to add some comment in a moment. Ms Jones?
Thank you, Senator. I'm sorry, it dropped out for me too, so I'm not exactly sure. I can take the question on notice regarding the number of employers we've taken in respect to litigation, in respect to how many complaints and inquiries we've looked at. In regard to the apartment audit that you were referring to from our annual report, this was an audit program that we commenced in May 2019 and is an ongoing program. With regard to the non-compliance, 39% of the companies audited within that program were found to have failed to pay the correct wages, base rates of pay, allowances, penalties, etc. 38% of those employers had contravened record keeping and or payslip provisions, and or were found to be not complying with their Fair Work instrument, but the employees weren't financially disadvantaged. So in that type of scenario, we provide education to the employer as to how to comply with their record keeping and payslip obligations and how to ensure that they're meeting the requirements of the Fair Work instrument that applies to their employees.
Would you say that all those issues are of importance within the workplace laws?
Yes, I would.
Thank you.
Yes.
I know that you've said 39% regards wages and allowances, if I understood correctly. Then how many employers are in the construction industry under the purview of the ABCC? I'm mindful you've done 154 employers, but aren't there many, many, many thousands? You might be able to give me a ballpark and maybe later take on notice that you can give us an appropriate figure?
Senator, I'm unable to give you an appropriate figure because we're unable to disaggregate the jurisdiction of the Australian Building Construction Commission as defined by the Building Construction Improving Productivity Act versus the other sectors, other parts of the sector that would fall within the remit of the Fair Work Ombudsman, such as residential construction.
So
Senator Sheldon,
you haven't answered the question to me. How many employers are there in the section that ABCC has responsibility for?
I'm sorry, Senator, we don't have that information.
Would it be over 1,000?
I would estimate so, yes.
Over 5,000?
Senator, I can't speculate. I don't have the information. I'm sorry.
Righto. So
Senator Sheldon,
there's certainly well over 1,000. There's certainly well over 1,000 people that are companies.
Okay, Senator Sheldon, I just wanted to get an indication.
You may not be surprised. I'm just going to finish up. I'm just going to finish up with this.
Okay, great. Thank you. Yep, that's fine. Yep.
I just indicate to you that there are tens of thousands of employers in the sector. And all we've managed to do is look at 154, and you've found that 77% of employers do not comply with Australian workplace laws. And if Mr McBurney's evidence is accurate, then there's 3 prosecutions are all that's happened during this period of the ABCC I'm referring to. It's quite disturbing. Back to you, Chair.
Okay, Senator Pratt, thank you.
Chair, just some brief questions. It's been reported in the Sydney Morning Herald, I've got the link if you require it, but that the ABCC spent around $500,000 in a failed prosecution of the CFMEU for demanding a women's toilet be made available on a Melbourne worksite. I believe the case is referred to as the Bay Street case. As I understand it, it involved the ABCC taking the CFMEU to the High Court over a dispute where union organisers demanded a woman's toilet be made available on a worksite. So, can I begin by asking, does the ABCC agree that women on construction sites should have toilets available to them?
Senator, it's my view that women in all workplaces should have appropriate amenities made available to them. I'll refer your question to Deputy Commissioner Kelleher, who can explain to you what the case was actually about rather than what's been misreported about the case. And he can also address you on legal costs. I'll ask Mr Kelleher to take it further. Thank you.
Thank you, Commissioner. Senator, the case that you referred to is known as the Bay Street case. It related to the correct interpretation of provisions within Part 3.1 of the Fair Work Act, specifically the meaning attached to industrial activity in section 347 of the Act. At the trial in that case, which was taken on or commenced by the ABCC, the agency was successful. It concerned a stoppage of work organised by 2 officials of the CFMEU.
Because there was no toilet for women on the construction site?
Not entirely, Senator. Okay. It related to the fact that there was amenities that the union considered weren't sufficient, site accommodation that the union considered weren't sufficient, that nonetheless accommodated 18 workers when there were 16 on the site, and also in relation to separate amenities for a female worker, which which had been the subject of arrangements in consultation with WorkSafe and the female worker that would allow her to use existing amenities on the site. In fact, the manager at the site had agreed to organise a separate toilet, and a separate amenity was subsequently put onto the site. The due of that amenity, although forming part of the underlying factual circumstance, was of such insignificance in the High Court that it did not feature one mention on transcript. So I understand that you look like you're struggling to hear me. it did not feature in one mention on the transcript, and in the full federal court on the appeal, it was by a majority of 2 to 1 that the ABCC was unsuccessful. It overturned what had been a well understood line of authority, and as I indicated, was the subject of a dissenting judgment on part of that decision. It was an unsuccessful outcome, but as I indicated, I think to Senator Small earlier, the agency was successful in 16 out of 17 cases decided last financial year, 94%, which was a testament to our rigorous internal processes. And I think you also asked
Thank you.
about the costs.
Yes, the costs. $500,000 for the dispute over these amenities.
It was somewhat under $500,000, Senator. It was total costs of $440,203, including the trial, the full court appeal, the High Court appeal, and costs agreed to be paid to the respondents in that case of an additional $55,000.
So the employer, it was found, did have to put in those extra amenities, and you spent just under $500,000 arguing that the industrial action relating to those amenities was illegitimate. Is that correct? Defending employers against even the simplest and most basic form of workplace dignity, which is
Senator, as I indicated, the arrangements on the site had been agreed in consultation with WorkSafe. That was a finding of the judge, together with the worker on site, and the application succeeded before the trial judge. It was overturned 2 to 1 at the full federal court stage, overturning what had been an established line of authority.
Okay. It is, sometimes you do need support in a workplace to get what you need for your basic dignity, and that collective organising to say, actually, it's not right that I have to share a toilet. How did you balance those questions?
So I missed hearing you said, Senator, what was that?
I was simply seeing if you could acknowledge the fact that it can be difficult for women in male-dominated workplaces to say, actually, I need something separate and different to everybody else. We've been through those same kinds of debates here in our national parliament, where it was found that women weren't safe. So do you understand the need for women to have people that are prepared to stand up for their rights?
Senator, could I take this question, please?
Sure.
Senator, the ABCC stands ready to support any building industry participant, and I use that term advisedly, that's what the Act describes it as, without distinction, and we will support females, workers in the building and construction industry. This appeal did not relate to the provision of site amenities for women. We just need to make that clear. This appeal concerned the interpretation of relevant provisions of the Fair Work Act. And the critical fact, which has been missed in all of the criticism of us about this case, is that the officials organised a work stoppage despite the fact that the head contractor had agreed to organise the separate amenities for the female worker, and that had been agreed. Now, we are not the amenities police, Senator. We do not prescribe the amenities on site. I agree with you 100% that wherever possible, female amenities should be provided. And I've been in workplaces where that hasn't occurred and alternative arrangements have had to be made. But this case was not about female amenities in the High Court or indeed the full court. And that's mischaracterisation of the case.
I think we can put the rest of our questions for the ABCC on notice.
Okay. Thank you very much, Senator Pratt. So with that, the Australian Building and Construction Commission is dismissed. We're moving on to our next witnesses from the Registered Organisations Commission. So do we have, are they online already? Okay, we're just waiting for people to come and go. Okay, Mr. Bilecki, have we got everybody or all your officials? Can you see everybody?
Yes, thank you.
They're all here. I'm Senator Matthew Canavan, the Chair. Thank you for joining us. Mr. Bilecki, do you have an opening statement?
No, thank you, Chair. No opening statement.
Okay, well, we'll go straight to questions. Senator Sheldon.
Good, thanks very much for joining us this afternoon. I just want to ask a few questions about registered organisations. Do registered organisations have powers that unregistered organisations do not have?
Registered organisations have entitlements that unregistered organisations do not have. They include the ability to represent certain segments of members. They have privileges like there's no obligation to pay income tax. So they are in a different category to an unregistered organisation.
And there are also financial reporting requirements for registered organisations, as you're aware. Right of entry permits. Right of entry permits.
There are. We don't manage right of entry permits, but there are a number of financial and other obligations under our Act that relate to registered organisations.
But you're aware that, are you aware or not, that right of entry permits is something that's given to registered organisations and...
Yes, generally I'm aware of that. Thank you, Senator.
Thank you. Is it concerning from a governance perspective that there are people out there referring to themselves as unions and are collecting membership fees when they are not registered, cannot represent members before the Fair Work Commission and do not have any governance or transparency requirements?
Senator, we've been focused, of course, on registered organisations who are subject to a number of obligations under the Act. In terms of organisations that are not registered and representations they make, I'm not really in a position to comment other than to say if the representation is a misrepresentation, then of course it would be of concern, but we would not have the jurisdiction to do anything about that.
Thank you. There's been a number of recent media stories about the so-called Red Union and various organisations operating under the banner, including the so-called Nurses Professionals Association of Queensland. Are you familiar with those reports at all?
I have seen some of them, sir, and I have read them. I haven't committed them to memory, of course.
The MPAQ's website says, I quote, we are a non-party political alternative to the QNMU. Our membership fees are lower and we provide all the same services. But we've just established that a fake union which is not registered with the ROC, and thank you for your comments, that would be an issue of concern if someone was holding themselves out to be a union, but they weren't. Do you consider that as a blatant lie, if someone's holding out that they're a union when they're not?
It would appear that the claim that you've just narrated is an organisation claiming to be registered, if I've understood you correctly. In terms of other claims that might be made by an unregistered organisation, the efficacy of those would be really to be judged against the characteristics of that unregistered organisation.
Does this goes back to an earlier answer you gave me, but I was going to ask the question in case we've missed something. What is the ROC doing about fake unions making false, misleading claims and duping people out of membership fees? Have you got the capacity to turn around and take action?
No, Senator, we don't have the jurisdiction to do that. From my general knowledge, if there was a misrepresentation made by an organisation and it was in trade or commerce, then the ACCC might have jurisdiction. And there may be state-based bodies with jurisdiction. but I'm not an expert in those areas.
Thank you. The MPAQ website includes repeated references to being non-political and having no connection to any political parties. But reporting by Nick Bonihandy at the Sydney Morning Herald in fact revealed that the director of the Red Union, Mr Jack Maguire, was formerly president of the Queensland University of Technology Liberal National Club. The article also revealed that a person establishing their fake unions in New South Wales, a Mr Lata, is a member of the New South Wales Liberal Party. Is it concerning that this fake union is misleading people into paying membership fees under false pretences when they are actually obviously political?
Senator, I can't take that further. It's not a matter that we regulate. Obviously, it would be good if all organisations made accurate representations about what they do, but I'm not in a position to assess the accuracy or otherwise of those statements.
I've got some press statements I'd like to share with the committee and the Minister. Thank you. Oh, actually, I can do one. I need to put my they're handed out. Oh, thank you. And I understand that they've been handed out, Chair. Chair? Matt? Mate, yeah, they've been handed out.
Have these been cleared? Or? Yeah, we've already got this one, haven't we? Not these ones.
Thank you. Are you aware that Senator Stoker at a hearing at last estimate said, "I value the work that many unions do. When they're at their best, they do good work. I can think of some outstanding ones in Queensland, like the Nurses Professional Association of Queensland and many others." Do you hold those views as well, Minister, in light of the fact we've just been given evidence that they've been making false assertions?
Do you have the article that I could possibly have a look at?
Yep. Yeah. You just photocopy an additional copy, Minister. Thank you. I'll let you just approve
No,
it.
that's okay. So what are you referring me to?
Well, there's a Nick Bonihandy at the Sydney Morning Herald made a number of observations in the article regarding those workers. And also there's an article in front of you by Black Antrobus regarding unvaccinated nurses facing potential sacking as federal court to intervene.
Yes.
Thank you. So what I'm asking is that we've just been given evidence, I've just asked questions of the ROC, and I don't want to put any words into Mr Black, but the way that I understood the answer given, that somebody should not be holding themselves out as a union if they're not actually a union, and for very good reason, because there's substantially different arrangements and rights of representation and obligations that a non-registered organisation has. So I just want to go then to the last estimates. In your absence, Minister Stoker was here, and the Minister at the last estimates said, "I value the work that many unions do. When they are at their best, they do good work. I can think of some outstanding ones in Queensland, like the Nurses Professional Association of Queensland and many others." Do you hold that view as well?
I'm not quite sure what the view is that I'm meant to hold. That's a statement made by Senator Stoker, yes.
Yeah. Do you hold a view that the Queensland Nurses Professionals Association is a fit and proper...
Well, I don't know the Queensland
Nurses Federation Association.
Well, it's in the articles in front of you, Minister.
Oh, you're saying that they're a fake union, are you?
Yes.
Oh, well, I think the evidence from Mr Bielicki was very clear. A registered organisation is one that is registered as an organisation by the Fair Work Commission under the Registered Organisations Act. As a result of that registration, they receive certain privileges and they play a very important role in our industrial relations system. Then there are unregistered organisations, and my understanding is, from a Commonwealth perspective, we don't have a lot of visibility of unregistered organisations, and they are most likely to be incorporated associations under state law and are regulated as such. But certainly in relation to registered organisations that are registered under the Fair Work Commission under the Registered Organisations Act, they have certain rights and privileges.
And of course, under the Registered Organisations Act gives people access to federal awards.
That is correct,
those sorts of
yes.
matters, so they need to be registered. Thank you. I just want to move just briefly, just a couple more questions on this matter. In the article from Nick Bonahandy, the Sydney Morning Herald, is reported about some of the content of the MPAQ puts on its social media pages. In one MPAQ video about the COVID-19 vaccine, a nurse says, and I quote, "It's not even a vaccine if it's not preventing the spread of illness. It's not preventing you from getting sick. It's not a vaccine. We should not even be using this word. I'd prefer to use the term experimental biological agent because that's closer to the truth." Are you concerned that the union I've just described to you, the Queensland, the Nurses Professional Association of Queensland,
it's an organisation that you are referring to.
the reason I'm getting caught in that is
Understood.
because the names that they've used under these fake
Understood.
unions have
Yeah.
tried to capture the exact same names.
Understood. And
as
look,
the areas
they're not
that
a
they're
registered
encroaching on.
organisation. They're not registered by the Fair Work Commission under the Registered Organisations Act. My understanding is they are more likely than not to be an incorporated association under state law, being regulated as such. And as such, any claim that you'd wish to make against them, you probably have to pursue at a state level. But they would not be entitled to the rights and privileges of registered organisations that the registered organisations officials have taken you through.
Minister, would you be concerned if a nurse was saying that it's not even a vaccine, it's not preventing the spread of illness, it's not preventing you from getting sick, it's not a vaccine, we should not even be using the word. I'd prefer to use the term experimental biological agent, but because that's closer to the truth. You don't hold those views, do you?
I think the government's position in relation to the vaccines is very, very clear. Advice in particular in relation to COVID-19 that we take is from the medical professionals. But as I said, from what I understand you're saying, and I only do have the article in front of me, but what I understand you're saying is they are not a registered organisation. They are not registered formally by the Fair Work Commission under the Registered Organisations Act. As such, they are an unregistered organisation, I'm assuming. I will take what you've said. If so, they are likely to be incorporated under Queensland state law, and you'd probably have to raise that with the Queensland government.
Yeah.
So we might go to Senator Betts, if that's okay, and then come back to you, Senator Pratt. Senator Betts.
Thank you, Chair. Good to see the Registered Organisations Commission with us again. I have a bracket of questions relating to your investigation into the Australian Workers' Union, which has now been going on for some time, where you have been successful in relation to each and every legal matter that has been before the courts, and which has unfortunately delayed this investigation. My first question is, in relation to documents that you found that were shredded at the time that the officers were visited in Melbourne, as I understand it, you came across some shredded documents which I think Federal Police then took away. Is that correct? Not all at once or off mute?
Is someone on mute? maybe?
If it's helpful, Senator, I think we did traverse this in estimates a couple of times ago, and we talked about who actually has machines that can shred, and I understood that just about everybody around the table in the room said they have those types of machines in their organisation.
Senator Sheldon,
Okay,
you,
that's
as always, are most
commentary,
helpful,
have
but
we
I
got the
didn't ask you.
witnesses? Was someone answering that question?
I thought
Senator Sheldon, we need to...
Here we go.
Okay, so we can
Yes,
hear you now,
sorry,
Mr. Miller.
Chair. Someone, I think, put me on mute.
It's okay, I was
hadn't
filling
realised it.
the vacant air for you.
Thank you very much, Senator, much appreciated. In terms of the shredded documents, my understanding, and Mr Enright will have more detail, but my understanding is they were seized both from the Melbourne and the Sydney offices.
Look, you have already answered my question as to whether there were shredded documents both in Melbourne and Sydney, because I think last time I only inquired as to Melbourne. But you are now confirming that there were shredded documents, and they may have been appropriate documents for shredding, and I don't want to get into that aspect at this stage, but there were shredded documents both in Sydney and Melbourne.
Can I assist there, Senator? The shredded material was obtained. Chris Enright, I'm the Executive Director. The shredded material was collected by the AFP during the Sydney visit.
So they collected it from the Sydney office. What about from the Melbourne office? There was some collected from there as well?
There were documents collected from the Sydney from the Melbourne office, Senator, but not shredded material.
So the shredded material was only from the Sydney office, none from the Melbourne?
The National Office of the AWU, yes, Senator.
All right, thank you for that, but nothing from Melbourne. Thanks for that clarification. I read with interest a statement in your recent annual report that suggests this investigation is likely to be completed in now, a couple of months, by December. Can you be any more precise?
Senator, we can't be more precise. Our estimate is exactly that. We are subject to impediments that may arise, particularly with the organisation responding to requests that arise from the pandemic. So it's possible that could have an impact on that estimate, but we haven't formally changed our estimate, and we're working as hard as we can to have the investigation completed by that time.
And when you have completed that inquiry, then will that determine whether the AWU and indeed any other individuals might have a case to answer in relation to potential breaches of the law?
The investigation will reveal whether there were any breaches, and in the usual course, the outcome of an investigation would include recommendations as to actions which should be undertaken by myself.
Look, thank you for that. And in relation to the shredded documents, have we had any indication as to whether those documents were of any relevance to this inquiry?
Senator, we're not really able to comment on an ongoing investigation.
I appreciate that. I appreciate that.
Thank you, sir.
Were you able to put that together or not?
I don't know where that question came from, but...
I think that was a rhetorical question that you can ignore, all of us are here. Can I ask, are you familiar with the comments made by the Secretary of the AWU, Daniel Walton, in a press conference on the 24th of October when he said, and I quote, "The AWU has and will always cooperate with any investigation, be it with the Registered Organisations Commission or any other body. We've cooperated from the beginning." In relation to that statement, would you describe that as an accurate statement, given the experience of cooperation or non-cooperation that you've received from the Australian Workers' Union?
Well, there are two investigations underway into the Australian Workers' Union. One involves the donations to GetUp and other donations. That one, of course, was delayed by a number of years because of action taken to challenge our decision to investigate.
And they were failed court actions.
Yes, as you're aware, Senator, every allegation, every argument and every ground put against us failed, and it involved us in extraordinary effort in defending ourselves against those scattergun allegations. Objectively speaking, that's not normally an indicator of cooperation, but since that time we have had some cooperation with the AWU. I'll defer to Mr. Enright in a moment for any further information about that. The other investigation is in relation to membership numbers, and that one has been going for a while. We have had, ultimately after quite a few years of correspondence and acknowledgement by the AWU, that there are errors and inconsistencies in the maintenance of their registers of members in all jurisdictions other than Victoria. The Victorian one, as you know, was dealt with separately in proceedings that also involved the then Victorian Secretary, Mr. Mellor. And the AWU has told us that it is now unable to provide accurate membership figures to the ROC in respect of the period that we are looking at, which is an 8-year period. I can't say much more about all of that because it's an ongoing investigation. One thing we can say, and it's in the public sphere, is that the AWU did commission an audit of their membership figures by external consultants. That was a suggestion that we made to the AWU, and the AWU has indicated that it feels that at least since 2018, its reported membership figures are accurate. But in relation to years before that, we're trying to determine a number of issues that would go to potential breaches, and that work is still continuing.
And, well, I suppose it's an ongoing investigation, but interesting that the word error was made, because usually that is an error is a miscalculation as opposed to a deliberate fabrication, but I don't expect you to comment at this stage as that is an ongoing investigation. You did indicate to us that there had been some cooperation from the Australian Workers' Union, because on the 9th of March 2019 there was a report by Mr. Ewan Hannon, a journalist. AWU National Secretary Mr. Walton has promised to release all documents once the legal process is completed, even if the union loses the current court case. We know the union lost the court case. I therefore ask, have all documents been released as promised?
I'll defer to Mr. Enright, Senator.
Well, thank you, Senator. Well, firstly, in terms of the cooperation, it was in about August 2017 that I expressed the view that with cooperation of the AWU, we may well have been able to resolve this matter in weeks or perhaps even days. And Mr. Walton gave an undertaking that he would cooperate, and then some short time later rejected that or deleted that and undertook this litigation. So in terms of that cooperation, it didn't really work out in accordance with his undertaking. But the cooperation, I don't know what cooperation you're referring to, but all the documents in this matter have been provided, we think provided to the ROC, but those have been provided under compulsion we've had to resort to the ROC's powers to require the production of documents, and so they've been produced in that context, Senator.
Look, thank you very much. Then quickly, can I turn to the issue of costs and ask, in relation to the AWU's failed federal court challenge to the ROC investigation, is it correct that all three judges ruled in favour of the ROC and against the AWU? And I think we've agreed with that. And so the question then is, in relation to costs thrown away, to which reference has been made, has the AWU paid the ROC any costs? And if so, how much?
Under our Act, Senator, we are effectively in a no-costs jurisdiction. So it would be a very exceptional circumstance where a court would order costs to be paid by any party, although in this case it is the case that the AW has paid us the sum of $10,365 towards costs thrown away as a result of a late amendment to its case theory at trial.
Yeah, look, that's what I was going to refer to. So an extra $10,000 plus of members' money was thrown away and paid to the Registered Organisations Commission because of this frolic through the courts in a desperate attempt to stymie your investigations. I look forward to your findings in due course. Thank you very much. Thanks, Chair.
Thank you, Senator Betts. Going back to any more questions? No? No more questions? Great. Okay, well, thank you very much, Mr. Bilecki and others. You are dismissed, and we are now... No problems at all. We're now moving to Comcare. They'd be here, wouldn't they? They'd be in Canberra.
She'll probably slip in for this one.
They're online. Okay, I thought they were Canberra-based organisation.
Yeah, absolutely.
Okay, so we do have some...
Now,
We have some officials here.
Joining us
You're
for
right.
this because this is one of her agencies. If
Okay.
she doesn't arrive, I'm happy to sit here,
Okay.
obviously.
Okay, no problems. I was just checking...
I think we've got people from Comcare here.
Yeah, that's what we thought. So Comcare officials outside, maybe they're just making their way up?
That's the next debate. That's the next one coming in.
So I think we've got officials from interstate online already, and we'll just pause while others make their way.
Yeah, they're coming from downstairs. Oh, they're coming from downstairs, okay.
Did you say Senator Stoker was joining us? For this one?
If she doesn't, it's fine.
But
I can
you
sit here and
okay.
there's no issues there.
Okay, we might just briefly suspend so we can stand down. Great. Back on. I do welcome representatives from Comcare. We note we have some from Interstate Online. And here, Ms Weston, do you have an opening statement?
No, thank you, Senator.
Okay, we'll straight to questions. Senator Pratt.
Thank you. Is Comcare satisfied with the COVID arrangements for your agency to attend today here in Parliament? And what inquiries have you made in that regard?
Thanks, Senator. Look, we have raised this issue as a WH is concerned. You will recall other estimates we've explained that sometimes that when we see some media articles or we have some other things come to our attention that might not be notifiable to us in the normal course of events, we'll raise a WH is concern, and we have in this instance. Obviously, it's the first time we've had to attend estimates with COVID-19 circulating in the community, we did have our inspectors come up and have a look at controls, as already been mentioned today. I think...
What findings did they make? What advice did they provide to you?
So our inspectors had a look about whether there were, what changes had been made from the last estimates, and, you know, there's things like the temperature checks and the check-in. We had a look at what controls were in place, and that the arrangements reflected the appropriate health requirements. I think one of the things that we were waiting for, or our inspectors were waiting for, is the information coming to the two PCBUs, and an area we'd like to have a look at is whether there was any breakdown in getting that information to all PCBUs, because it seems like some areas might have got the advice from the Senate earlier than others, so that's a piece that we're going to have a little look at and work out that.
Okay, so do you think all agencies have fulfilled their PCBU requirement in terms of assessing any risk in attending?
So PCBUs will be making their own determinations of that. Obviously, they'll need to do a risk assessment, and the information provided by the Senate is very important to that. They'll be looking at controls in place and what's reasonably practicable, and they'll be, as relevant, consulting with the workers and implementing anything that they need to, and of course reviewing if things changed.
Okay, but you've seen fit for your agency to be able to attend today, taking account of mask wearing, vaccinations, and consideration of any possible chains of transmission, which we would be hoping don't occur.
So there are controls that are in place, some of which are outlined by the Senate, and there are other controls that we're aware of, and I chased up some other controls to see how they were as well. And we think that there are controls in place that are reasonably practicable to support safe attendance.
Okay, and so you support the fact that all agencies have been able to make a decision to attend in relation that means they still meet their obligations in the Work Health and Safety Act?
Well, I haven't asked them. They will obviously...
But you, as your own agency?
In my own agency, I have looked at the controls. I considered that they're reasonably practicable to support our safe attendance.
Okay. And I think this will be a question really for the next agency, but I'm somewhat surprised that Safe Work Australia has made a decision not to attend when, in effect, it does the consultation to set these regulations that agencies such as yourself and others are supposed to uphold. And I'm somewhat bemused that they've come to a decision that they did not consider, that they had enough time to assure themselves that this was a safe workplace. And I worry that they're supposed to be, if you like, the role models for everybody else, in the same way that Comcare is an agency that does that, because they are the ones that in effect have consulted to set these guidelines. Is that something that you've also reflected on?
So I think that as you say, Senator, they're questions for Safe Work Australia.
Okay.
But there are, in the Act, there are various sections that talk about joint duties and a requirement for PCBUs to consult, cooperate, coordinate. There are instances where there are shared duties. And
okay, but in essence, each PCBU, which stands for
person conducting a business or undertaking, you might be able to use employer as a rough proxy for that.
In effect, each employer noting that sometimes there are interagency obligations or individual obligations, essentially they have the same obligations to assure themselves of the safety of their employees attending.
And they've been doing that all the way through the pandemic. They've
Yes,
been doing that.
they have. And Safe Work Australia is the agency that's supposed to provide that framework and guidance, and I still don't understand why you're all here and I'm here and they're not. Okay, I probably guess I'm at my limits of asking those questions to Comcare, but I'm glad you've been able to assure yourself of that due diligence. I understand Comcare has a new guide to the assessment of the degree of permanent impairment, edition 3 for workplace injuries and illnesses for those workers captured under the Safety, Rehabilitation and Compensation Act. That's right, isn't it?
Senator, we have a current permanent impairment guide that is sunsetting. So
Yes.
we are required, as you would understand, to undertake a review of that, and we have had a. I'll get one of my colleagues. He was.
Okay, but is it on you? It's sunsetting. Is it on track to meet the rewrite of it, or the review is on track to come out the other side in time for that sunsetting?
So we have been out for consultation, and there has been some issues raised with us, and so we have asked for an extension for us to be able to do that consultation appropriately, and then we will progress with that new instrument.
Okay, so do those issues raised include concerns regarding the increase to the threshold for compensation for injured workers?
I'm going to ask my colleague, Mr. Dukin, who's on the screen. He told me he could get in, so I'm hoping he's there. He can explain that to you.
Thank you, Senator. Michael Duke from General Manager of Scheme Management. Just checking you can hear me?
Yes, thank you.
Yeah, thanks. Yeah, so Senator, we were out for consultation in relation to a draft guide, and I'd stress it was a draft guide. In relation to the threshold, which is I take that to minimum amount required to reach a permanent impairment amount. Under the current arrangements, that's 10%, and the proposal was to maintain that at 10%. There's no change to that.
Okay, so where has there been, and where are the changes in the draft, please?
So the draft guide, Senator, what we were proposing to do and was to adopt Safe Work Australia's national template guide, which has gone through a process in about 2014-15, which involved employers, employees and other stakeholders. As much as we could, we looked to adopt that guide, noting there are some restrictions. We can't adopt it fully, so we needed to make some reasonable adjustments to that.
Perhaps I can put the question to you in another way. What areas of the new guide have you received negative feedback about?
So,
can you explain?
Sure.
Can you paraphrase for me, please, the concerns of stakeholders?
Sure, Senator. Just give me 1 second. There were probably 3 main areas that were raised that I would say were areas of concern. I would note that there was quite a lot of feedback that was probably generally in support of what we're proposing to do, but the 3 main areas were just questions around the policy justification for the decision to adopt the SWA National Guide. Concerns about adopting the National Guide may result in fewer claimants being entitled to that permanent impairment, so there are some changes.
Sorry, understanding what you're saying, but if the threshold is still 10%, why will there be fewer people getting to it? And if you could put that in context, because your earlier statement seemed to contradict what you're saying now.
Yes, so Senator, there are numerous tables in the guides that refer to types of injuries. They could be lower body, upper limb, those types of things. There is a method of assessment of how you would assess impairment on those. in 3 of the tables, and there are many tables within the guide, in 3 of the tables we are proposing a different approach to assessment. That different approach aligns to the SWA National Guide, but that is where people are suggesting that there may be, because of the different approach to assessment, some people who may have been entitled to a permanent impairment may not, as a virtue of
Okay,
this.
so what is the
approach to
policy rationale for picking up the SWA assessment? And therefore, what's the policy rationale for the changes overall? Is there a policy rationale behind picking up SWA instead of what's already in here?
Yeah, so the current guide is more than 10 years old, and it adopts, in a large part, adopts the American AMA 5, which is, I'll just get the exact name of that. It's the American Medical Association's Guide for Permanent Impairment. Now, the current guide presently does adopt AMA 5 for most tables, but there are 3 tables where it doesn't. We are proposing on those.
Why do you?
On those 3 tables.
To line them up, yeah.
Why to SWA's National Guide.
Why is the American Guide seen as more relevant, and what's the relationship of that with the SWA?
So it's deemed, it's the guide that obviously SWA through its work did quite a lot of work to determine an appropriate approach to their national guide. It's adopted by 5 other jurisdictions. It's deemed to be relevant to the assessment of permanent impairment in Australian conditions. There are some slight tweaks that have been made to that to accommodate the Australian circumstances.
Okay, so in terms of who put forward the suggestion of using SWA or the American hybrid of it? Was it a board initiative or is it government?
It's Comcare owns the guide, so Comcare is proposing to do it, and that's what Comcare has been consulting on.
Okay, so the board of Comcare asked Comcare to go ahead and do this work and come up with directions.
Yeah, so Comcare, critical to us is ensuring that there is a guide in place, a legislative instrument in place so that permanent impairment can be assessed. Without that, then permanent impairment couldn't be assessed. With the sunsetting, what we looked to do was to adopt what we considered to be better practice and a more modern approach to the assessment of permanent impairment. We deemed that to be the national guide that Safe Work Australia have adopted, and it has been adopted across 5 jurisdictions already.
What has been the reaction of stakeholders, particularly in terms of concerns that should the guide be implemented, some injured workers will no longer have an entitlement to claim lump sum compensation for permanent impairment?
So, Senator, whether an individual would reach that permanent impairment threshold really depends on the individual's circumstances. I think in our view, our review of the analysis of our data would indicate that generally we feel that employees would still meet those thresholds, but obviously it depends on the individual circumstances. There's more work for us to do in terms of consulting with all the stakeholders to flesh out their concerns as to why they feel, that people may not meet those requirements.
Well, have you done your own assessment?
For an extra 12 months.
Thank you. They are changing. Have you done your own assessment according to whether, you wouldn't change it if it was just going to get the same outcome. You must have done your own assessment about who is likely to get pushed out or get pushed in for different types of compensation, including lump sum payments.
Yeah, so we have done some assessment, and we will be doing some more assessment because, based on the feedback, we're now exploring a few different options that are available, we would, and we'd seek, I think, an actuarial assessment of some of those things. But in broad terms, our assessment is that, as I said, we feel that those who are currently reaching that threshold, we believe, would still reach that threshold in most instances. And in some ways, many employees may in fact be better off. There are some advantages to the National Guide approach. In our current guide, you hit increments, so you're assessed at 10% or 15% or 20%. If you had an impairment that might exist between the 10 and the 15, for example, you could only get assessed at the 10, whereas under our proposed approach, if you were assessed at 12%, you would get that 12% as opposed to the 10.
Yes, look, and I understand that, my focus will largely be around ensuring people aren't worse off. You've agreed, in effect, that there are, in some cases, higher thresholds imposed by the American Medical Association's guide to permanent impairment, which in part you're adopting.
So, Senator, I wouldn't say higher thresholds, just a different type of assessment. And in particular, in a large part, the current guide adopts AMA 5 as it currently is. There are only 3 tables, 2 of which our analysis shows are rarely used, maybe less than 5 of instances in a single year.
On what kind of impairments?
So they are upper and lower limb impairments.
So if you crush a hand, then what's that considered?
Well, that would be a severe impairment.
If I lose a finger, what is that?
Yeah. It requires a medical assessment, Senator. I can't say.
Well,
but there is some modelling that is going to happen, that now we know what the concerns are of the stakeholders, and that's why we've asked for additional time as well, Senator, so that we can go through that, work out what are the pluses and minuses, with actually, based on the actuarial assessment and other assessments, whether there are people really impacted by that and the positives as well. So that work is ahead of us. And we are engaging with the stakeholders. I think there's very active engagement with the stakeholders on that.
So you're aware of criticism that the guide adds to the complexity of assessing impairment rather than reducing it? How do you respond to that?
Well, I think I'll give Mr Duke to answer, but one of the things about having the same arrangements as 5 other jurisdictions, it will make it easy for those assessing, for instance. Yeah. But I'll hand over to Mr Duke on that.
I think that's probably enough of an answer, if that's okay. There's been criticism that the guide will lead to a loss of rights for people with psychological injuries by raising the threshold and reducing a worker's rights to claims for compensation. And of course, Comcare knows from its own evidence base that mental stress is the second highest cause for claims. How do you respond to the criticism that Comcare is now trying to ensure injured workers with psychological injuries have less access to compensation for that injury?
So, Senator, as I said before, what we're proposing, and it is a draft, we haven't finalised this yet, but what we were proposing is a different approach to assessment, one that is more modern. The current guide is based off an assessment from, I think it's 20 plus years ago. This is more modern and it's more adaptable to the Australian circumstances, and it's more understood and more known by those who are making the assessment, which are medical practitioners. So I would say that what we're proposing makes a lot of sense in terms of it's a modern, more up-to-date approach than what we currently have in our current guide. Noting though that it's our draft proposal. We are still working with the stakeholders to see what, if any, changes we might need to make to our proposed approach.
Okay. Have you finalised claims for 2019-2020 period? and can it be tabled for the committee?
So you're talking about claims as in workers' compensation claims, or specifically the
Yeah.
impairment element? Because, you know, the claim can have replacement for salary, it can have medical expenses, it can have permanent impairment if someone is, you know, is unfortunately permanently impaired.
Well, I guess there are a couple of elements to it. I wanted also to ask you for disaggregated data for serious impairment and permanent injury and illness claims for the last 5 years, if that's possible. You don't have anything like that with you? I can take, you can take
Mr.
it on
Duke
notice.
may have something, but we certainly will be very willing to take that on notice, Senator.
Okay, and I'll just...
And there's some information too generally on our website as well, just for your info for later.
Okay. I'm interested in to see if you've done modelling of claims under the new guidelines, including the financial impact of the new scheme.
I assume you're still talking about permanent impairment here, Senator.
Well, the impairments that the scheme is designed to cover, yes.
Yep, okay.
The new guide for permanent impairment is supposed to cover. Have you done any modelling?
So we've commenced some work to scope the modelling, because, as I said, what we were waiting on, Senator, was the feedback on the draft proposal so that we could help refine how we would target that modelling. And so that's probably the next step in the exercise, along with the ongoing engagement with stakeholders.
So you haven't modelled it?
That's underway at the moment, based on
Yeah.
now what has been identified as the stakeholders' areas of concern. So
Okay, and is the funding envelope, in terms of the support that people get for permanent impairment under these new guidelines, does it look like it grows?
So CompCare scheme is a cost recovered scheme. It's based on premiums that we charge and so forth. So but in terms of whether it's expected to cost more or not, I think that's something that the modelling will be able to.
Yeah, but you don't know the answer to that yet? Oh, look, I expect it will cost more in that the scheme grows, but I'm interested in the extent to which you're going to make savings from any of these tweaks, and that must be part of the model, surely.
So part of the modelling will go to what the impacts will be from a liability perspective.
Okay, can I ask you to take on notice which parts of the new guide, when you model it, create savings?
Yeah, I know
Thank you. The draft guide uses...
Sorry, I might just quickly check how much longer we would be normally scheduled for a break now, but I'm happy to...
We will come back after a break.
Well, do we want to have a break now then? Is that a break in your questions? We might do that to give everyone a chance. So we will suspend and we'll be back at 4:15. Okay.
No, sorry, I'm still finishing off on these questions about... The current guide is free, yes?
She's on.
Sorry, Senator, what was that?
The current guide is free. The guide uses examples such as unable to read more than X number of news articles, I can no longer make significant repairs to a motor vehicle, and I can't do things like follow a pattern for making clothes, tapestry or knitting. That's the kind of thing the draft guide now says. Is that true?
Sorry, Senator Pratt, perhaps I lost something over the break, but what's the guide that you're talking about?
Yeah, it's the ComCare's draft guide for workers for permanent impairment.
I'm not familiar with that element of it, but I'll ask Mr Duke to if he can cover that.
Sorry, Senator, you didn't have your audio at the start of what you were saying, so could you please repeat?
My apologies. I understand the draft guide uses examples of outdated and gendered demonstrations of daily activities, such as being unable to read more than X number of newspaper articles, make significant repairs to motor vehicles, and this following a pattern for making clothes, tapestry or knitting. Is that correct?
I'd have to take that on notice, Senator. What I'd say is that the current guide, what you're sort of describing references what I believe the current guide touches on. The proposed draft guide references the assessment approaches as I outlined in the AMA 5.
Okay.
And I think, yeah.
If you can just clarify on notice just that evidence is correct and that I'm wrong in saying they are in the draft, that would be fine.
I haven't seen the draft, so forgive my ignorance somewhat. But is your concern that those items are gendered? I mean, I like doing all of those things.
I like doing them too, and
I don't regard any of them as
I
particularly
don't necessarily
gendered.
regard those examples as gendered, but it's been put to me by others that they are.
Right, okay.
I like knitting and
I like fixing
repairing
things and I like
cars.
crafting, and I'm sure there's many
Thank
people
you.
who
So
do too.
let's not. And the current guide is free.
Senator, the current guide, I think the tables that, what you're referring to is the sort of tables that exist within the guide. They are actually within the current legislative instrument, so yes, would be free.
Okay. The new draft guide has a cost attached to it.
The new draft guide, and I believe what you're touching on is some of the feedback that we have received, which is that access to AMA 5 does require it exists behind a paywall, so you'd have to pay to access the exact.
Oh, really? We have a lot of discussion in estimates about the sovereignty of our Australian systems, and here we've got a government department outsourcing something behind a foreign paywall that we'll have to pay to access. Will you rethink that,
that's
please?
the training element, though, isn't it? As opposed to the actual. Is that right, Mick?
So the reference in the draft guide, not the current guide, but the draft guide is proposing to draw on AMA 5. This is something that we've had feedback on. This is something that we're working with our stakeholders through to work out what is the best solution here. That's why I'm sort of stressing that what we've consulted on was very much a first point, and that's what we were. That's why it's draft, and that's why we're consulting on it.
Okay, so can I ask, does the existing references to the AMA guide, do we pay for that because it's in our legislation? You said that it's embedded in the existing system.
So they use the current guide.
No, the current
AMA 5.
references to the current system that draw on the guide, do we have to pay to reference it? Okay.
Because they have used that guide as the basis for development of certain tables.
Okay, when
but they don't
when the
directly
AMA guide changes in America, will our guide also change?
So our guide will, the AMA 5 is, I'll have to take it on notice, but it stands in its entirety as is. When they update, they produce a new version, so it would be AMA 6 or AMA 7. So ours would always reference AMA 5 while the legislative...
That's a quick and easy answer. The $326 that it's been said it will cost to access, is that revenue for Comcare or does it go back to the US?
So
It's not revenue for Comcare, Senator.
And this payment issue is an issue that Safe Work Australia is also looking at into the national guide, so that the one that's used more broadly, and it was agreed by SWA members originally 5 years ago. This payment issue is new, and as Mr Duke has said, we're working our way through how we manage that.
Okay, and medical practitioners and lawyers that need access to the guide, does that mean they would need to pay that $326?
We're working our way through that, Senator.
So the answer is probably yes, unless you change what you've proposed.
I think we need to work our way through that. I'm not sure whether that's a yes or a no.
Okay, but you have proposed a cost and you're working out whether previously there was none, and you're working out whether that will be the permanent position.
That situation in the future.
Have you briefed the Minister on the proposed draft, and has the Minister asked you to keep on track or postpone the process?
So the Minister has been kept advised about this. We have asked her for an extension, which she has granted.
So it's no longer postponed, it is now back up and running again?
I don't think it was ever postponed, Senator. It was
Okay, so
just
it's
it
simply...
sunsets in April, 1st of April or something, and we realised we won't have it finished, and we have asked for an extension, and that has
framed my question poorly, and thank you for correcting it. And you need that extra time because the initial reaction was so negative?
It wasn't so negative, but there were some comments that we really needed to explore and do some modelling, as we've said.
Okay, but if everyone had said this is hunky-dory, you wouldn't have needed to postpone it, would you?
I don't know the answer to that. Maybe we could have done that, but maybe not, because it is an instrument. We have to work through the government. You know, there's an election coming.
There is an election coming. Was it postponed to get past an election?
No, not really. But, you know, obviously when you're working on timing and you need to have this instrument in place to be able to pay people, you can't afford to not have it, you can't afford to have it caught up in anything that would
Okay, so do we need to extend it in the Parliament before sitting stops?
No, I think all that has been approved.
Great. Thank you. Do you want to do voice?
Thanks very much. Sorry. I'm just going to go to Senator Waters, who's online and is pressed for time, if that's okay, sorry, with your indulgence. Then we'll come back to you, Senator Sheldon. No problems at all. Senator Waters, you have the call.
Thank you very much, Chair. Hi, folks. Hopefully you can all hear me okay on the remote connection.
Yes, I can.
Yes, lovely. Thank you. All right. Healthcare has announced that it will hold a forum on the 11th and 12th of November on the prevention, management and regulation of workplace sexual harassment. That's obviously not very long away. Can you run me through who the target audience is and how's it being promoted or advertised, please?
Certainly. I'll ask Ms Beakers to handle that, and she's in Melbourne, so she'll be coming online shortly.
Thank you.
She was there a minute ago. I saw her face. I think she might be N7.
We cannot hear.
Can see someone with that name on the remote participant. Ms Beakers, did you catch that question, or would you like me to repeat it?
Yeah, Ms Beakers, you might be on mute, or we cannot hear you if you are talking. And there is a Ms Beakers on the participants list there. Is there anyone else, Ms Weston, that can help Senator Waters out?
I'm just trying to work out which one of my numbers is the answer to that.
Oh, here we are. Ms Beakers, are you there? We still can't hear you. We still can't hear you.
Oh, what's going on?
There we go.
Excellent.
Okay.
Sorry about that. Oh, technology works when it's good. Thank you, Senator Waters, for your question. I did hear it. I might have missed a little bit. You did talk about the Sexual Harassment National Forum. That is on the 11th and 12th, and you are right, it is coming up very soon. We have been promoting that. You would have seen that Minister Cash did make an announcement around that. What we have been doing is working very closely with states and territories in particular. There is a co-designed communication plan that is underway where individual states and territories as well as the Commonwealth have been promoting publicly using LinkedIn, other social media platforms, but also we are going to be doing some targeted communication to our own jurisdictions as well. So just to run you through the format. Sorry to interrupt. When will that targeted communication to your jurisdiction? Thank you. Yes, so to our jurisdiction, so we have made it available. We have over 8,000 followers on our LinkedIn, for example. We also have a dedicated website page that we have been promoting, and so that has gone out to all of those people. For day two, specific. Sorry. I was just after the date. The date, this week. So we have been promoting as of this week.
Okay. And when, I'm sorry, I didn't see Mr. Cash's announcement. What day was that made, please?
I believe that was made on Monday, but I can take it on notice and we can provide you with a copy as well.
Oh, okay. So it's like less than 2 weeks of promotion. Why such a short period of promotion?
So we've been working.
Planned for?
So we only recently have, as part of the portfolio measure around respect at work, and so obviously COVID, we were planning to do live events. Obviously with the Delta strain, we've been unable to do that, so we did need to pivot the event to be online platform. What's been really important for us is to make sure that we are working with states and territories. So we have been consulting on the agenda. So as you well understand, the issues around workplace sexual harassment are complex, particularly the pathways. So day one is a broad sort of orientation to the myriad of issues that are centred around sexual harassment. So there's a variety of speakers. Safe Work Australia will be there. The Australian Institute of Company Directors will be there. We also have some representation from law enforcement, other commissioners, equal opportunity from South Australia. The program is on our website, it is live, but I can give you a copy of that also. And then day two, we did want a dedicated focus to actually be for inspectors. So this is a closed, day two is closed for inspectors around the country, so work health and safety inspectors, to come together to discuss the issue of workplace regulation around sexual harassment. And so there'll be opportunity for each states and territories to present what it is they're doing, what are the opportunities that they see, what are the challenges they face around regulation, so that we can continue to have that discussion.
Can I ask whether the Respect at Work Council had any involvement in drafting the agenda?
Sue, did you want to answer that? I don't believe so.
Senator, can you repeat that again?
Yes, just whether the Respect at Work Council had it into the setting of the agenda for that forum.
Well, the Respect at Work Council was made aware through our updates to it of how the measures that were announced in the government's response to Respect at Work have been progressing, and so they have had a chance to see that program.
Okay, did they have any input into the making of the agenda?
Well, there are members there are some members of the council who are going to present. For instance, Kate Jenkins, and also just remind me, Nat, of the ACTU. It's not it's Michelle O'Neill. Sorry,
yes,
I do beg your pardon.
Michelle O'Neill, the president. Yes.
Yes, okay, but were they consulted on the agenda or what they thought the agenda should comprise?
We didn't table, Senator Waters, we didn't table the agenda specifically with the Respect at Work Council. We did, however, talk, as Ms Weston has said, to a number of council members to ask them to present. And as you've already highlighted, we are under time pressure and we really did want to do this side, but having to shift quite quickly and move it to a virtual event has been something that we've been cognisant of, as well as actually bringing it to life.
Yes, okay. So sorry, please, the agenda then, just Comcare on its own. Did you consult anybody in the setting of the agenda?
So we did consult with Hausa members, so states and territories, so similar bodies like Comcare, but in the other states and territories around the draft agenda. And so there's a little working group that has been working on that and taking that back to their respective agencies. Obviously, as Ms Weston said, we have spoken to Kate Jenkins as well as invited her to present along with other people as well.
Okay, thank you. Perhaps you could just take on notice who is on the working group, please, and provide that to me on notice. Thank you very much.
Lastly, Senator, sorry, I just missed that question. The question to take on notice?
Who's on that working group that Ms Speaker's just...
Okay, yep.
The officers or the roles that they hold. Thank you. You could also just provide a bit more detail on notice, please, of the time frames. I got a bit confused I understand it's now online, but I'm interested in when the original forum was proposed, albeit in person at that stage. And
so Senator Waters, November has always been planned as the time to have the event.
When was the event decided to happen? As in,
so it was a measure as part of the government's response to the Respected Work report. It was a measure there, so that would be budget timing. So, you know, whenever was it May? Would have been around May, and we've been working to get that forum up and running in the space between May and now.
Okay, and November had always been earmarked as the month which we didn't want to move, Senator Waters, but it was originally planned to be in person, a much bigger event.
Thank you, I understand, appreciate that. In submission to the Jenkins review, Comcast said it was unclear who was responsible for directing MOP staff or holding them accountable for their behaviour, and it noted ambiguity about the influence, control, authority and accountability of the Department of Finance over parliamentary workplaces. You've called for the removal of that ambiguity. What do you propose should be done, and have you had any conversations with relevant ministers about such reform?
Well Senator, I just want to go back to that other matter and just say that Senator Cash and Senator Stoker announced that forum on the 25th of October. So just to give you that extra information there. Just going to what do we propose to do? We obviously made a submission to the Jenkins review, which, as you note, noted some concerns we have about the bringing together of all the elements of the system, and we also, as you would know from other estimates, for Comcare, we are working on the safety system in Parliament House itself, and there's the Jenkins review coming up as well. So, as well as the Foster review already having shone a light on some issues. So one of the things that we're quite cognisant of is the need for, and one of the requirements under the Workplace Health and Safety Act is for there to be consultation, coordination and cooperation with people who share duties. And one of the things that we would like to help with, you know, so far as reasonably practicable, but one of the things that we would like to help with is helping with that coordination of all the elements that contribute to the safety system in Parliament House. Now, there's workplace health and safety duty holders. There's other elements that Foster pointed to, like statements of ministerial expectations, the roles of other parties, and in fact, the first 8 recommendations of Foster's report's 10 recommendations all have elements of safety attached to them. So we think that there is a place for an articulation of all the duty holders, how they all fit together, and making that more transparent for the parties who are participants. Look, there's workplace health and safety management systems in places. It's bringing that all together, and we think there is a role for us to help with that. There's a bit of water under the bridge we've got to do in terms of finalising our report. There's the Jenkins report, and we'll want to see how the responses to the Foster report are being implemented. Those things will all be relevant, but I think there's a good piece of work that we can help with.
Okay, and having discussions with the government about that piece of work?
Well, we just need to finish our own piece of work first. Obviously, we have put our submission into the Jenkins review, and we have been working, for instance, with the Department of Finance on the policies that they are working on. So we are doing steps along the way, but there's a couple of major pieces of work that have got to come together, and we want to loop back on all of that as well.
Okay, what's the time frame for finishing your body of work? And pardon me, but what is the body of work that you're referring to? There's so many moving parts.
So we have an inspection underway examining the safety systems that exist in the parliamentary workplace. We are not too far away from finishing that.
Okay, is there a due date as such?
Well, we have a 2-year jurisdiction, Senator, so no, I don't have a date for you at the moment.
Okay. All right, there are indeed a lot of moving parts. All right, so you say once you finish that body of work, back and essentially use that as your framework to assess how the other parts of the jigsaw could fit together?
So what we want to do is help the duty holders who hold duties in the parliamentary workplace, help to, so, you know, there's a Commonwealth itself as a PC, person conducting business or undertaking, and then there's the parliamentary departments, Department of Finance, and then all the other members and senators and the leadership within that. They're all part of this system, but there's requirements under the Work Health and Safety Act around consultation, coordination, cooperation. And I think that's the part that we think we have, we can help with to identify all those bits.
Okay, thank you. Noting that in the course of the Respect at Work legislation, there was quite substantial debate about the need for a positive duty on employers or person conducting a business, and that the government ultimately did not, well, they voted against my amendment to it was a joint amendment with Labor to have a positive duty, and noting that they've referenced workplace health and safety duty is either adequate or partially covers the field. With that context, I asked the Attorney General's Department last night, are they actually working on progressing a positive duty? And they indicated, I think, that they were. Is CompCare having any involvement with the AG's department on that positive duty body of work?
Obviously, that's for the, you know, that is for the policy department to manage, and we will continue to do our role in terms of the positive duty that employers have to keep workplaces safe under the Workplace Health and Safety Act.
I don't quite understand that, the policy section within CompCare, or?
No, Senator.
I'll ask.
Senator, it's Martin Head, Deputy Secretary, Industrial Relations Group for Attorney General's Department. So the working group within the task force within Attorney General's Department is consulting with my team, where we have a team responsible for work health and safety policy overall. So it's my team that actually deal with the policy, Senator. Of course, we engage routinely with Sue and her team, but we're actually responsible for the policy.
Okay, thank you. Yeah, forgive me, it's been hard to see who's who from the remote connection. I don't have the benefit of name tags, etc. So is that something that CompCare isn't necessarily involved in, but will touch base with them as needed?
So I'm a statutory agency and I have responsibility for regulating workplace health and safety, well, CompCare, under the Commonwealth's version of the model workplace health and safety laws. So that's my job, along with a few other jobs. But the department is responsible for progressing the government's agenda around that, and they will consult with us just for our view. But my main job in this area is to get on with being the for CompCare to regulate under the Commonwealth's version of the model laws. So that's what the legislation tells me I need to do.
Yes. Thank you. I appreciate your jurisdiction. I just assumed that as the relevant expert and regulator that you would be consulted. They will consult us for your view. Has that happened in relation to the work that's underway on the drafting of a positive duty?
Well, yes, we have had conversations, but I'm also a member of the, because I chair the Heads of Workers' Compensation Authorities. I'm part of the council. That role is finishing up for me in November. So, but nonetheless, that issue around the positive duty is raised in that forum as well.
Okay, so when you're wearing a different hat, you've been consulted, but have you been consulted while you're on care hat?
Look,
positive duty that's currently underway.
We have talked about positive duty when we've been developing. Yes, so yes, the answer to that is yes.
Okay, all right, thank you very much. And can I just ask when that consultation occurred and is it ongoing?
Senator, I don't know that I'll have that sort of a record, and it would have been since May, in the period from May till now.
Senator Waters, could I just get an indication of how many
Yes,
more
that's
questions?
my last question,
Easy.
Chair. That's my last one. If I can just ask the witness to take on notice to provide the dates of that consultation, just about the positive, which the government claims it's now working on. Thank you very much. And Chair.
I missed a bit of that.
Yes.
You might want to just repeat that, Senator Waters. I think we missed a word. Could you just repeat that last
Sorry.
question for us? That's okay, just the
Yes,
connection.
Just asking the witness to take on notice the details of the dates of the consultation that she says might have occurred since May, relating to the government's work on now potentially drafting a positive duty, which they...
Senator, that largely my engagement would have been around my positive duty in relation to the Workplace Health and Safety Act. So it wouldn't have been progressing the government's...
That's not what I'm talking about. Yeah, I'm talking about the government claims they're now working on a positive duty under the Respect at Work Bill, as opposed to under the Workplace Health and Safety laws. And I'm interested in whether they've consulted with on that new work. That's what I thought.
So I've misunderstood you there.
So, Senator, we've had broad conversations with Comcare. I'm happy to take on note when we've had discussions. But our primary focus in the discussions with Comcare has been in addressing parts of the Respect at Work report, and indeed that's why the conferences on the 11th and 12th of November are so important, is to address one of the significant criticisms within the Respect at Work report, that the work health and safety jurisdictions aren't doing enough to enforce the positive duty. So that's been the primary area of focus in our discussions with Comcare at this point. As options are developed and looked at, we will consult with Comcare to discuss any issues or concerns. One of the key things that, of course, we'll be looking at is whether the duplication or the potential duplication would cause an issue or not. So in relation to those aspects, we're more likely to be talking to the head of Comcare. As Ms Weston referred to, in terms of the broader policy, we're more likely to engage with the council.
Okay, so has any of that consultation occurred already with Comcare?
Sorry, Senator, the discussion with Comcare to date, as I just said, what has predominantly been about trying to improve work health and safety regulators, already existing requirement to enforce a positive duty.
And the only other thing, Senator, would be that as a member of the council, I did hear an update on that particular recommendation, but I wasn't consulted per se, and so I apologise. I didn't really hear you properly, and I should have asked you.
It's hard with the remote connection. The audio is terrible. Yes. Thanks for your time. Thank you, Chair.
Thank you, Senator Waters. I think we're going back to Senator Sheldon. Thank you, Senator Sheldon.
Good, thanks very much, and welcome Senator Stoker and Ms Weston.
Thank you.
Good to see you and your team.
Thank you.
I just want to get, you may recall questions that were asked on previous occasion, and it's related just to refresh your memory. In the Australian on the 23rd of March 2021, it's quoted as saying, Fair Work Commission Deputy President Gerard Boyce has been referred to the New South Wales Police for setting off firecrackers during a post-Christmas party staff gathering on the Tribunal's office balcony in Sydney. The Australian revealed that the Fair Work General Manager, Bernadette O'Neill, had referred Mr Boyce's conduct to the New South Wales Police after he let off 2 throwdown firecrackers at a staff get-together in December. Under the New South Wales law, of course, it is illegal to buy, possess or discharge fireworks unless a person has a single-use licence or holds pyrotechnician's licence. And subsequently, Ms O'Neill has also referred Mr Boyce's conduct to Comcare, the National Authority for Work, Health and Safety. And we did ask some questions at the last hearing about Mr Boyce, and it's now 255 days since that, and I'm just going to ask you, has Comcare concluded its investigation into the actions of Fair Work Commissioner Gerard Boyce?
Yes, Senator. Comcare has recently completed an inspection in relation to that incident earlier in the year at the Fair Work Commission's offices in Sydney.
Right, thank you. What are the findings of your investigation?
So, as you know, Comcare's role is to assess whether or not duty holders have complied with their duties under the Work Health and Safety Act. In this inspection, Comcare didn't find evidence to a criminal standard of contravention of the Workplace Health and Safety Act.
Did you interview Mr Boyce as part of the investigation?
I believe that is the case, yes.
Did you interview, how many people did you interview?
I think there might have been, I'm thinking 8.
Was there any overlap or cooperation with the New South Wales Police as part of your investigation?
So the New South Wales Police did contact Comcare in relation to the incident.
So their evidence was shared with you, or was it considered?
So I think they asked us for information, but I'll take that on notice for you, Senator, to be accurate. But I don't have an update on the current status of any work they may be doing, and probably need to be asked to them.
Thank you. We've got no further questions on the subject.
Okay. Any other senators with questions? If not, thank you, Ms Weston, and thank you all the officials from Comcare. You are free to go. And so now we will move to officials from Safe Work Australia. I believe they are appearing remotely. So we'll just pause here while they come online. Okay, we've got Ms Baxter there, and Ms Smith, and a couple of officials. Ms Baxter, is that everybody from your organisation? I think you're on mute, Ms Baxter. Sorry, Ms Baxter, we can't hear you. I think you might... No, still not. Do we need... Oh, you won't be able to answer. We might just have to suspend then while we sort this out. So we'll just suspend the committee and we'll see if we can get a connection with Safe Work Australia.
Apologies.
No problems at all, Ms Baxter. We are all very schooled in these difficulties over the past 18 months. I believe we have recommenced, and so I do welcome officials from Safe Work Australia. Ms Baxter, did you have an opening statement?
Yes, Chair, I have a brief opening statement. Thank you.
You have the call.
Yes, Michelle Baxter, CEO, Safe Work Australia. Thank you, Chair. I welcome the opportunity to clarify the circumstances of the agency appearing remotely today. First, let me be very clear that I never suggested that Safe Work Australia would not be appearing today at Senate estimates. As is always the case, my staff and I take our obligations to appear before Senate estimates very seriously. We would always cooperate with the committee and any of its requests. Second, let me also be very clear that I never decided that Safe Work Australia would not appear in person today at Senate estimates. Rather, I was advised this morning that the committee had made a decision that we could appear remotely today, and I thank the committee very much for taking that decision. Third, I have never made any assessment, communicated concerns, or reached a view that the hearings today are unsafe. As the CEO of the National WHS Policy Agency, it would not be appropriate for me to do so, and I am not in a position to make such an assessment. Rather, I, as an officer of the Commonwealth under the Work Health and Safety Act, sought additional information to assess whether all reasonably practicable measures had been taken to manage the risks of COVID-19 during the hearings. I also sought clarification about the consultation process that had occurred. The relevant parliamentary departments were very helpful in providing us with advice on the control measures that were being taken in relation to Parliament House for COVID-19. In particular, we understood that its view was that, consistent with the position broadly in the ACT, People should continue to work from home if possible, and Senate estimate witnesses should be kept to a minimum. However, we were subsequently advised that the committee required us to attend the hearings in person. As the CEO of the National Policy Agency responsible for work health and safety, I wanted to better understand the reasoning for this decision in the context of the other control measures being taken, so that I could assure myself and my staff that all reasonably practicable control measures were being taken in accordance with the Work Health and Safety Act. As you would be aware, the Commonwealth, as the person conducting the business or undertaking, owes positive duties under the Work Health and Safety Act to ensure, as far as reasonably practicable, the health and safety of their workers whilst at work. There is also a positive duty on officers in each agency to exercise due diligence to ensure their agency complies with its WHS duties. I and my executive team are officers under the Work Health and Safety Act. Further, when multiple duty holders owe duties in relation to the same matter, the WHS Act sets out how those duty holders are to work together in relation to these duties. Section 46 imposes a duty on all duty holders to, as far as reasonably practicable, consult, cooperate and coordinate activities with other duty holders who have a duty for the same matter. So Safe Work Australia must consult, cooperate and coordinate its activities relating to the health and safety of its officials appearing before estimates with the parliamentary departments. This is simply what I was seeking to do. Be assured, SWA has provided very clear guidance on the duties of PCBUs in relation to COVID-19. We have guidance for all industries, including for those in office-based work. We do not have specific guidance for Parliament House as a workplace, as it would of course not be tenable for us to provide specific guidance for all workplaces in Australia. However, the guidance for office-based work would be relevant to Parliament House as it is to our own agency. At present, SWA's control measures include continuing working from home where possible, not undertaking travel and not attending other work sites. We are currently consulting our staff about whether additional control measures are required, given that community transmission of the virus is ongoing in the ACT. Given our approach to work health and safety control measures and that a number of my executive team are vulnerable, including myself, I simply wanted to understand the approach taken by the committee so that I could assure myself that I had properly discharged my duties under the Work Health and Safety Act. When raising this matter with the committee, I had a feeling this could become contentious, and I'm sorry for that, and that some may consider it would have been expedient for me to just require SWA's officials to appear in person. However, my team and I understand our duties and take them very seriously. I consider that it is important that we satisfy ourselves that we are acting in accordance with the Work Health and Safety Act. Again, I thank the committee for allowing us to raise this matter, for taking it seriously and advising us that we could appear remotely. Thank you.
Well, thank you, Ms Baxter, and thank you for that comprehensive explanation. I do have a request from a senator. Is there any possibility we could table that? I presume that would require you to email it to the Secretariat. Is that possible, Ms Baxter? So could
yes,
anyone, I think, yes, someone can do that for us. So thank you, if you could do that. And look, and I also thank you for your cooperative conversation last evening, and I want to stress that we do want to see a situation where officials do come physically into the Senate. It does help the scrutiny process, which is an essential part of our democracy. And so while we were willing, with this late notice and time, to have you appear remotely today, wanted to stress that that will not be a long-term precedent. We will work together, obviously, ahead of the next estimates to make sure we can all see each other face to face. And now to questions. Senator Pratt, over to you.
Ms Baxter, thank you very much for your explanation of the procedures in relation to the COVID safe practices here at Parliament House and your positive duty to assess whether in fact this is a safe workplace. Have you had, just first of all agencies have the same positive duty that you do, is that correct?
Yes, Senator, that's correct. Could I just correct something you've said?
Yes, please.
I'm not assessing. It's not my role or my duty under work health and safety legislation to assess whether Parliament House is a safe workplace. My duty is in relation to ensuring the health and safety of my workers and others, and ensuring that all reasonably practicable control measures have been put in place.
Thank you. Is Parliament House a safe place for your staff to attend in the context of estimates or not? I accept that we didn't have time to resolve this issue before the hearing, and I'm quite comfortable with you appearing remotely. My question really is around whether you assessed it to be safe to attend, or whether you still felt you required further consultation to make that conclusion.
So, Senator, as I said in my opening statement, I have not made any such assessment about whether Parliament House is a safe workplace in relation to Senate estimates.
Yeah.
I was
So what would you
seeking
have done
further
if
information.
we... I'm just somewhat confused. If we had required you to attend, because you said that it was in the committee's hands and we let you appear remotely, if we had said we would prefer you to attend, would you have had to conclude that assessment, or what would you have done?
I would have still persevered in trying to obtain the information that I still don't have. Two main questions in my mind.
Yeah.
There are a number, but two main questions. I consider that it would be a reasonably practicable control measure to apply to appear remotely for estimates in a work health and safety context. I have been seeking to explore why the committee holds the view that that is not a reasonably practicable control measure to apply. I still don't understand the reasoning. Perhaps my reasoning, if I had further information, perhaps I would arrive at a different position in terms of my initial view.
Well,
the other significant issue is in relation to a question that I have asked, which is, will the witnesses appearing at the witness table be 1.5 metres apart? And that is, will there be appropriate, adequate physical distancing?
And you didn't get an answer to that?
And I have not had a response. No.
Do you consider that all the other PCBUs or all of the other employers that have allowed their staff to come to Parliament for estimates have the same duty to acquit as you? Should they be, you are, if you like, the role model for answering these questions. Should they, I guess I'm somewhat confused, Ms Baxter, as to why all the other agencies are here, assuming they have also acquitted themselves of these same obligations under the Safe Work Act.
Senator, I think you would need to ask those other departments and agencies. As was stressed this morning, and I believe again this afternoon when Comcare appeared, it is up to each individual officer of the PCBU to discharge their duty under the work health and safety laws. It's not a one-size-fits-all approach. There may be different issues, different risk concerns. The profile of the staff who might attend estimates may be very different, vastly different, between different agencies and departments. So it is necessarily a case-by-case basis.
Okay, and I can understand there might be individuals that can't attend, and we were very clear as a whole, across the whole of estimates, that if people had a reason not to come in terms of being vulnerable themselves or having someone very close to them being vulnerable, that would be an acceptable reason not to attend. But I'm still somewhat... But is it the overall chain of transmission, should COVID be here, that you're worried about?
Senator, I think my main consideration is having regard to the Work Health and Safety Act, where my first duty is to eliminate the risk. And if I can't eliminate, it's to minimise or mitigate the risk as far as reasonably practicable. From my perspective, the approach that I took was, by my officers and myself appearing remotely, we are eliminating the risk of coming into contact possibly with any COVID situation that may be in Parliament House.
Thank you. I can understand that, but I'm somewhat bemused by the double standard that you have the same obligation as every other employer, and that, if you like, yes, it's your job to role model these things, but I'm just very perplexed that other agencies haven't come to the same conclusion, and that I'm here and that everyone else is here.
Senator Pratt, I'd suggest that rather than a double standard, what we're dealing with is different judgment.
Yes, I can understand. And why should the Safe Work Agency Authority have a different judgment than the judgments made by all other agencies?
Senator, as Ms Baxter's outlined, the work health and safety legislation puts the responsibility on the individual PCBUs, and those PCBUs actually have to look at the individual circumstances of their staff. So,
if this was any other agency other than Safe Work Australia, frankly, I would understand that, but it just seems to me that there may be some exceptional circumstances in terms of particular profiles of vulnerability. I can accept that, but what I don't see is, given the inquiries that Ms Baxter made of the Parliament, I'm not assured, frankly, that every other agency made similar types of inquiries of their staff as to their potential vulnerabilities, or of the Parliament as to how those would be resolved. And so I'm really more interested in the complexity of how we manage COVID in Parliament, so that we can all be assured that we have a safe workplace.
I understand
I'd take that as a comment.
Okay, I just wanted to ask
moving on?
very...
You're moving on, Senator Pratt?
Yes, I just wanted to...
Well, can I, before you, are you moving on or same topic?
Well, I just wanted to briefly highlight that we do have technical issues crop up, as we did at the beginning of this hearing, and if you have multiple episodes of those with different agencies, it's not uncommon for half the day
Absolutely.
to be gone, which is one of the reasons to have a preference for...
I simply wanted to somewhat repeat what I said earlier, Ms Baxter, and just pick up upon some of the answers of your answers to Senator Pratt's questions. I think you mentioned you weren't clear yet on the reasoning of requiring physical attendance and the need for that. Obviously, we can communicate that in more detail before next estimates, but there is that strong resolve, I know, from committee members and talking to other senators, that remote participation does not provide the same degree of scrutiny for the Parliament. We're all human beings, and this is an important process in our democracy. We obviously have to do it in a way that is safe. We believe we have achieved that through the Department of the Senate, but we'll be obviously having more conversations before next estimates to resolve any other questions or issues you have. Thank you, Ms Baxter. Were you going to continue, Senator Pratt?
Well, I was just going to advise, I would, like other people here, would be concerned if Safe Work Australia had a view about this Parliament being unsafe for its own staff to attend, if that was your ultimate conclusion, if all of us are here.
Senator, as I said, sorry, beg pardon.
No, that's fine. You didn't have a chance to conclude your inquiries as to whether you consider this place safe for staff to attend.
That's right. I have made no final assessment.
Nevertheless, you've got the same obligation as the Parliament and all the other officers to assure their staff that have attended Parliament that it is a safe workplace. I'm happy to move on.
Just a follow-up question. Ms Baxter, thanks for joining us, and thanks for giving direct answers. you're saying that with the investigation, when do you expect that to be completed about the safe work recommendations for the Parliament?
Well, I think it's redundant because we let them off the hook.
Well, COVID's still going to be here.
Senator, sorry, we're not conducting an investigation. That's not the role of Safe Work Australia.
I think, Senator Sheldon, they no longer have to conclude their assessment as to whether it's safe for their staff to attend because we didn't require them to attend.
There is still some ongoing correspondence, I believe, between the Secretariat and Safe Work Australia, some questions that had not yet been answered because there was a lot of back and forth. So that's why in this case, with the limited time we have, we've allowed the remote participation so we can continue. That was in part to ensure we didn't disrupt our hearings. I would just note we have now spent 20 minutes on this topic, so it might be time to perhaps move on, and we'll hopefully see Ms Baxter next time.
Thank you. Can I just ask some questions in relation to silica and silicosis? There's been an increase in cases and other dust diseases. We've had some discussion this in the past, but do you consider this is a problem not just for stonemasons, but all workers, including but not limited to workers in construction, hard rock, metalliferous mining, quarrying, abrasive blasting, concrete and concrete product manufacturing?
Senator, there certainly does seem to be a body of emerging evidence, and there has been for some time, that the issue in relation to respirable crystalline silica and silicosis and accelerated silicosis is not confined only to the engineered stone benchtop industry, yes.
And so are you collecting, what data are you collecting to supplement workers' compensation data?
Senator, we're not collecting any data to supplement workers' compensation data.
Okay, well, what data are you collecting to demonstrate that there are risks then?
So, Senator, we're actually commencing a regulatory impact assessment process, and it will be very broad and consider industries such as quarrying, tunnelling and mining, as well as engineered stone, the engineered stone section. That process will itself seek to obtain any relevant data that may be available, either through states and territories themselves or through other databases, such as databases that the Australian Institute of Health and Welfare can interrogate. So that will be part of that assessment process. Part of the evidence gathering process to determine what the problem is and what is the extent of the problem.
Okay, so that would include jurisdictions such as Victoria and Queensland's Health Surveillance Program, New South Wales iCare Dust Diseases Report, those kinds of things. Have you recommended to the Department of the Attorney General's Department in relation to adopting particular learnings from those jurisdictions? Less than half of the cases identified in those reports, for example, demonstrate that those cases of silicosis come from only manufactured stone.
So, Senator, we've been progressing a whole body of work in Safe Work Australia in relation to occupational respiratory diseases. I think I spoke last time I was here at estimates in terms of the work that we are doing. Let me see, we've reduced the workplace exposure standard for respirable crystalline silica and respirable coal dust. We're publishing national guidance on working with silica-containing products. I believe we have today, and I'll pass to Dr. Newton, who can provide more detail of the activities that we've been conducting and the work that we've been doing with our Safe Work Australia members.
Thanks. Rebecca Newton, Branch Manager, Chemicals, Occupational Hygiene and High Risk Work Policy. So we've got quite a comprehensive program of work that Safe Work Australia members have agreed for occupational lung diseases, including silicosis. And just yesterday we published the Model Code of Practice managing the risks of respirable crystalline silica from engineered stone in the workplace. That's following Majority Minister's agreement to publish that. And together we've got a communication strategy to raise awareness of that code. So that's there to assist those in the engineered stone industry to understand how they need to comply with their duties under the WHS model laws. As Ms Baxter also mentioned, members have also agreed to the regulatory impact analysis to consider regulatory and non-regulatory options for managing the risks of respirable crystalline silica, and work on this is progressing. The options to be considered will cover a broad range of silica-containing materials and industries, and in accordance with the National Dust Disease Task Force report, this analysis will also consider a licensing scheme for PCBUs working with engineered stone. More broadly, for occupational lung diseases, in June this year, the agency commenced a national education and awareness campaign for occupational lung diseases, the Clean Air, Clear Lungs campaign, which was aimed at micro, small and medium-sized businesses, particularly in construction, agriculture, manufacturing and engineered stone industries. The first phase of the campaign was to raise awareness that there are hazards in the workplace that do affect the lungs. The second phase focusing on those control measures, and that's actually started this month.
Thank you. I wanted to drill down into, I can see the education happening. I wanted to look at the work that you're doing in relation to other international standards. I see that the UK requires continuous dust and diesel particulate matter monitoring and real-time monitoring of DPMs. Is this something you will also do?
Senator, we've actually just recently commissioned some consultants to undertake work for us at the request of our members to investigate setting a workplace exposure standard for diesel engine emissions.
Okay, and if it were a standard, it would be a regulated standard that would require monitoring?
So under Regulation 49, it would be an exposure standard that would not be able to be exceeded. Under Regulation 50, those health monitoring requirements would apply, but there are stipulations there about the level of risk that would need to be determined by the PCBU to ascertain whether health monitoring is required.
Okay, how long do you expect that work to take? If the UK's already done it, sure, and we know that these risks are ongoing in workplaces, is there not some urgency to this?
The work is underway and we expect we're having fortnightly meetings with our consultants and determining their progress, and we hope to have a recommendation from them soon to take back to our members.
It's been said to me that where there are laws that cover this from jurisdiction to jurisdiction, they're either not enforced, they're often not enforced. Would you agree that that's the case?
Senator, we don't have any oversight of that.
Of whether they're enforced or not? Okay.
No, that's a matter for each state and territory and the Commonwealth.
Has there been any progress on the development of a national regulation applying to every affected industry with minimum benchmarks that can be policed and enforced?
Senator, that would be the subject of our regulatory impact analysis. We will be looking at what would be appropriate for different products or different industries.
So you said that would be. I'm asking specifically what progress you've made in relation to that. So where does that sit now?
For silica?
Yes.
Sorry. Yeah. So the regulatory. So we're in the process of negotiating contract with a preferred supplier for that regulatory impact analysis. And obviously, as part of that analysis, there'll be a consultation process.
Okay. So the regulatory impact analysis is one thing, but but you've already satisfied yourself that the health urgency is there. The regulatory impact is one thing. I'm asking about all of the other work that means benchmarks, and so that the health effects are taken account of first. Perhaps you don't understand. I do understand the way I've asked the question is confusing. Of course, regulations have impacts, but you could still have a very high impact but still need the regulation because it's workers' lives at risk.
So we have actually also initiated some other work in this space. So, for example, we have already commenced drafting instructions for a specific regulation to prohibit the uncontrolled processing of engineered stone, because that is one of the highest risk industries that we're aware of. Yes.
Thank you. Have you got a screening? Have you done any work with the Department of Health or the AGD regarding a national screening program for current and former workers that might help diagnose silicosis and other dust diseases before they become advanced?
So currently the health screening programs that are being undertaken are at the jurisdictional level. In some cases it's within the work health and safety portfolios and in others in the health portfolios, but it's not something that at this stage is being undertaken, as far as I'm aware, by the Department of Health or the Attorney General's Department.
Okay.
Senator Amanda Johnston. Sorry, Senator. Just Deputy CEO. Just to be clear, health screening isn't actually something that's within the remit of the work health and safety laws. So it's not something that we would actually have any carriage of, and particularly in relation to former workers, we have no remit.
Yeah, no, I understand that, but you've helped identify the problem as an agency, and I want to know so I can go ask the questions of the other agencies to make sure that there is something in place in the future for that screening program to be in place. Do you have a view about what should be done? Where are these people? Who are they likely to be? How do we find them? Surely in putting a screening program together, we would be drawing on your expertise as an agency anyway. You know where
Senator,
the exposures have
I think
been.
health screening is a recommendation of the Dust Disease Task Force, and it's something that's being handled by the Department of Health, so that might be a question better addressed to them.
Has the Department of Health asked your advice on or for your expertise in this regard as yet?
In relation to health screening programs?
Yes.
No, sorry, Senator, I wouldn't say we have particular expertise in relation to that, given that it's not within our remit.
No, I'm simply, you know where these exposures occur, don't you? You would know where to find the workers who might have had an exposure. I'm just surprised that if they're going to outreach, the department needs to know which industries, which circumstances might have been unsafe, all of those kinds of things, so that they know who to target.
So we're hoping, as a part of the regulatory impact assessment process, that better evidence, we understand better the evidence of where these things occur. But no, we don't generally have all the evidence relating to exposures in industries, because we only collect the workers' compensation data, and as we all know, that's limited. So notifiable incidents, for example, they're notified to the regulators, not to us, and we don't have any oversight in relation to those matters. So while we are very well aware of the risks of working with silica, we aren't expert on where all the exposures occur, the incidence of exposures, the likelihood of developing accelerated silicosis, etc., etc.
Will there be a government response to the National Dust Diseases Task Force, given that it recommends action by the end of this year, including a prevention plan, that exposures to silica at work, sorry, I've wrongly phrased that, sorry, you won't. So I'll just start with the question about the response to the task force.
Senator, whether there's a... Oh, sorry, I'll let Mr Hare talk.
The responsibility for responding to the report rests with Minister Hunt as the Minister for Health. The report was actually undertaken by the Department of Health through a reference group process. So Minister Hunt is consulting with Minister Cash on the matter, and I understand that a response is imminent. They've also provided the report to jurisdictions.
Yeah.
Because it's, as you're aware, work health and safety in particular the enforcement side and often the health screening side, is actually a jurisdictional matter, so it's important we get feedback from the jurisdictions as part of that.
Okay, so my concluding questions in that case will be around the consultation that's occurred with industry and worker representatives regarding recommendations 3 and 7 of the national plan, which one is in relation to the strategy, education, early detection and response with a view to preventing risk and exposure, and then the other one is the cross-jurisdictional governance. I'm not, is Safe Work or AGDs doing that work?
So where, as I said, the report's been provided to the jurisdiction, so I'd need to take on notice the level of progress. I'm not quite sure of how many jurisdictions have responded to any of the recommendations. In relation to the consultation with the workforce
and industry,
I'd need to check and see who was actually on the reference group, on the task force, sorry. I can't remember whether there was, I think there was industry and union representation, but I need to take that on notice.
Okay, if you can take that on notice.
Yep.
And Ms Baxter, do you have any comment? I gather that that's a job for AGD to finalise and not for Safe Work Australia in terms of those recommendations, or is that something that Safe Work Australia is also involved in?
No, Senator. The Department of Health and the Attorney General's Department are working on those.
Okay. And is there any progress on a national register for cases of dust, all cases of dust disease?
Senator, that question would be should be directed to the Department of Health. They have carriage of that matter.
Okay, but have you given them any advice regarding that, or regarding a compensation fund for workers exposed to silica dust?
So I might just point out that Safe Work Australia don't deal with workers' compensation as such.
No, I understand that. I asked simply if they'd provided any advice to the Department of Health or AGD. They understand
I don't
the
believe
risk.
so, Senator.
Okay, thank you. Thank you, Chair. I think Senator Sheldon's got some questions on a new topic.
Okay, Senator Sheldon.
Good, thanks very much, Chair. Just want to go to some questions regarding Safe Work and its overview of key threats during COVID transmissions. I'm just wondering, is exposure to COVID-19 transmissions a key workplace risk, particularly for people who work in highly exposed sectors like international aviation?
Senator, it's a risk, it's a workplace risk. I guess depending on the workplace, it might be a higher or lower risk, and depending on your susceptibility to, I guess, severe ill health should you contract COVID-19, but definitely it's a serious risk for health workplaces currently.
And in international aviation, you would consider as potentially one of the highly risk areas?
Senator, given the coverage of the other regulator in national aviation, we're not experts in that field. We don't provide guidance on aviation, so I don't think it's something that we can particularly speak to.
I think I've got some other questions here on a similar line, but slightly different, which you may be able to help me with. What role do health and safety representatives play under the model WHS law, and how important is their work to creating a safe work environment?
Senator, there are different obligations and rights in relation to health and safety representatives under the work health and safety laws. An important one of those is the right to be consulted in relation to work health and safety risks and the control measures that will be implemented in a workplace in relation to those risks. So it is definitely a feature of the work health and safety system.
And to stop work in areas that are potentially life-threatening. Is that It
That's
ultimately.
also another, there is a possibility to stop work if you fear that, if you have a reasonable belief that there's an imminent risk to your health and safety. That is also another right under the work health and safety laws.
Thank you. I just want to then just go to next question. Section 104 of the model WHS laws prohibit discriminatory conduct, as you've, I gather that's the section that you're broadly referring to. And for example, dismissing or terminating a worker because they were exercise their role as a health and safety rep. And I just want to go to this question. If someone was dismissed for exercising their role as a health and safety rep, is that a very serious charge?
Sorry, Senator, would you mind repeating the question?
Yeah, thank you.
Just
Section
hoping
10,
to hand
Section
you the
10,
document.
as I understand it, Section 104 of the model workplace health and safety laws prohibit discriminatory conduct for a prohibited reason. For example, dismissing or terminating a worker because they exercise their role as a health and safety representative. Is that a very serious charge?
Senator, the maximum penalties for an individual is $100,000 and in the case of a body corporate it's $500,000. So yes, it is a reasonably serious offence.
And why is it important that health and safety representatives are protected from this sort of retaliatory action?
Senator, I guess that's a question of policy, but so that work health and safety is protected in workplaces, that people are assured that they can raise work health and safety concerns and that they won't have retaliatory conduct against them if they do so. So it's to, I guess, to make sure there's a check and balance and that you can ensure health and safety in the workplace.
Thank you very much. Is it very common to see state work regulators file charges against companies for a breach of Section 104?
Again,
Senator, that's not something that I'm able to answer. I don't have any oversight or notice of when such action is taken. It's something we could take on notice, but I'm not sure whether it's something we'd be able to provide an answer to.
Mr. here, can you inform us on whether there's it's common to see state safe work regulators to file charges against companies for a breach of Section 104?
I'd need to take that on notice, Senator. As I've said before, the states and territories each have their own work health and safety regulators. We could certainly write to them and ask. Happy to do that.
Thank you. And are you aware that if any of the regulators, so you're not aware of any cases and you're taking it on notice?
I'm not personally aware. I'll take that on notice.
And nobody here would be aware of it? Is that...
No, I need to take it on notice.
Safe work regulators, as I understand it, would not pursue court action under Section 104. It is extremely rare, and I think the rareness of it is demonstrated by the, I appreciate you taking it on notice, but demonstrated by the fact that you aren't able to drop any particular case in my lap. Safe Work New South Wales recently filed charges against Qantas for dismissing a health and safety representative after he raised concerns about cabin cleaners being directed to clean planes arriving from China at the beginning of the pandemic without PPE and nothing more than spray bottles of water. Are those the sort of allegations very serious?
Senator, I think the fact that WorkSafe New South Wales have sought to press charges, it would indicate that on their view of the facts in front of them, they believe this is a serious matter.
Thank you, Mr. Hare. Do safe work regulators typically jump straight into filing charges in court, or do they get, at that stage, does safe work need to be fairly confident and satisfied that there would be been a serious breach?
Senator, I can't talk to the individual jurisdiction. Certainly most jurisdictions require their regulators to behave as model litigators. So yes, they would need to be confident they would do that. In general, I can't comment on New South Wales specifically, but I'm also aware that the regulatory agencies often work in a spirit of cooperation and education in terms of trying to make sure that work health and safety matters are addressed.
Thank you. Are you familiar with any other major companies being charged or even accused of such reckless COVID-19 safety practices?
As I said, Senator, I'll need to take that on notice.
So, I mean, if it was a sort of a regular thing, obviously it would be something quite in the forefront of your mind.
Look, recognising that we're not a regulator and that we're one jurisdiction in relation to the model work health and safety laws, but it hasn't been raised with me, Senator.
Back to safe work. When it comes to breaches of the workers' health safety laws by companies, can individuals, particularly executive managers, be liable for breaches that happen under their watch?
Yes, Senator, that's the officer duty that we were speaking to earlier. So officers have a positive duty.
Thank you.
Can be, sorry.
No, by all means, you continue.
I was to say, and there are serious penalties for officers, which can include being imprisoned.
Can people like Alan Joyce be held responsible potentially for establishing a culture of recklessness and fear when it comes to workers' health and safety?
Senator, that would require speculation. What I would say is that the Act does enable for officers, and as a CEO you can be an officer, so the Act does enable charges to be made against officers.
Mr. Here, so that's senior executive of an airline, CEO, could potentially be.
Well, it would depend on
the
facts of the circumstances and how much individual control, etc. he had. So there'll be a whole series of tests that they could work through. It's certainly possible for a CEO to be a responsible officer.
Minister Stoker, you've made some comments about the Qantas workforce on a number of occasions. Just want to, are you concerned about these?
Expressions of deep concern.
Well, I haven't finished the question, thanks.
I'm just a bit concerned given the way you've misrepresented me in the past on this subject. So forgive my being concerned about it.
Well, in actual fact, as you well know, Senator Stoker.
Chair, Senator Stoker should respect the processes of the Senate and not interrupt Senator Sheldon during his questioning.
Well, look, we've had a pause now, so let Senator Sheldon, you want to continue your questioning?
Thank you.
No, I just encourage Senator Sheldon not to abuse parliamentary privilege in the way that he has in the chamber in the past.
Point of order, Chair. That's not only is it inappropriate to make that assertion in this place. If the minister wants to make that assertion, she can do it again in Parliament.
Well,
and just for the record, as people would know, I've allowed Senator Stoker's response on my website as well, on my Facebook site as well. So I still stand by what concerns I raised.
We've had a few points back and forth. There's actually not a time for debate. There's plenty of times for that in the chamber. It's time for questions. So, Senator Sheldon, if we could return to questions, and Minister, if we could concentrate on engaging with those questions. Thank you.
Certainly, Chair.
We've just had comments regarding the Section 104 of the Model Workplace Health and Safety Laws and about the importance of representatives of health and safety are protected. And we've also heard that there is this case with Qantas, and there's no known at this point other cases that exist at this point. And we've also been made aware that this is a rare thing to occur for a regulator to take this action under Section 104, and it's certainly been suggested that this will be the first case. I'm saying that's correct. It'll need to be checked, but I'm confident that people have genuinely put that suggestion to me. Are you concerned about a work health and safety rep being terminated because they've stood up for H&S matters?
I would be concerned if that were the sole reason for a person being terminated, absolutely. The importance of people being safe at work is one that I regard as both high and serious.
So are you concerned that Safe Work New South Wales has laid charges against Qantas? And as we've seen, substantial amounts of money that they could be potentially liable for, plus individuals, and even including the CEO.
Legislation sets up serious and high penalties for safety-related matters because the safety of working people matters a great deal, yes.
So, particularly drawing you to the question I'm asking, and that is regarding Qantas, do you believe that these are serious allegations that have been made against Qantas?
Look, any allegation that interferes with the ability of people to work safely is serious. Now, I'm not going to speculate on the ins and outs of that case because I don't have the full brief about it before me and I'm not the person running that matter. But as a principle, I think it is very important that any interference with the ability of people to work safely is treated seriously, yes.
And that includes at Qantas?
In any workplace.
So I'm gathering you're saying that including Qantas. Thank you.
Well, yes, I just think it's
I
Qantas.
don't know why you can't say the word Qantas, because it is actually the charges against Qantas.
I just think I'm saying more than that. I'm saying it should be true at Qantas. It should be true in every workplace.
Thank you.
I don't confine it to that one employer. It's very important.
Thank you, Senator.
Okay, any more? Senator O'Neill,
Actually,
any questions?
this is actually with regard to the Attorney General's Department and interactions with Safe Work. So, Ms Baxter, good afternoon. I just wanted to find out what advice you've provided to the Attorney General about the interaction of a positive duty in the Sex Discrimination Act, which was represented in Recommendation 17 and 18 of the Respect at Work and the work health and safety obligations in relation to sexual harassment. So the intersectionality there, if you could speak to that and work that you've done.
Thanks, Senator. My recollection is that we have not provided any such advice to the Attorney General.
Okay, so to be clear, my understanding is that the Attorney General's Department has actually been saying that they were developing a work plan as a priority, and that was the impression that I received this morning as well, for the regulatory reforms that they missed out on in their first advance in the Respect at Work issues. In particular, they have been indicating, to the best of my knowledge, the interaction of a new positive duty with WHS obligations. If that is the case, and that is what the government is leading participants or civic agents to believe, then shouldn't we expect them to be in discussion with you with regard to that matter?
Senator, no, I wouldn't, because my understanding of the recommendation is for a positive duty to be inserted into the Sex Discrimination Act, of which I have no expertise in, and it would be the intersectionality of that Commonwealth legislation with another piece of Commonwealth legislation, the Commonwealth Work Health and Safety Act. Both of those, my understanding, and Mr Hare could correct me if I'm wrong, but my understanding is the policy responsibility for both of those pieces of legislation sits within the Attorney General's Department.
So am I misguided to think about the WHS as intersecting with the work that you do, Ms Baxter?
So if I may...
Mr Hare, thank you.
Senator, the government response was clear that there would be further work undertaken, and I believe at yesterday's estimates hearings in relation to the Attorney General's Department in legal, the legal side of it. They advised of the plan in terms of the next stages of work. Certainly, the department has advised the Attorney General in relation to the existence of the existing positive duty within the work health and safety jurisdiction, and that was acknowledged in the Respect at Work report. And what the government has identified is that they will do further consideration and have a look at the Sex Discrimination Act and the recommendation from the Sex Discrimination Commissioner, Ms Jenkins, for a positive duty there in conjunction with an existing positive duty. So at this point, Safe Work Australia has been tasked with implementing a range of measures by work health and safety ministers in relation to providing increased guidance. They've been tasked with developing a regulation around the psychosocial positive duty, which would include a duty to ensure that workplaces are kept free of sexual harassment, amongst other psychosocial implementations, and that work is underway. So Safe Work Australia as the national policy body around work health and safety is there. The department is responsible for looking at the Sex Discrimination Act aspects of it.
Okay, so Ms Baxter, do you have a response to Mr Hare's comments there, and do you see yourself as having a role in that ecosystem that he's just described?
Senator, as I said earlier, in respect of the recommendation for the inclusion of a positive duty in the Sex Discrimination Act and the intersectionality with the Commonwealth Work Health and Safety Act, no, I don't consider that Safe Work Australia has a role.
Mr Hare, just to be clear with your response, there is no engagement anticipated with Safe Work Australia, is that correct or not?
It might be helpful at this point, Mr Hare, for me to point out that the Attorney General's Department is commencing a consultation process that is anticipated to be one that is quite extensive. It will commence in December. That public consultation process will close in March 2022, and those stakeholder views will be considered and advice will be prepared for the government to consider in March, April. And from there, a decision on the next steps, legislative or otherwise, will be taken. So I anticipate, for what it's worth, there being a role to play for Safe Work Australia in that consultation process, but December is when that commences.
Right. Mr Hare, does that accord with your view that you were sort of expressing previously?
So, as I said, the work is being undertaken within the department in terms of the task force work. The Minister has outlined the plan, which, as I said, was referred to last night.
Yes.
And indeed will have public consultation as the Minister's outlined. What I would expect is that a range of policy bodies from across Australia would engage in that process, but policy bodies in relation to work health and safety. The model laws apply in the majority of jurisdictions, and in the jurisdictions where the model laws don't apply, they have similar provisions. And I would anticipate that those jurisdictions would engage in that discussion. I'd also note, of course, that as the Chief Executive Officer of Safe Work Australia, Ms Baxter is on the council, so does have an engagement in the broader discussion.
But not
as council.
formally as the, sorry, is it the Secretary? I cannot read your title from here, Ms Baxter.
Chief Executive Officer.
Chief Executive Officer.
So Ms Baxter's role on that council is to look at the recommendations the government has agreed to proceed through that, the consultation process through that council, and there's a number of them. The process around the consultation on the positive duty, as the Minister's identified, will be a public consultation process and open for a range of people to participate in. We won't be putting limitations on that.
Okay. So how much of that is news to you, Ms Baxter?
Senator, I am aware that the Attorney-General's Department has been progressing work in relation to that recommendation and consideration. I was not aware of the timetable, but I'm sure I would have been made aware of it in due course.
But you are a member of the committee that's giving that process oversight, but you're unaware of the engagement of Safe Work Australia at any point of time.
I might just clarify that. So a range of activities have been passed to the council, and the council works on those. So that was the distinction I was drawing. The actual process of consulting on or examining whether there should be a positive duty or not within the Sex Discrimination Act was not passed to the council.
Right. And Ms Baxter, do you have any further information after you've just had a consultation with your assistant there? I'm sorry, I can't see your name either. It's remoteness from one another is a problem.
It's Amanda Johnston, Deputy CEO. Ms Johnston was simply reminding me of the fact that I wouldn't have a role in relation to the intersectionality, but of course if consulted and from the evidence that's been given recently, I will be or will be able to provide a submission. I would certainly look at the issue from the perspective of the model work health and safety laws and the positive duty that already exists under those laws. But my ability and expertise to comment in relation to the Sexual Discrimination Act is very limited, I'm afraid.
Okay. So given that reveal of where things are, can I just get your view on the positive duty? Do you share the view with your knowledge of the work health and safety laws that a positive duty would complement, not duplicate, existing duties under WH&S safety laws?
Yeah, Senator, as I've indicated, I am not an expert in the Sex Discrimination Act, so I really don't have expertise or a view that I can provide comment to you on.
And can I just check, have you discerned through any interactions with the businesses that you engage with about the need or the impact of the implementation of a positive duty? Have you done any work or research in that area at all?
So can I just clarify? So Safe Work Australia has members, which include states, territories and the social partners, so being both the union movement and some employer reps.
Yes.
The Work Health and Safety Ministers, as part of the response to the Boland Review, has charged Safe Work Australia with developing regulations in relation to psychosocial injuries, as identified earlier. So I'm sure Ms Baxter can talk about where they're up to with that process and any consultation process they've undertaken, but it's not normally their role to engage with individual businesses.
Well, sorry, I could have phrased that better. You know, business groups that are representative of swathes of the economy.
They're members, but they'll have other engagement processes. That's all I was trying to say.
Yeah, okay. So, Ms Baxter, have you got anything further to add?
In terms of the development of the psychosocial regulations?
No, in terms of the positive duty, have you done any work at all on that?
Senator, we've done a body of work in relation to sexual harassment in the workplace, and I think I've run through that at the previous estimates, including the fact that in January 2021, Safe Work Australia published one of the world's first comprehensive WHS guides to clarify work health and safety duties and provide practical information on how to prevent sexual harassment. That's available on our website and supported by a range of shorter fact sheets, including for workers and small businesses. And then in May 2021, Work Health Safety Ministers, as Mr Hare has indicated, agreed to amend the model work health safety regulations to include specific regulation dealing with psychosocial risks, of which sexual harassment comes in. Drafting instructions are currently with Parliamentary Council's Committee in relation to those regulations. And then in November 2020, Safe Work Australia members agreed to develop a model code of practice on managing psychosocial risks at work. That code is currently with members for their consideration and their broader consultation. And subject to further feedback from members, it's intended that members consider a revised draft of that code at our December 2021 meeting. And if agreed to, that will then be progressed to Work Health and Safety Ministers to consider. So we're doing a great deal of work in relation to the positive duty on PCBUs that exists in the Work Health and Safety, the Model Work Health and Safety laws, if that's of assistance.
Thank you for indicating the work that you're doing. The intersection between what you just said in terms of the programs that you're creating, the codes to get people engaged, indicates that you understand how important it is to create a safe workplace. But without the strength of a positive duty embedded in legislation, these are merely recommendations and guides to people, as good as they may be. I'm sure, Ms Baxter, you've seen a resistance to change is a natural human a human response, and certainly, you know, some businesses can be particularly resistant. So again, can I just put to you that a positive duty legislated would be very complementary to the work that you're doing? Is that a fair assessment, Ms Baxter?
Senator, the duty to eliminate sexual harassment in a workplace or minimise it so far as reasonably practicable is a positive duty that already exists in the Model Work Health and Safety laws. So that positive duty does exist.
And given what's going on in workplaces, clearly it's not adequate, is it, as it stands? And the opportunity to embed it in federal legislation has passed us by.
So, Senator, I think that's why our members have, some while ago now, asked us to, in the agency, to undertake a body of work in relation to, you know, the guidance, the code, the regulations. All of that body of work goes towards emphasising the fact of the existence of this positive duty in the Model Work Health and Safety laws, with a view to educating, raising awareness, and that type of thing.
Senator, can I just make clear that the positive duty requires elimination or management of sexual harassment at the workplace. So it's broad, it's extensive, it covers the whole of the risk of sexual harassment at a workplace. And it is part of the Commonwealth Work Health and Safety Act as well.
Thank you very much.
Senator O'Neill, I think that evidence just given by the representatives from Safe Work Australia goes to the heart of the government's point here, and that is there is already a positive duty in place that demands all workplaces do all that they can to ensure that sexual harassment isn't something that their employees experience. And the work we are doing, both through the Respect at Work Bill, on which the Respect at Work Council was consulted, and in this consultation process that is going on through here, is about making sure we can get that to the front of mind of those workplaces that may not realise that duty is upon them, but also ensure that we do that in a way that doesn't unduly duplicate or increase the complexity of the environment in which workplaces need to operate.
And can I just put on the record that almost a quarter of workers have experienced sexual harassment at work in the last 12 months, and that was reported in 2021. Young workers more likely to experience sexual violence or harassment at work, 30%. Young female workers even more likely, under 25 years, 37% of them. Retail, 26%, health, 22%, transport, 18%, particularly high-risk industries for all genders, even so more so for women. Retail, 32%, health, 24%. So whatever is in place currently is not acting in a sufficient manner to deter the sexual harassment of women in our workplaces.
And Senator, both Ms Baxter's evidence and my evidence and the Minister's evidence has been that further work needs to be undertaken. That's clear in terms of the work that both Comcare and Safe Work Australia have been asked to do. And there's absolutely a recognition that it's not appropriate that anyone be sexually harassed in the workplace, and that workplaces need to do better. The work that we're, particularly that Safe Work Australia is doing on behalf of governments across Australia, is to try and provide better education, better guidance, and more clarity for people to try and do that. Notwithstanding that, the government's also committed to examining whether there needs to be a positive duty within the Sexual Discrimination Act, and that work, that consultation process is due to commence shortly.
Thank you, Mr Hare.
Okay, we're moving
Done,
on.
yeah.
Good.
Thank
Okay,
you.
well, we will let Safe Work Australia go. Thank you very much, Miss.
Another set of questions.
Oh, sorry.
I haven't had a reply as to whether
I thought
they
you
want
were.
us to ask them. Just let me check.
Okay, sorry, just
one
well, we're going to start the
sec.
going once, going
Huh?
twice.
These ones, have we done those? Oh,
We
that's
better move on, guys.
Yeah,
we're
we're
a
right.
little
Okay,
bit behind.
no worries.
So you're right. You're right. Okay, we can put questions on notice, of course. Thank you very much, Ms. Baxter. Thank you to other officials at Safe Work Australia. I will now welcome officials from the Fair Work
Thank you.
Commission.
Thank
No problems. Thank you. Okay. Sorry. Okay, they're not online. Well, I might. Well, let's suspend shortly until we can fix it up. Amanda, just don't go anywhere. We'll recommence just briefly. We're back on. Okay, after a quick discussion, we've decided we'll break for dinner at now, so we'll reconvene at 7 o'clock with Fair Work Commission. Is that okay with everybody? Thank you. Recommence. And we welcome officials from the Fair Work Commission. I'm sorry with the Zoom type screen here. I'm just not sure who of you is taking the charge there, but sorry. Mr. Furlong, sorry, I found my notes. Mr. Furlong, do you have an opening statement?
I do not, Chair.
Okay, well, thank you very much. And I will, with that, go to questions and pass over to Senator Sheldon.
Good, thanks very much, Chair. Good evening, everybody, and Mr. Furlong and your team. Mr. Furlong, I note that since the budget estimates, the Commission has released on its website a new member code of conduct dated the 2nd of July 2021. Does this code of conduct replace an existing code of conduct?
Senator, yes. It is updated. It's an updated of the member code of conduct that was established a number of years ago now.
Thank you. How many iterations of the code has there been?
From memory, three iterations. It's updated from time to time.
What is the basis for determining whether or when the code needs updating?
A number of things, but ultimately to keep up with community expectations.
So that doesn't quite tell me exactly why you would make it. What are the reasons that the code has recently been updated?
Well, as I said, community expectations. But one of the main drivers, Senator, is we partnered with the Human Rights Commission and Comcare last year. Commenced a partnership to undertake a number of activities. It's a very large project to look at ways that we could improve our workplace. And this is following the release of the Respect at Work report. And one of the things that we looked at as part of that process was the member code of conduct.
Yeah, include the code of conduct and for commissioners and deputy presidents, etc. Does it?
Yes.
So
my understanding is that
So you gave me some reasons why the code was updated and some of the in the last code. Was that all of them? Because I'm just trying to work out what the community expectations were and whether there was some concern about that it needed to be updated because it wasn't sufficient. So it's obviously some changes are made, so people decide that it's that's a positive thing. I'm not saying it's negative.
in terms of maybe I'll just provide a bit of background. The member code of conduct is a statutory instrument. It's provided for by the Fair Work Act, but it's a voluntary instrument and it's that can be developed by the President in consultation with members. And that's what occurred through this process. There are a number of members of the subcommittee of members who looked at the code and suggested some changes, and then they presented that to the President and the rest of the member cohort. And then through that process, it was updated.
Did someone request the code to be updated?
Not that I'm aware of, Senator. And I'd have to be honest with you, I probably, my role is largely administrative. The members, as you're aware, independent statutory office holders, smaller role under the Fair Work Act to assist the President in ensuring that the Commission performs its functions and exercises its powers.
Thank you, Mr. Furlong. What parts of the code specifically were updated or changed?
Several areas, but one of the main areas that was updated. Have you got a copy of the document in front of you there?
No, I don't actually, but you can step me through it and I'll take a record of it.
Okay. Well, and I can certainly ask one of the Fair Work Commission staff to table a copy. It's freely available on our website as well. But the significant changes, there were 3 limbs to it. Initially, the 3 principles: to uphold public confidence in the Commission, to enhance public respect for the Commission, and to protect the reputation of individual members and of the Commission as a whole. And the 4th limb was to ensure Commission workplaces are safe and free from bullying, harassment, sexual harassment, and other forms of unlawful discrimination, vilification, and violence. And obviously, it deals with a number of things, including social media.
Thank you. So who just so I'm clear, who in the pecking order of the decision-making process, who decided to update the code?
We'll have to take that question on notice, Senator. I'm not aware of who actually ultimately decided that the code was to be updated.
Is the responsibility with the President or some other system?
Yes. The President has the power under the Fair Work Act to establish the code. But the Fair Work Act requires the President in establishing the code consult with the members of the Tribunal.
Would you mind just stepping me through what the process is for updating the code?
I can certainly say in this
Appreciate you touched on it before, Mr. Furlong, but if you can give me the outline. You had touched on it before, but if you can give me the outline of the process, it would be helpful.
Yeah. Okay. My understanding, Senator, through this process, and it happens exclusive of my involvement between the Tribunal members and the President. But my understanding is that one second. Okay. The President initiated the review of the member code on the 26th of March. A committee of members reviewed the member code to determine whether the form, scope and content of the code were appropriate in order to ensure that the code continued to reflect community expectations, as I mentioned earlier. The updated member code incorporates comments from the committee of members and the Human Rights Commissioner.
So I missed that last bit, just can quite clearly hear it.
The updated member code incorporates comments from the committee of members and the Human Rights Commissioner.
Right. So I call them, there might be a different language for it, but tip staff of the commissioners or vice presidents, are they consulted?
The vice presidents would certainly be consulted. Associates, not that I'm aware of, call them associates of the Commission.
Associates, thank you. So the ultimate sign-off is with the President, isn't it? You said before.
Yes.
Did the Minister see or have any involvement in the code prior to it being signed off?
Not that I'm aware of, and I wouldn't have visibility of that in any case, in the normal course of things.
Thank you. Mr. Heer?
I'm not aware of the code being provided to the Minister.
Right. Is it something that that it wasn't, or you're not sure whether it was?
I have no knowledge of whether it was or wasn't, Senator.
Righto. Would you be able to take that on notice?
Yes, Senator.
Yeah.
What I can say, Senator, if it may assist, is that once it was updated, it was published on our website, available on our website.
Thank you, Mr. Furlong. Is there training associated with the updating the code?
There was. There was training that was conducted soon after the code had been updated by a QC. It was considered mandatory training that was attended by, my understanding, all members, or if there was a small number of members who weren't able to attend specific training, were required to watch a video of the training subsequent to it occurring.
So who wasn't able to attend?
I don't have the list in front of me, Senator.
Could you provide that?
I can take that on notice.
If you can take it on notice, that's fine. Ones that are unable and able to attend, just clearly on one page.
My understanding is that if they were unable to attend the training, they subsequently watched the training. They were required to watch the training. So my understanding, and I'm happy to correct this on notice if required, is that the members either attended the training that occurred at the time that it occurred, or through the member professional development committee were required to watch that training. We recorded the training, that's my understanding.
I gather the training something signed off. I'm just wondering who it's signed off by. What the training modules are, and what's the content is.
I didn't attend the training. It's probably not appropriate for me to attend. But the training went through, my understanding, and we engaged a QC to undertake this training for us, is that it went through the updates to the member code of conduct. In addition to that...
Yes, certainly go ahead.
In addition to that, when members are appointed to the tribunal, they undertake an induction, and through that induction program, they're provided with a copy of the member code of conduct, and there is a session that relates to the member code of conduct as well. And in terms of the date of the training that occurred for all members, it was facilitated by Tom Hannah QC, from the Australian Government Solicitor, and it occurred on the 22nd of July.
And so, can you thank you, the 22nd of July. How long was that? Was it for? What was the length of time that was spent the training, and is there a process of follow-up training?
There's been quite a lot of training over the last 6 months. My understanding is that the training went for between an hour and an hour and a half.
Okay. And you've said to me all the commissioners have either been at a physical meeting with their peers or have said that they've watched the video. Is that correct?
That's right. The initial session occurred via a video link, a Teams meeting, Microsoft Teams meeting that was recorded.
And since the code has been released, has the President received any complaints about a member's conduct?
In relation to, we do receive complaints about members, and we provided some information in this year's annual report about complaints that relate to members. And there's some information on page 43. Last financial year, there were 54 complaints relating to members. The vast majority of those were about member conduct in relation to a conference or hearing, and the vast majority of those were not substantiated.
And how's that tracking with previous years?
I think that it was higher this year than it was last year. But in general, we've only been reporting on this information in our annual report for the last 2 years.
So just so I I may have missed the figure. So it's roughly five last year, best of your recollection, and there was how many this year?
No, there's, and if I could please direct you to, and we're happy to table this as well, our annual report, page 43, deals with, at table 3 deals with complaints. There were 54 complaints in relation to members, and this is of the 30,000 matters that we receive, applications that we receive in the year, on the balance were related to staff. And if you look at the in terms of the footnotes, it explains what each of those complaints was in relation to.
Thank you for that. That's very, very helpful. And thank you for drawing to my attention where to do some further looking as well. So we've got a situation where we've had an increase from 5 to 54 complaints. Sounds like the training was pretty desperately needed.
Senator,
could I just jump in there to help you? Sorry, it's Ailsa Carruthers. I'm Executive Director, Client Services Delivery Branch. I've just had an opportunity while you've been talking to bring up last year's annual report. The total number of complaints last year was 65, compared with this year 54.
Righto. So, do you think the code's helping with that, or is it just like numbers change from year to year?
Can't make an observation on that. As I said, they were reported on the last 2 years.
Have you, since the code was set, have you received any complaints about the code?
Not that I'm aware of, but in a normal course of events, I wouldn't. Because I imagine that those complaints will be made to the president, and they'll be dealt with by the president with the member. And I would not, in the normal course of things, see correspondence between the president and members of the tribunal, or deal with specific complaints under the member code of conduct about the performance or behaviour of members.
Just want to clarify something. Those figures that were given before for last year and this year, they are directly in relationship to the code, aren't they? That's what I'm specifically asking about.
No, they're not.
Right. Could you give me the figures directly related to the code? For the last occasion, it was calculated on this occasion?
I don't have that information, Senator.
Senator, I might be able to help you.
Thank you.
Again, just we have combined the two, so the complaints can be about either responsibilities of a member under the the practice note about fair hearings, or it can be about member code of conduct, and the two are joined in together. So I'm not sure that going to the annual report itself is going to give you those individual figures.
So moving from the annual report, are you able to do a manual check, or does the annual report give you the capacity to say which ones were matters in relationship to the code and which ones weren't?
The annual report does not provide that information about separating complaints that relate to the code of conduct.
Can you
on fair hearings practice note.
Have the complaints about the code increased from the previous year? Do we know?
I don't know the answer to that question. I can take it on notice.
Does anyone else in your team know the answer to that question?
No, Senator. No. And as I so a number of times in the normal course of things, our role are as administrators, and matters that pertain to the conduct of members and the code of conduct will generally be dealt with by the president or his delegate with the members directly, and won't move to the administrative side of the organisation, which I'm responsible for.
Thank you. Have you, as the General Manager of the Commission, received any complaints about the code?
I have not, no.
Sorry, I missed your answer, just the connection.
No.
Thank you. Has the minister dealt with any complaints about a member's conduct? Are you aware?
I'm aware that very recently the President of the Commission wrote to the Minister about the Kimber decision, which involved Deputy President Dan. I haven't seen that correspondence, but I understand that he has written and provided. He wrote to the Deputy President and he provided a copy of that correspondence to the Minister.
I note that the guide specifies that the principles applicable to member conduct have four main objectives. First of all, to uphold public confidence in the Commission, and you've said this before, in the administration of justice. To enhance public respect for the Commission. To protect the reputation of individual members and of the Commission as a whole. And to ensure Commission workplaces are safe and free from bullying, harassment and other forms of unlawful discrimination, vilification and violence. And you've said this to me in your earlier evidence. Mr Furlong, given ongoing issues with at least one of your deputy presidents, these objectives seem very pertinent. Would you agree?
It's not appropriate for me to express any view on members' performance of their duties, including the content of a decision of a member.
And that's why obviously the arrangement, the code was developed, isn't it?
Is to provide guidance to members about appropriate behaviour, yes. But the compliance with the code ultimately rests with members themselves.
Further, Mr Furlong, the code goes on to say that there are four principles against which member conduct should be tested to ensure compliance with the above objectives. These are impartiality, independence, integrity and personal behaviour, and safe and respectful workplace behaviour. Can I just ask you again, Mr Furlong, these four principles around member conduct also seem quite topical. Is that why they've been developed or reissued?
I've gone through the process of the update of the how the member code of conduct was updated and the genesis of that update. I can't speak on behalf of the President.
How do you think Deputy President Boyce's various behaviours over the years since the appointment just before a federal election would be judged?
Once again, it's not for me to say in relation to how it would be judged. In relation to the member code of conduct, in any case, as I said, compliance with the member code of conduct rests with the individual members themselves, and the President has limited power in this regard. He has power to deal with complaints under the Act. He has very little or no power to discipline a member for misbehaviour.
Senator Sheldon, could I just, I've let it go because I mean there's legitimate elements to your questions, but I would remind you the standing order is not to ask officials for an opinion, so it's best to perhaps link any judgments or views back to things like a code of conduct or judgment against something rather than a more general opinion on someone's behaviour or personality in the broad, if that makes sense. Thank you, Senator Sheldon.
Has Commissioner Boyce received training on the code?
I can take that on notice in terms of whether or not he attended the training, but my understanding is that he did attend that training.
And that was training physically, not just by video, not just by looking at, well, how was it physically, by, as you said, by Zoom or some system like that?
It was a
or
Microsoft Teams.
By just watching a video?
Yeah, it was a Microsoft Teams. Yeah.
Pardon, I just still didn't get your answer, sorry.
It was a Microsoft Teams meeting. So members appeared or attended the training from across the country, and it occurred in a member, we call them twilight professional development sessions. They occur late in the afternoon, and they obviously because of restrictions on movement at the moment, it occurred via a Microsoft Teams meeting.
Thank you for that. I just want to then, still on Mr Boyce, what were the outcomes that you discovered for the Comcare report?
The most recent Comcare report?
Yes, regarding
about
Mr Boyce.
Okay. As Ms Weston indicated in her evidence earlier today, the Comcare inspector's report indicated that they did not identify any contraventions of the Work Health and Safety Act. I received a copy of the report on the 8th of October and subsequently provided copies of the report to the Deputy President Boyce and the President on Tuesday the 12th of October. I might also add here, to assistance, the inspector's report, while it didn't make any findings or findings of contraventions, it identified a small number of recommendations and things that we could look to improve, and we're well on our way to implementing those recommendations.
Can you outline
one of those recommendations?
Sorry, Mr Furlong, you were saying something else and I meant to cut you off.
I was just going to say that one of those recommendations related to reminding Deputy President Boyce of his obligations as to work under Section 29 of the WHS Act, and in providing the Deputy President with a copy of the inspector's report, I took that opportunity to remind him of his obligations as well.
What were the recommendations in the report on what steps should be taken? So, and I'm including all recommendations on however they may have been framed. So what were the recommendations?
One of them is around controls about the consumption of alcohol, including establishing a consumption of alcohol policy. And on that, we circulated a draft policy to the organisation recently. There's some training, additional information and training about the consumption of alcohol, behaviour at workplace functions, and about notifying obligations around notifying incidents that may be considered notifiable under the WHS Act, and the fifth and final is the one that I spoke about at the start, which is reminding the Deputy President of his obligations as a work under Section 29 of the WHS Act, which I've already completed.
Are you able to make that Comcare report available to the committee?
I can provide it to the Senate.
Thank you. Can you just go into a same situation but different people involved? Are you aware of what the outcomes were of the police investigation and what steps were taken by the police?
My understanding is that that inquiry, investigation, is ongoing.
So it's still open?
Yes.
Just one other question. Were all the... I wasn't quite clear where there was an assessment that probably was that that Mr Boyce was... Deputy President Boyce was also interviewed. Was he interviewed?
That is a question for Comcare.
Senator, my recollection of Ms Weston's evidence was that that Deputy President Boyce was interviewed.
Yeah, I just thank you for that.
I'll check that, but that was my recollection.
Yeah. No, thanks very much, Mr. Hare. Is there? I'm not asking the names of the people, but what capacity of others that were interviewed? What who else got interviewed?
It was an independent investigation or inspection, sorry, by an independent regulator. So it was conducted at arm's length from the Commission. I don't have that detail. My understanding broadly is that members and staff were involved in the investigation, but as I said, it was conducted at arm's length of the Commission.
Thank you for that. It's understandable. Are you aware of what the numbers were of members and staff that were interviewed?
No, I don't. I know that we provided a list to Comcare at the early in their inquiries, but I have no visibility in terms of the specifics of the inspection beyond that.
Just back on the police investigation, are you aware of who was interviewed from the police investigation?
No, and that is an ongoing inquiry at the moment, as far as I understand.
Have the police interviewed you?
No.
That's disappointing.
I wasn't at the event, Senator, and I wasn't in this position at the time either.
I wasn't putting any aspersions against you, Mr. Furlong. What I was suggesting is that it would be appropriate that somebody who knows the systems and has some administrative oversight would be able to give the police an understanding of what you understood had gone on, even though it's obviously not first-hand. You weren't at the alleged firecracker incident, but you were aware of the other public issues that had occurred. Are you aware what the police is actually investigating? Is it just is it only the firecracker incident, or is there additional things?
My understanding, it's about the firecrackers or fireworks or however they're described. In the inspector's report, it refers to the articles as throwdowns, whatever that means.
I don't wish to disrupt Senator Sheldon, but I'm conscious that while the rules of evidence don't apply in this forum, we have a person who wasn't present at an incident being questioned about things not within his personal understanding about an investigation that neither he or his office is conducting. We've now reached the point where any information we could be getting here is of dubious utility. And so perhaps it might be appropriate for Senator Sheldon to focus on matters that are within the witness's actual knowledge.
So
point of
on
order
the,
with the minister's
is this on the point of order? You're on the point of order?
Yeah.
Okay, on the point of order, Senator Sheldon.
These matters are relevant because of the administrative role that Mr. Furlong has, and I'm sorry you aren't going to shut me down asking these questions.
My objection wasn't as to relevance, it was as to reliability.
Okay, sorry, I'll rule on the point of order. Is this one? I'll take one more submission on the point of order, that Senator Pratt, then I'm ready to rule. So.
Well, it was simply to draw to Senator Stoker's attention, and you were here, Chair.
Through the Chair, yes.
Through you, Chair, the department and others said that we would need to canvass these issues in relation to the responsibilities of the President of the Commission this evening, as Senator Sheldon's been doing.
Except that he's asking about the police.
Okay. I'm ready. No more. I've got enough information. Look, there's, and I don't think Senator Stoker was raising a point of relevance. So I think the questions are relevant in terms of whether or not the witness, the official, has information in regards to those. Senator Stoker would say the official can take anything on notice or simply say they don't know. That is absolutely perfectly fine. But I will let Senator Sheldon continue with the questions.
Thank you, Chair. Mr. Furlong, just want to go to another issue. What is the vaccination policy associated with people working at the Fair Work Commission? Are vaccinations mandatory?
We encourage our members and staff to get vaccinated, consistent with the guidance provided by the Australian Public Service Commissioner. And members, or voluntary members and staff, are able to access reasonable paid time to obtain the vaccination, and that actually extends to our contractors as well. But it is not. It's certainly it's not compulsory.
So is it not compulsory for some people, or is it not compulsory for only people that have medical conditions? Just so I can clarify.
We've successfully navigated the pandemic by following. We have offices, as you'd be aware, in each state and territory, and the risk parameters and the controls that you have to put in place differ on each location. So throughout the pandemic, we have observed state and territory directions and orders in relation to vaccination. So if a staff member, if a member contractor wanted to attend our premises in Sydney at the moment, the New South Wales direction or orders in relation to vaccinations requires double vaccination, and we adhere to that.
Thank you for that. What was the basis of the decision of not making it, I'm still not quite clear, not making it compulsory, and I'm excluding, in this case, with my question, people that have medical reasons. What was the basis for that decision?
It's consistent with guidance provided by the Australian Public Service Sector, the Public Service Commission, Safe Work Australia and Fair Work Ombudsman. We've engaged, and where we are in the pandemic, we've engaged an external consultant to assist us with risk assessment and to make sure that we have adequate controls in place for every location. And it will be that will also look at classes or classes of workers in our premises. So the risk assessment, obviously, in all organisations differs depending on the nature or the duties of the workers as well.
You mentioned three bodies, if I understood correctly. I can go back on Hansard, but 3 bodies. Who else gave input to the vaccination policy? Were there consultations with the deputy commissioners, the commissioners, etc., staff?
We have, as I said, we've followed throughout the whole pandemic. We've followed state and territory orders and directions on vaccinations, and access to workplaces and physical distancing and face masks, and it has been being focused on each location has allowed us to be flexible in our response as well.
Are you aware that today Safe Work didn't attend these hearings because of concerns over the processes of whether they could be confident that there was adequate systems in place? Are you aware of that?
Yes, I saw some of their evidence.
Thank you. I just want to go then to this question of have you considered making the mandatory vaccination? We at the moment there's a couple of things that sort of that work into this. That we've engaged external experts to assist us with our control mechanisms. As you're aware, different locations, there's different risk profiles. Have we made a decision, a blanket decision, to make vaccinations mandatory? We certainly haven't. I can say that we're following and we continue to follow in relation to vaccination requirements, guidance provided by Australian Public Service Commission, Safe Work Australia and the Fair Work Ombudsman. Thank you for that, Mr Furlong. Did anyone in your organisation express an objection to having a COVID vaccination?
No, not that I'm aware of.
Look, and might just, I think that's, we've got to be a bit careful here, I think, with the line of questioning. Obviously, we don't want to go to anyone's personal status here. I think if it's generic and broad, that's okay, but there are protections.
I'm not quite sure whether we can go to personal, but I'm not intending to.
Okay, thank you, Senator.
Certainly at this point. Okay. What advice and guidance have been given to employees, executive members and commissioners regarding COVID vaccinations?
Throughout, from the time that vaccinations were available, we've been promoting vaccinations for, as I said, all of our members, employees and contractors. We've provided paid time, reasonable paid time for people across all of our locations to get vaccinated as well. There's signage, there's intranet articles, it's reiterated on our very, very regular communications that go out at the state or territory level, but also across the nation as well. We last week, the President and I sent out a COVID-19 update about proposed return to the office, and in that we talk about the fact that we've closely followed public health guidance and comply with state and territory public health orders and directions throughout the pandemic.
Good, thank you for that. Are you aware of how many of your staff are unvaccinated?
No, I don't know the answer to that question.
I'm going to put the next question in this context. Are you aware of the fact that a number of companies have made it compulsory on their workforce to be vaccinated? Is in the case of that requirement, is because obviously as an OH&S issue is what they're relying on. Isn't it an issue of concern if some people are unvaccinated? And I appreciate that some may be medical conditions, but isn't that of some concern? Isn't somebody in the organisation should know who's been vaccinated?
At the moment, to access our workplaces in certain locations, New South Wales, Victoria with a couple of other conditions, Canberra office is closed at the moment. You require to be double vaccinated, and the way that to get access to the workplace, you organise a short video call, and you have to show your certificate to an officer of the Commission. So while we're not requiring people to provide status of their vaccination, we're saying that if to access workplaces in accordance with state public health orders and directions, that if they want to access their workplaces, they need to prove evidence or provide evidence that they're vaccinated.
Thank you. Look, I just want to go to another issue. I'm sure you'll agree that the standing and credibility of the Fair Work Commission is of utmost importance. Would you agree?
Senator Sheldon, sorry to interrupt. I just did realise. Sorry, I might be wrong actually. Senator Faruqi, you wanted Fair Work Ombudsman, didn't you? Okay, sorry, my mistake. I've just noticed you had the call for a while, but back to you, Senator Sheldon.
No, thanks, Chair. There's no problems. Mr Furlong, I'm sure you will agree that the standing and the credibility of the Fair Work Commission is of the utmost importance.
Yes, I absolutely agree with that.
We've previously had the embarrassment of hearing about the antics of Deputy President Boyce, who I think has been established many times has brought the Commission into disrepute on more than one occasion. We've had partisan political social media posts, erotic anime figurines decorating his office, as well as a life-sized Donald Trump cutout, allegedly fake security cameras designed to intimidate staff of the Commission, repeated judgments being overturned, including one involving bias, and then, of course, the infamous firecrackers off the balcony route at the office Christmas party. We'll return to Mr Boyce later, but however, I want to just ask you about some questions about one of your other Deputy Presidents, Commissioner Dean. Can you tell me where Ms Dean's work base is? Is she Sydney based?
I think my understanding is she's moving from Sydney to the Canberra office.
The Canberra office, thank you. I'm aware from comments made by Commissioner President Ross that throughout the pandemic, much of the work of the Commission was done remotely. During the COVID pandemic, how did Deputy President Lyndall, President Dean work? And did she work only remotely or a mix of remote or in person or only in person?
I don't have that information to hand, Senator. What I can say is that over the last 12 months, about 70% of Commission's hearings and conferences occurred via online technology, online.
Could I, would you be able to give me the answers to those questions on notice regarding Deputy President Dean?
I can take them on notice, yes.
Thank you. I now turn to media reports about a dissenting judgment Ms Dean made in regard to a case involving a worker in an aged care centre who refused to have a flu needle and was eventually dismissed by her employer. As I understand the matter, the worker, Ms Jennifer Kimber, lodged an unfair dismissal application via her lawyer, Nathan Buckley, a prominent anti-vaxxer, and one of the commissioners found she had not been unfairly dismissed. Is that correct?
I'm aware of the dissenting decision that you're referring to, yes.
Then as I understand, thank you, Mr. Furlong. Then as I understand the case, she sought leave to appeal that decision, which was considered by a 3-person bench of the Fair Work Commission, who by majority verdict upheld the original ruling that Ms Kimber had not been unfairly dismissed. Is that correct?
That's my understanding. I can't, as you appreciate, I can't talk to the substance of decisions of the tribunal.
I'm not at this point intending to ask you that question, testing it. But thank you for raising it. Last, the Commissioner who did not agree with the decision of the other 2 members then wrote a dissenting decision that has been widely reported in the media and subsequently used by Ms Kimber's anti-vaxxer lawyer to support other cases when he's running in New South Wales against mandatory vaccinations. Is that correct?
I have said it, yes, it's been reported widely, yes. I think that's a reasonable assumption.
Thank you, Mr Furlong. I appreciate that. How often do majority verdicts occur in the course of Fair Work Commission decision making? Are you aware?
We don't maintain those records.
Righto. So would you agree that the decision was highly unusual in the normal course of events?
I can't comment. Well, it's immaterial what my views or observations are of these matters. Ultimately, the decision stands for itself. It's available, publicly available. Independent statutory office holders making decisions within their powers.
Isn't it the case that the opinions expressed in Ms Dean's dissenting decision went beyond the scope of the matter being considered by the 3-person bench?
I'm aware that the President has taken several steps in relation to this matter. Maybe it'd be more appropriate if I answered in that way.
Well, I guess then just go this. Given to the extent which Mrs Dean's decision strayed outside the matter under consideration, how did Ms Dean's views, as expressed so strongly in her judgment, accord with the views of the Commission broadly and the advice provided by the Commission on vaccines as the principal workplace regulator?
Just to reiterate my evidence of what our position is as an organisation in terms of vaccinations, and while it's not mandatory, we have gone to significant lengths to provide opportunities for all of our members, staff and contractors to get vaccinated, including paid time. A decision of a full bench, a dissenting decision of a full bench it contains the views, the observations and the application of law as that member, as that member interpreted. But beyond that, there's very little I can say about the content of the decision.
I appreciate responsibility as a PCBU about providing appropriate workplace safety. That's why I was specifically asking about Ms Dean's views. Those views were expressed obviously publicly in her judgment. Just so I'm clear, that's not the views that's held by the Commission, is it?
It's not the views that I hold, no.
How does Ms Dean's behaviour in this matter accord with the Code of Conduct?
I understand, and once again, it's certainly not for me to go into the application of the Code of Conduct. But my understanding is that the President has written to both the Deputy President and, as I said earlier, provided a copy of that correspondence to the Minister that relates to this decision and the performance of the members' duties or responsibilities, statutory powers in relation to this decision.
Does Ms Dean's decision give rise to concerns she has breached the Code of Conduct on the issues that she raised publicly?
It's not appropriate for me to express the views of members' compliance or otherwise with the Code of Conduct. Ultimately, in terms of the Code of Conduct and the conduct of members, the responsibility for compliance or observation with the code rests with the individual member, and ultimately the responsibility for disciplining members or any other activity rests with Parliament.
The Minister earlier today said that, and this is the Minister that appointed Ms Dean, said that we would need to ask the Commission as to any breaches of the code. But essentially you're now telling us that the Commission itself has no role in that, because ultimately it is an appointment that no one can touch until the Parliament itself decides to take action. Who does the Parliament ask for evidence as to the nature of conduct?
Mind if I just clarify?
Hang on.
Yeah.
Sorry, Mr Furlong. The Minister just wanted to add some context to that question.
Respectfully, that first doesn't accurately characterise what Mr Furlong had said. Second, the Code of Conduct is very clear on what it requires of members of the Commission.
It does.
It says...
The Code of Conduct's very clear, but there's no one to enforce it.
Well, can we just take the temperature down for a moment, Senator Pratt? Members are responsible for ensuring that proceedings are fair and that parties are treated with courtesy and respect. Members have a responsibility to listen to evidence, ask questions to clarify points, manage the behaviour of advocates to ensure that parties are treated with courtesy and respect, exclude irrelevant information, discourage repetition, and deal with each matter on its merits.
Okay,
let me finish. A dissenting opinion which indicates that on the facts and the law relevant to a particular matter, one member of the Commission has reached a different perspective to others, a process which is utterly normal in the field of law, utterly normal in the field of the Commission, is not an indicia of a breach of the Code of Conduct.
No, we know that.
Unless there's
we know
evidence,
that, Minister.
Well, respectfully, it's not borne out by the questions that are being asked that is known.
No,
there's
Minister, there are...
Can I finish, please? There is nothing that has been put forward here to indicate that any of those matters in the Code of Conduct are directly relevant to the decision that's been made. Now, none of that is to comment positively or negatively on the content of the decision, but to suggest that there is a breach of the Code of Conduct, one needs to direct oneself to the behaviour of a member of the Commission in conducting the hearing, not the content of the decision that was actually made.
That's not what is at question.
Could I also
Thank
just,
you, Chair.
if we could just return, thank you for that context, Minister. Could we just return to the question, Senator Pratt, or the background you gave? Might be helpful. I don't think you were quoting from a transcript. I probably don't have one yet. But my recollection was I thought the Minister said the President of the Fair Work Commission had the responsibility of enforcing the code. And I thought she did indicate that I don't know if it's a he or she, but he or she won't be here tonight. That was my recollection. I
Yes,
could be
you're
wrong,
perfectly correct, Chair.
but with that, Mr. Furlong, do you remember the question, or would you like that restated?
We're really inquiring into that in a procedural sense.
Chair, sorry, Senator Pratt, just before you launch, I have a question on a slightly different topic, but I have to go to another committee.
Well, it's you can all work out among yourselves.
Could I just ask this one question? It may be able to be answered now, or it might need to be taken on notice. But
well, as long as Senator Pratt is okay with that. But okay,
great,
Senator O'Neill.
thank you. So, one of the matters that has been discussed here in the context of these estimates hearings today is the need to address psychosocial hazards in the workplace. I'm not sure if you are aware of the recent publication of Challenges of Work, Family and Care, which is a survey of 6,500 workers that was undertaken by the SDA, the Union for Retail Workers. And in it, they raise the impact of poor rostering and insecure hours on the mental health of workers. My question is, have you done any work about the impact of poor rostering and insecure hours on the mental health of workers?
Is this a question to the Commission.
Yeah.
Do you mind if I take that question on notice, Senator? It's a very broad question. I'm aware of the report that you're referring to. I haven't read it closely, but there are a number of major cases that have been dealt with by the Commission over many years, and lots of research about domestic violence, leave, and casual conversion, and variations, amendments to modern awards, where some of these issues that you are traversing may have been touched on. So it's a very broad question. Do you mind if I take it on notice?
Yeah, Mr Furlong, that's great. If you want to take it on notice, clearly I've drawn your attention to the report, and it provides detail that I think has been otherwise unavailable really in the public place, and it is a good sample size of 6,500 people. So if you could take it on notice, what's the impact of poor rostering and insecure hours on the mental health of workers? Thank you. Thank you very much, everyone. I'll be back.
Thanks for that.
We go, Senator Sheldon now.
If there was a complaint, how would it be managed by the Commission if there was a complaint made to the President under the Code of Conduct?
The actual member code of conduct, I think you may have a copy in front of you now, Senator, at page 11, sets out the process for dealing with concerns about member conduct and complaints to the President under Section 581A of the Fair Work Act. I can go through the process broadly for you if that would assist.
Thank you. That would be assistance, but thanks for drawing that to my attention. Have any complaints been made to the Minister regards the code of conduct?
Not that I'm aware of. I'm not, and nor would it be appropriate for me to be across correspondence between the President and the Minister. What I can say to you is that I am aware that the President provided a copy of his correspondence that he sent to Deputy President Dean to the Minister.
What's the significance of that correspondence?
The correspondence went to a number of things, including the several steps that the President has taken in relation to the complaint. So while the President does not have the power to discipline members, he has certain powers to deal with complaints about members. And in particular, I'm aware that the President has written to the Deputy President about this and informed the Deputy President that she'll be directed to attend training on the responsibilities and standards of professional conduct expected of a member of the Commission once a suitable course is identified. She will be excluded from all and any further full bench work at least until she has completed that training. And as she has disqualified herself on the grounds of bias from adjudicating disputes relating to workplace vaccinations in the future, the President is requesting the regional coordinator, I'll explain that in a second, not to allocate any matters to her, and she is directed until further notice to inform the President immediately if a dispute of that nature arises in any matter that's allocated to her. Now, in terms of, just by way of explanation, we work on a regional allocation model at the Commission. We have two very senior members of the tribunal as regional allocators. There's two regions, and they are responsible for overseeing the allocation of cases to individual members in consultation with the national practice leaders for particular matter types.
Thank you. Can I ask in that context, that's in relation to the actions of this Commissioner in relation to cases in relation to COVID. What about any social media policy breaches?
I am aware, and I've only become aware today of the social media posts that I think that you're referring to. I've not seen the originals, but we'll assume that for the purpose of this discussion, that their extracts are an accurate reflection of the post made by Deputy President Dean.
Thank you. I would note that Commissioner Boyce had previous counselling, or I'm not sure the right terminology, but had been required to adhere. It was noted that he might have acted outside the code and needed to adhere to it in relation to his social media postings. Is Commissioner Boyce now adhering, and have commissioners all had counselling as to their requirements? It seems pretty startling to me that it looks like, and clearly there's not been a finding, that there could be other commissioners doing such things when already there's been a lot of visibility around the need to adhere to the code of conduct, not only into the conduct as a commissioner, but also in relation to social media.
In terms of your first question about Deputy President Boyce and adherence to the code of conduct in relation to social media, I'm not aware of any further social media posts from Deputy President Boyce that may conflict with the code of conduct. And in terms of the use the word counselling, but training, we've I noted earlier that that all members undertook mandatory training on the revised member code of conduct in July this year.
Thank you, that's helpful.
Earlier this month, Ms Dean commented on a post on social media site LinkedIn that likened Australia's public health response to COVID to Chinese-style totalitarianism and to the Jewish Holocaust. Are you aware of that?
I have seen a copy of it, that post, yes.
The post by Tanya de Jong says that the Western world has responded to COVID by adopting all the trappings of totalitarianism fueled by rationality and fear. It goes on to say, we have imported far more from China than the virus. We have imported Chinese-style totalitarian social control mechanisms based upon very selective science. It then quotes from the Hungarian Jews about the rise of the Nazis and the Holocaust and concludes, now we are at the precipice of another global tragedy fanned again by ideology of health for the majority. Do those comments seem reasonable or credible views? Are they views you hold?
It's irrelevant, ultimately, Senator, what I think in relation to these views. What I can say is that if you like, the member code of conduct specifically goes to these issues at paragraph 4.3.7, and in particular, a number of things that members should not identify themselves on social media as members of the Commission, but should also assume that this may become known, and that a member should also avoid involvement through social media in any controversy that might come before the Commission, and then it's in brackets, such as by liking a post about such a controversy.
Can I just take you back on some evidence you gave before? You mentioned that there was a letter from the President to the Minister. Can you give us some details of what was in that correspondence, or can you give us a copy of that correspondence?
I haven't seen that correspondence, and in the normal course of things, I wouldn't see that correspondence. Correspondence between the President and members, or the President and the Minister, are generally dealt with confidentially. And in terms of the correspondence, well, I'd be happy to take it on notice. Correspondence or interactions between the President and members has not been provided previously because it goes to the essential independence of the tribunal.
Thank you. I just want to ask you, what are you aware that was it about Ms Dean?
Yes, and I understand from some notes that have been provided to me that the President's correspondence informed the Deputy President, and these are the items that I just read out previously about, directed to attend training on the responsibilities and standards of professional conduct expected of a member of the Commission, be excluded from any further full bench work, at least until she's completed the training, and that she's disqualified herself on the grounds of bias from adjudicating disputes relating to workplace vaccinations in the future. The President has requested that the regional coordinator, the person who allocates the work to her, not allocate any such matters to her, and she is directed until further notice to inform the President immediately if a dispute of that nature arises in any matter allocated to her. So if there is any conflict or any apprehended bias in relation to a matter that ultimately gets allocated to the Deputy President, and there is under the Fair Work Act in any case, but that expressly requires her to communicate that to the President.
So that's from the notes that you've been provided, but you don't know explicitly what is in the correspondence.
I haven't seen the correspondence, no.
So the notes that you have are from
Can I just-
records about complaints or advice from the President.
Can I just follow through my question?
They've been provided to me by our legal counsel.
Legal counsel, thank you.
What is the significance of writing to the Minister, the President? What's the significance of that? Just so I'm a little bit in the dark about what that significance is.
I think from time to time, the President writes to the Minister about operations of the tribunal. There can be many and varied reasons for writing to the Minister. I don't know specifically if the President wrote to the Minister about the compliance with the Code of Conduct, or if he just provided a copy of his correspondence, forwarded a copy of his correspondence to the Minister. But in terms of the significance of it, in relation to complaints about members of the Commission, and I refer to that any party, any person can make a complaint about the conduct of a member directly to the Minister as well.
Minister, Ms Dean commented on the post saying that I've mentioned before regarding that sort of long explanation from Ms Tanya de Jong. I can repeat it if you like. Comment on that post saying, I fully agree, Tanya, meaning she agrees that our public health response is comparable to the Holocaust. What's your response to that?
It's something I've seen for the first time now. It's not a view I share, and that's my view. It's not a view I share.
Does it raise concerns that a Commissioner is espousing those views?
Everybody who comes before the Commission deserves to be treated with a fair hearing and impartiality, and it sounds like the procedures that are in place are appropriate to ensure that that occurs for litigants who come before the Commission.
And you're saying Ms Dean filled those requirements you just outlined?
That's not what I said.
No, I'm asking you, did Ms Dean meet those commitments that you just outlined?
I don't know what the full suite of Ms Dean's behaviour has been like, and I think it would be foolish to judge the entirety of a person's contribution in light of one article. But that said, I don't agree with what she has posted, and it sounds like the procedure that has been put in place by the Commission to manage any perception of bias arising from it is appropriate.
Can I ask Mr Furlong, it is, who has responsibility to address breaches of the code in a Commissioner?
The compliance with the code ultimately rests with the members themselves, and there is a process for...
And if they fail to address their conduct, what then happens?
There's a process, and it's in the member code of conduct at page 11 for dealing with concerns about member conduct. and it goes through, and it's in relation to as prescribed by Section 581A of the Fair Work Act. But essentially, it goes through a process for an inquiry and investigation, and that if it's substantiated, then the President may form a view that he refer the matter to the Minister.
So was the letter to the Minister a referral of those matters after an investigation?
Not that I'm aware of, Senator. As you know, I haven't seen the correspondence.
Okay, is there an investigation underway?
Not that I'm aware of. My understanding is that the President...
I guess the question is, ultimately, as I understand it, it's the job of the Parliament, and therefore, when the time is appropriate, Parliament needs access to that information via the Minister.
There's also, if I could just draw to your attention, a question on notice from the Attorney-General's Department from estimates on the 24th of May, EEC AE21-45, and at the penultimate paragraph, it refers to the Fair Work Amendment repeal of 4 yearly reviews and other measures Act, which amended the Fair Work Act to apply the Judicial Misbehaviour and Incapacity Parliamentary Commissions Act 2012 in relation to FWC members.
Yes.
It enables Parliament to establish a commission to inform its consideration of any case for requesting the Governor-General to terminate an FWC's member's appointment by inquiring into and reporting on allegations of misbehaviour or incapacity. As I said, the President's powers are limited to the complaint process. And,
Thank you.
Yeah.
Minister,
Thank you for clarifying that.
Apologies. Minister, given Gerard Boyce was counselled over his social media use, why are Deputy Presidents still making these sorts of posts?
Sorry, can I please ask you to repeat the question?
Addressing that to the Minister, Mr. Furlong.
Thank you, Senator Sheldon. I can't speak for what is in the minds of individuals other than myself, but what I can say is that the social media use that you have drawn my attention to is something about which the AG was asked earlier today. She's indicated it will be raised with the President, and you can expect that it will be taken seriously.
Thank you for that.
Can I ask, can we do these ones now? Yeah. Can I ask, please, if there have been any workplace complaints levelled against Deputy President Binay?
I think you might be on mute there.
Thank you. I was just trying to mute myself when I was shuffling papers and didn't want to distract you. Some WHS concerns were raised in relation to the Deputy President. Those matters were investigated and concluded quite some time ago, and no adverse findings were made.
Okay, so the outcome of the complaint was that there were no adverse findings and the Commission's response is now finalised?
Yes.
Okay, in terms of who made the complaint, are they still a staff member within the Commission?
Do you mind if I take, I don't want to appear unhelpful, Senator.
No, you've been...
do you mind if I take the question on notice? There might be a strong public interest immunity grievance weighing against disclosure of that information at this point in time.
Okay, so if I might then allow you to weigh those issues up in terms of asking if they're still there or not there, and if they're not there, what were the circumstances of departure, and if they still work under that Commissioner. May I ask, are there any legal costs incurred as a result of this dispute?
I believe that the Commission incurred legal costs associated with the WHS concerns.
You said you didn't believe there were.
I do. I believe that there were. I will take it on notice. I'm not aware of the quantum, but I'm certainly happy to take that on notice.
Okay, if you can take on notice who actually covered those legal costs and what that quantity was, if it was indeed the Commission or another government agency.
My understanding, I might be able to provide some assistance here, is that the Commission did not pay any legal costs for the
Didn't
Deputy
pay?
President. No.
Okay, but it was resolved in the favour of the Commissioner in terms of it being settled, or was it
No
kind of
adverse findings.
settled, or was it resolved in terms of there being an outcome of no finding of wrongdoing?
I have to be quite careful with my language here, but no adverse findings were made.
Okay, was there a settlement that therefore meant there were no, like, that the matter was not pursued any further?
Providing further information, there are strict secrecy provisions in relation to these inquiries.
May I ask, in terms of, this is a Senate hearing, the normal procedures of the contract in that regard don't necessarily apply? I might ask the clerk, draw the clerk's attention in relation to, I've asked the Commission in relation to a potential settlement. I don't know if that's the case. There were no adverse findings made against Ms Benet. However, I'm unclear whether that was subject to some kind of contract that precludes us from finding out what the initial complaint was about. But it is my understanding that Senate should still, that a public interest immunity claim does not necessarily apply to an individual settlement between those parties.
Well, I suppose the first instance, that question should be put to the officials.
Okay.
Senator Pratt. It's up to them to claim a public interest immunity, really, before.
Okay, so
it's appropriate for the Secretary to rule on it, or ultimately me.
in terms of the settlement between the Commissioner, Ms Benet, and whomever made the complaint in that regard, you've said that there were no adverse findings that have been made. I've fairly much presumed, therefore, that there was some other kind of settlement. Can you please advise us what the Commission knows about the initial complaint, please? Because you're not subject to needing to uphold the terms of that settlement. If it's within your individual knowledge, you're able to tell estimates.
I don't have that information available to me at the moment.
At the moment, but it is within your knowledge to know that there was a complaint that was made. Do you know, is it within your knowledge to know the type or nature of that complaint?
I can certainly, it was before I was appointed to this position.
Yeah.
I don't know in terms of the settlement and any sort of any other activities of the predecessor in this position. What I can do is make inquiries and come back to you on notice.
Okay, and you would understand that any settlement between the Commissioner and the individual, it's still within the public interest for the Parliament to know the nature of any complaint that might have been made. We canvass complaints here quite often without there necessarily being a reason. There'd need to be a strong public interest, not a private interest in terms of keeping them secret.
I understand.
Did Minister Cash's office, as far as you're aware, get involved in this dispute in any way?
Can I just clarify which dispute are you referring to?
The dispute with relation to Ms Benet and this complaint.
Certainly not.
I wouldn't.
Mr Furlong, sorry, you can't hear, probably it's not your fault, but Mr Heer was going to add something.
I believe Minister Cash said, provided advice that they hadn't been involved in that. I do note that Mr Furlong identified that this was some time ago.
Okay, thank you. What about the previous minister?
Senator.
Okay, so we don't know whether we have a case of a coalition appointee behaving badly, because whether they did or not, it sounds like could have been a secret settlement about it, but you'll be able to provide us the details of
Senator, in the course of this conversation, I've been able to confirm that there was no settlement.
There was a settlement?
There was no settlement.
No settlement. Oh, well, that's very helpful. So there was no settlement and there was no adverse finding. Was there?
That's right.
Does that mean the Commission and the President concluded an investigation?
Concluded an investigation. Is that that?
Was there there were complaints, which we've confirmed, but we don't know what the outcome of that complaint was, other than the fact that no adverse finding was made. I'm taking from that therefore, if there was no adverse finding made or any settlement that would keep any of that behaviour under wraps.
That's accurate, yes.
Nevertheless, we know there were legal costs that the taxpayer didn't pay for that I'm presuming Ms Benet would have therefore covered.
I'm not aware of that, but I assume so. And just at the start of this conversation, I indicated that the matter has concluded. It's not ongoing. It was concluded some time ago.
I'll just ask now, has there been any action under any codes of conduct in relation to Ms Benet's behaviour?
Not that I'm aware of, but as I've said previously this evening, I would not necessarily be aware of all communications or complaints. I can certainly say from my knowledge, from my experience, no.
Okay, so if you can have taken on notice in terms of your knowledge, because we're aware that it might not be within your knowledge, whether there are any active complaints before the President in relation to Ms Benet's behaviour. It sounds like they've been resolved, but I would be keen perhaps to get in writing whether there was one and whether it's been resolved without... it sounds like it's been resolved without adverse finding, but it would be good to get something back in writing, noting that we're aware that there was a complaint.
Yes.
Mr. Stokes, I'll ask a question in regards to this. We've had evidence over a period of estimates hearings and some updates again today regards Commissioner Boyce. We've had, that's included erotic anamine, staff intimidation. We've had allegations regards workplace complaints against Commissioner Bennett. And also we've had public comments, anti-vaxxer propaganda by Deputy President Dean. All those three are LNP appointments. You've picked some duds, haven't you?
I'm not in a position to comment on the relative merits of each and every person on the Commission. You've put forward a particular perspective based on particular people that you have researched. I haven't looked at the whole suite of people, and so I'm happy to allow you your opinion.
So Minister Stoker, thank you for that. I appreciate saying that to give an overall view of everybody within the Commission requires further investigation if you were to do that. I'm not asking for that. What I'm saying is that these three people are duds, aren't they?
I don't know the ins and outs of the things these individuals bring as compared to the mistakes they may or may not have made. I'm happy to take on notice and do a greater assessment if you'd like, but it is, I think, a mistake to judge anybody's contribution in a vacuum.
So erotic anamine, staff intimidation, allegations about workplace complaints and anti-vaxxer propaganda.
There's your allegations. I haven't verified
It's not
any
something
of
that
those
worries
things.
you.
Oh, if made out, many of those things would worry me, but at the moment they're allegations from you at the table, and until I've had an opportunity to verify those things in context, I would like to reserve judgment.
Well, you're aware that as I understood it, you're aware of the anti-vaxxer propaganda by Ms Dean.
I am now that you've provided me with a copy, yes.
Thank you. And you're aware of Mr Boyce. There's been decisions made about that and some quite considerable conversation again today. Are you able to make a view of those two? Are they duds?
I am not prepared to judge anybody's contribution in a vacuum. We don't know anything else about their contribution from the very narrow field of discussion we've had tonight. If you'd like me to take on notice and look into it in greater depth, I'm happy to, but I'm not prepared to celebrate or condemn anybody, you and me included, based on a few lines or from one moment in their career history.
Minister, just want to clarify, you've said that you don't agree with the comments from Ms Dean.
I don't.
Are they appropriate comments?
Again, I'd like to see things in context. I don't agree with them. I think the measures that have been put in place to manage any perception of a lack of impartiality arising from it are appropriate. That speaks volumes of how well the Commission manages these things. But ultimately, I'm not prepared to opine on these things in a vacuum. I will look at them in their context.
Well, so you would like to see a comment comparing vaccines to the Holocaust in context?
I don't think...
Senator Sheldon, you know that's not what I said.
I don't think...
That's exactly... You said you've got to look at it in context. Isn't that very clear about, comparing vaccines to the Holocaust is something in context? Is that what you're saying?
I've just told you I don't agree with what is in the post, but a person's entire career contribution, all of the good things they've done, all of the things that they have done badly, all of the mistakes they have made and all the glories they have achieved need to be taken as a whole.
Well, I'm not aware of many glories with any of these three.
You haven't provided a balanced perspective. I like to give people the kind of natural justice that means you look at the whole picture rather than judging the entirety of a person's professional worth based on one statement. I don't agree with that statement at all, but I suggest that it is a flawed logic to suggest that one statement defines a person and their professional contribution entirely.
You may want to make a response to this, of course. It's your prerogative. But doesn't it... So you're saying that you have no desire to hold any of these people accountable in your eyes on the actions that they've taken on the basis of the information, on the basis of the information that you have before you.
Senator Sheldon, I said I would take a look at it, take it on notice, examine it properly and fairly, rather than on one bit of evidence taken out of context. Quite frankly, I would do the same for you if I were asked to pass judgment on something you had said. I would look at it in context and I would look at all of the good things that you had done.
I'm not quite sure about that, Senator Stoker, but yes, you said you would.
I think that's...
Chair, I just want to stop here. I mean, your questions at one level are fine, Senator Sheldon, but I would appreciate if you could avoid quoting the minister back in your questions with your interpretation, because that's probably just going to elevate things. Sometimes I think you are stepping over into perhaps verballing the minister, but
don't mind if
the
he does
questions are
accurately,
fine. The
Chair.
questions are fine, but if we could avoid trying to reinterpret what each other's saying, that will probably lead for a smoother discussion.
I've asked the minister this way, and I may have I just realised where the minister might have a different interpretation, and you, Chair, about what I was asking. I was asking the Minister, and I'm asking the Minister now, through you, Chair, is a comment regards comparing vaccines to the Holocaust something that you can make a decision about, the appropriateness in light of the evidence that you have in front of you, on whether they are appropriate comments by the Commissioner?
They are not comments with which I agree. They are comments I disagree with. I've made that very clear to you. But to make a judgment on a person's professional worth necessitates looking at it as a whole, rather than on the basis of a one-page photocopy of something you've pulled off the internet. I would want to verify that it is, in fact, what it appears to be on its face. I would like to examine it against other statements made. It may be that the very next day something quite different was said. I don't know that. I'd like to compare the quality of decisions across a range of subject matters. What I will not do, Senator Sheldon, is be bullied by you into operating without the evidence necessary to be fair in assessing someone's contribution.
Well, I don't think I've actually interrupted your questions or comments throughout this hearing. You have done it to me on a number of occasions, so I'm not sure who's trying to bully who, but what I am trying to get to is the answers to the questions I'm asking.
I've answered them thoroughly.
Also, well, potentially one more, the last question on this subject. What are the steps that you believe should be taken? Because you've just said, and again, you'll correct me because this is what I understood you said, and that is that you have to weigh up those statements that have been in the public arena for a very long time. You're a senior minister in that role of industrial relations, certainly the Attorney General's as well, and that you haven't prevailed yourself of these serious allegations about an anti-vaxxer, and you're putting some suggestion that the evidence before you was inaccurate.
Yeah.
I mean, she certainly did not imply it was inaccurate. She's just asked for time to consider everything, and I do think that...
I think, Chair, we're nearly finished on this.
Okay, look, just in the interest of time, once again, I mean, I can't rule on the veracity or accuracy of questions, but once again, just draw your attention to please ask the questions with respect. I actually didn't hear the Minister say anything that they were inaccurate, so it would be useful for civil discussion if we could try and keep our statements in that fashion.
Thank you. I think we're nearly ready to go.
Did you want
on
to
the
finish that
next.
question, Senator Sheldon?
I've completed my question.
Okay.
I just wanted to ask very quickly.
Sorry,
answer it?
there was a question put, so
I
the
beg your
Minister
pardon, I wasn't
would
aware.
like to
Thank you.
answer, but if we could keep that brief as well, Minister.
It was a long question, so I think I've understood it. But I'm a person who comes from the tradition of the law. My job is one in the outer ministry related to the proper application of law. And in that tradition, we observe principles like natural justice, like allowing a person to put a point of view in their own defence, like not jumping to conclusions based on mob rule or by deplatforming. So what I intend to do is to adopt that kind of fair-minded approach. That means taking into account the bits and pieces you've given me and looking at them in the context of a broader contribution and anything that the relevant person can say in their defence. That's how we do things fairly. And I intend to adopt a fair approach. And I've said this before, and you may not believe me, but I would do the same for you or for anybody else. We are all individuals who deserve those basic rights, whatever mistakes we've made. And I would do that in this circumstance, and I would do it in any other circumstance.
Apologies, I thought you'd finished. Can I just, in every circumstance, I then just want to be clear, you've made some very disparaging comments about Qantas workers and the negotiations of agreements, and you're saying that you weighed up all those considerations when you made those comments and the role that you hold now.
Senator Sheldon, come on, don't repeat this error. All I said was how much of a tragedy it was, how disappointing it was, what had happened to the Qantas workers about which you had spoken.
You said a lot more than that.
When
I'll leave it for Hansard.
Well, the Hansard
I think it's
speaks
best
for
if we
itself,
might
Senator
move.
Sheldon.
Well, Hansard says quite clearly that you turned
Senator
around.
Sheldon.
Minister, I think it would be useful to move on now. We are starting to get a little bit out of relevance. Senator Pratt did want some more questions.
Plain dishonest, Senator Sheldon.
Answer.
Senator Stoker, that's an offensive comment from you, and
It is
it's quite
utterly
clear what.
dishonest.
It's quite clear
Can
that
I get some?
You've questioned those that have
Utterly-
negotiated agreements with Qantas about the disparity of the way they were negotiating those agreements, and those
That is not what I
negotiators
said.
for those agreements, in effect, were the workforce which do the negotiation. So,
No.
obviously one extension applies
That's
to the
not
other.
what I said.
Okay,
not what
all
I
right,
said,
no
Senator
more.
Sheldon.
Please, order.
Thank
That's it.
Thank you,
Senator
Chair.
Pratt.
Can I ask very briefly, the Commission said that no Commission funds, and as I understand it, no taxpayer funds have been used in relation to any particular legal bills that Commissioner Benet had in relation to complaints that were made in regards to her. Am I correct?
That's accurate. The Commission did not pay any legal costs for Deputy President Benet.
Can I ask Mr Hare if was there any other government agency that might have paid any legal costs?
I'm not aware of any payment of legal costs for
Can you-
Deputy President.
Take that on notice.
I can.
Please, thank you. We just heard that there are allegations in relation to costs being paid, and you've assured me also that Minister Cash nor any other minister have had any dealings in this matter.
I said I'd take that on notice, Senator.
Okay, can I ask you to take on notice whether there were any interactions between the Attorney-General in relation, either Attorney-General in the history of Commissioner Benet's tenure in relation to legal bills, and any knowledge that any Attorney-General might have had in regards to complaints?
I can take that on notice, Senator.
Thank you, and we're happy to now to move on.
Something. On what, to the Mr Furlong, what date did Commissioner Ross write to Commissioner Dean?
I don't have that information. Just to reiterate, I haven't seen the correspondence.
But you don't have any more questions.
Are you aware of the rough timing of it? Was it 6 months ago? Was it 3 months ago? Was it last month?
Well, the decision, the Senate decision was handed down as and please, one of my fellow officers of the Commission correct me if I'm wrong here, but my understanding is the decision was handed down on the 27th of September. So it was after that date, at some point after that date.
Thank you, Mr Furlong. You mentioned that maybe someone else could assist you from your team. Is there anyone else got any more, can shed any more light? All right, thank you.
Okay, I believe there are no more questions for the Fair Work Commission. Thank you very much, Mr Furlong, and all other officials. You can go home. I would now like to... Do you, sorry? Yep.
Thanks as well, because it's stressful.
Okay, we might just suspend shortly. Before we do that, I'll just indicate the plan is for Senator Faruqi. You got the call first with the Fair Work Ombudsman, and after your line of questions, we'll go for the break and come back and finish off the Ombudsman. So we'll just suspend shortly while we get the Fair Work Ombudsman on the line. We'll recommence with the Fair Work Ombudsman. Welcome along. So, Ms Parker, did you have an opening statement?
No, I didn't. Thank you, Chair.
No problems. We'll get straight to questions. We're going to Senator Faruqi remotely.
Thank you, Chair. Good evening, everyone, and thanks everyone for being with us at this time of the night. Ms. Parker, I want to ask you some questions about universities. And I have to say, I really welcomed your recent remarks at a TEXA online webinar on 28th September, where you spoke about underpayments in universities. And you particularly pointed out the piece rate style performance benchmarks, such as those containing policies, guidelines, or local operating rules relating to marking, lecture attendance, and student consultation, which are most likely in breach of the relevant enterprise agreements. And I was quoting from you there a little bit. I understand that you're currently investigating 14 universities. Would you say a majority of those institutions, or possibly all of them, are applying these kind of piece rate benchmarks, which are likely in breach of enterprise agreements?
Sandra Parker, Fair Work Ombudsman. Thank you for the question, Senator. So what a number of most of the universities have self-disclosed to us, and by that it means that they have come to the Fair Work Ombudsman of their own volition and told us that they are either undertaking audits or they're seeking our advice on what to do an audit. So I think in the webinar I said that I had written to all the universities, the vice chancellors and the boards, the councils, and I had suggested there could be an issue, that we were starting to see a pattern of underpayment against of enterprise agreements not being adhered to, and I asked them to audit their own payroll, and so a number of those universities have responded to my letter and said that they were instituting audits in response to that, and others had already started the process and informed us. So in answer to your question, we investigate each one of them. So 14 is what we have said we are investigating. If there are others that come forward, then we will investigate them as well. But at this stage, I can't say whether they all have the same issues. There does seem to be a pattern, and what we have identified, and I pointed out in my letter to them, was that what we were seeing was poor governance and management, issues with not centralising their payroll, human resources functions. There appears to be a lack of investment in payroll time recording systems. There's an issue around this, as you mentioned, this potential to be applying piece rate style performance benchmarks, and that's around marking, attending lectures and student consultation. And we do believe that they may be in breach of enterprise agreements, but noting that each university will have its own enterprise agreement, so that it may not be a breach in all cases. But there certainly seems to be a pattern arising. And I would say the university peak bodies that we have been talking to, and TEXA has been talking to as well, have been keen to work with us, keen to find out what the issues are, and keen to assist universities to address the issue. At this stage, we're not seeing deliberate underpayments happening.
And Ms. Parker, when you were, just to clarify, you're saying there is a pattern emerging. Were you also kind of alluding to the fact that there are these piece rate kinds of benchmarks across those universities?
Yes, we're seeing a pattern of similar approaches being taken across the universities.
I mean, I think we can all agree that underpayments obviously need to be rectified and paid back. But just looking at the bigger picture, is it your view that these piece rate style benchmarks in our universities should be abolished once and for all?
Well, I think it depends. There's actually nothing wrong inherently with piece rates, and as you'd be aware, they already occur in the horticulture sector, for example, and they are agreed to.
There are big problems there as well.
Potentially, but they are agreed by the Fair Work Commission. So, they are negotiated and they're agreed and they're discussed and they're assessed. There's some complexity in them, obviously, but in this case, it's not quite the same thing. What seems to be happening here is that it's almost there's almost some logic in it, in that people are saying, look, on average, it takes X number of hours to mark an essay, for example, of a first-year student. And therefore, if it takes this amount of time, it's probably worth this amount of money. What seems to be occurring, though, is that the agreement requires hourly rates to be paid. So it doesn't allow for that approach. But that doesn't mean that the university couldn't actually go to the Fair Work Commission and ask for it to be changed so that it is more realistic with what's happening on the ground. But as the regulator, we're there to regulate what is in play. So what's in play is an enterprise agreement that says hourly rates will be paid. There's a potential that, in fact, that's not what's happening. And so that's what we are investigating, and that we need to work with the universities, because they will be, if that's what's happening, and it appears that it is in some cases, then there will be monies owed to some of those workers.
Mm-hmm. And during that seminar that I referred to earlier, you said that the Fair Work Ombudsman will take a firm approach with those who do not cooperate with us. We're investigating technology and data analytics to assess compliance on a large scale. We can and will undertake independent validation or recalculations. So I'm just interested if you can provide the committee with some information or examples about the technology or data analytics that could be used in these situations.
Yes, and it's just so part of the challenge we have as a regulator is complex payroll systems, and because we have been seeing an increasing number of large corporate entities, for example, and universities as well, self-disclosing underpayments that go back many years. They involve, obviously, reams and reams and reams of potential payroll data, each individual worker, records, all of those things are quite complicated. But we are working with some external companies to automate some of our assessment, and we're also building our own capability within the Fair Work Ombudsman to do that. So what that means is when we get a lot of information through a notice to produce, or they might hand it over voluntarily, and that could include their audit and how they decide to go about that audit. We don't have to spend hundreds of hours going through spreadsheets line by line. Algorithms can be developed to assess whether or not it looks like there's underpayment occurring. So when I said in that presentation that we will use enforcement where necessary, what we're seeing is that the bulk of people are coming forward voluntarily. Universities are coming forward voluntarily when they find underpayment. But we did learn about some through the media rather than through self-disclosure. And if companies or universities, if you like, if they resist telling us how they're going about doing their calculations, or they don't show us what methodology they're using, or they don't cooperate, then we will, if needed, do a full investigation, our own calculations, our own assessment, and we will take them to court if we think that is necessary and that we feel that a penalty would be appropriate.
At the moment, are there any universities that you think you will take those steps with?
Senator, I can't comment on an investigation because that would preempt our actual auditing and investigation. So at this stage, I can't comment on that.
Okay. Could you provide the committee on notice with the list of the universities that you're currently investigating? And
Yes, we can provide the list of the, I can tell you the list of universities that we have publicly confirmed. I would be comfortable to provide you with a list of the 14. I do note that we don't, there is due process. I'm sure you'll appreciate. What we try to do is not do a sort of name and shame listing of corporates or any other companies. And that's because we actually want people to come to us. We don't want them to hide underpayments where they find them. If they feel that the regulator is going to, list them and shame them, then they're less likely to come to us. And in some cases, we have actually investigated and found there wasn't any underpayment. And so to name them would be, it would be unfair, I guess I would say. So we can provide it, but we would ask that it be kept confidential, if that's acceptable to you.
Sorry, just Ms Parker, we can't take confidential information at an estimates hearing. All of the evidence must be made in public. If you think that providing the information in public would be a breach of the public interest, you can make a claim for that to the committee for us to assess.
Yeah,
or you could take it on notice for now and come back to
I'll
us.
take it on notice. Look, we've been asked the questions before, Senators, so I'm really happy to consider it. I absolutely understand that you're trying to ascertain, what we're dealing with and what we're working with. What I will say too, Senator, to assure you, is that as soon as there is any type of enforcement outcome, that might be issuing a compliance notice, which is our lower level enforcement. It might mean signing up an enforceable undertaking, and it might mean litigation. As soon as that occurs, it's in the public domain. We publish enforceable undertakings on our website. We don't hide any of that. And we certainly don't hide litigations. We announce them through media releases and the like.
Well, I know you have taken that on notice, Ms Parker, and I would point out that quoting or referring to law enforcement investigations can be a grounds, but I'll let you take that on notice. Sorry, Senator Faruqi.
yeah, and if you could also provide on notice the number of staff at each of these universities you're investigating who may have been underpaid, if you have that. And so I'll leave those.
We probably don't have that, Senator, because it's dependent on where each of them is up to. And also we do expect, I think it's only fair that we expect universities to do their own assessment, pay for their own auditors, and for them to determine what the underpayments are. Obviously, we want to check methodology and assure ourselves as the regulator they're doing that correctly. We expect them to consult with the workers. We expect them to be transparent with those workers about what they're doing and with the university and so on. So I don't think I would be able to provide, a list of how many workers, for example, at each university. I don't think the information exists.
So that information will not be disclosed to you?
So if we have an enforcement outcome, you would generally be they will provide that information to us, assuming they are fully cooperative.
Yeah.
And if there is an enforceable undertaking signed up and negotiated with the Fair Work Ombudsman, then we generally would be listing the workers impacted.
Yeah, so that's what I'm asking. If they have provided that information to you, could you take it on notice and provide that to us?
I'll take that on notice, Senator. Thank you.
Thank you. You may have followed, Ms. Parker, some of the recent parliamentary hearings on these matters, including the Job Security Committee and Underpayments Inquiry. Some of the university senior leadership have been quite defensive and dismissive of the extent of this problem as I questioned them during those hearings. Is that a position that you have encountered so far in your work, or I think you've said before a little bit that there has been cooperation, and is that the case?
Senator, I think it's probably fair to say that I did write to them, I think the end of 2020, I believe, It has taken some time for universities to start to respond to that. I didn't get a lot of response to my letter, for example. What I can say is that in recent times, they certainly are taking the issue more seriously and looking into it. But I think it's probably fair to say in the early days they didn't necessarily believe that it impacted them. Not all of them, of course, but there was a view. And look, in their defence, they have been incredibly busy during COVID, and it's been incredibly difficult for universities. We are aware of that.
Sure,
but I am pleased.
Yeah. Sorry,
I'm pleased with the
response. Very different. Yeah. Sorry, you finish.
No, I'd say I'm pleased with how they're responding now. And what I would assure you is that the impact of COVID on them is not a consideration other than, we may discuss timeframes for paying back money if there's an issue with companies, but they still need to pay back what's owed.
Senator
Yeah,
Faruqi.
it's very difficult for the staff as well. Chair, I just have two more questions.
Okay, all right, let you finish if you can briefly. Thank you.
Yeah, I mean, I know that it has been very difficult for the staff who've been underpaid and whose wage has been stolen. I just want to ask briefly about casual conversion, if I may. We know about the inextricable relationship between casualisation and wage theft, and you would have seen evidence reported in various publications about the impacts of the recent changes to the Fair Work Act on casual conversions at universities. So as far as I know, that 69 staff at the University of Sydney were offered ongoing employment out of more than 4,000 that were assessed, and 72 staff at Melbourne were offered permanent employment, where there were more than 5,000 casual staff. And on top of this, as I understand, many staff who were not offered a conversion to a permanent position received emails where even a reason was not given. And worse still, they were sent form-type emails where the university's human resources had the word reason written, where they should have inserted the actual reason. I'm just wondering if you're surprised by these low numbers of conversions and how this was communicated. And does this suggest that some legislation needs to change to ensure that more casuals are being offered ongoing work?
Senator, I can't really comment because it is a matter for the employer and we apply the law as it stands. So I can't really comment on whether that should change or not. We just, as I said, we don't have an enforcement role in that area. What we try to do is provide as much information as we can and to talk to all the relevant stakeholders about the casual information statement and what's required. We continue to, we provide assistance. We obviously have a dedicated website and lots of other information, but in terms of how it's working in practice, that's something for government, really.
What do you think the revelations of these underpayments, wage theft, and increasing casualisation of the university workers tells us about the business model of universities?
Again, Senator, I couldn't comment on that. Casual work is allowed in the Act. There's nothing inherently wrong with casual work. It's part of the way many people choose to work. I couldn't.
But it has been linked very closely with the underpayments, though, which you are investigating.
In this case, in the university sector, that does appear to be the case. Yes.
Okay. Thank you very much, Ms. Parker, for your responses, and thanks, Chair.
Thank you, Chair. Thank you, Senator Faruqi. Now, I did say we were going to break, but Senator Sheldon has to go at 9:15. Just checking with Hansard, is that okay? We pushed through to 9:15 or so. Senator Sheldon, you have the call.
I just want to thank the Chair and also Hansard. I just want to go, just following through on the questions from Senator Faruqi. Some reports have put it as high as 21 universities out of 40 public universities is or have been investigated. And that includes, Ms Parker, as I understand from investigations that the National Tertiary Education Union is carrying out. Is there any industry you can think of that has a higher incidence of wage theft than higher education at the moment?
In terms of, I'm sorry, I've just gone dark.
We can see
Mr.
you.
Fogarty.
We can see you.
Thank you. I'll probably do better in the dark. I can't read my folder though. Senator, it's we certainly. How can I answer? Thank you, Chris. Thank you. Look, we're not happy with the university sector. Obviously, working with them, working through these issues. It is taking up a significant amount of our time, it's fair to say. We have had to develop a specific strategy to deal with these issues. Part of that is working with universities and stakeholders, Universities Australia, National Tertiary Education Union, Australian Higher Education Industrial Association and others to try to get on top of it. But I share your concern. This is incredibly disappointing and it shouldn't have happened.
Yeah, and thank you, Ms. Parker, because it is, as you're rightly pointing out, it is concerning. And I'll just add that half of our public universities are currently under investigation. According to the Department of Education data, 2/3 of university staff are either casuals or on short-term contracts. A lot of the casuals and those being paid piece rates to mark students' work. Is this where the bulk of the wage theft is occurring? Is it with casual staff?
That's our they're our initial findings, yes, Senator. And then we obviously need to look at each university on a case-by-case basis. That's how we, as a regulator, need to investigate, and that's what we're doing. But we're certainly seeing a pattern.
And are you aware whether, from your investigations or your team, whether there's a number of casuals that have been wanting to speak up about underpayments and are now speaking up? And I'm talking about over a period that they've been working there for a period of years and claiming underpayments. In terms of number of complaints we've had or requests for assistance, I'd have to take that on notice. I don't think I've got that in front of me, Senator, in terms of the universities. So I probably can't answer that at this point, but I can take it on notice. Thank you. Can I ask some more of a qualitative question then? Are you aware of those that have come forward, whether they have been working at the university and being allegedly, in some circumstances, actually underpaid, that have been working there for a number of years under those conditions?
We're certainly hearing that through media and other reports, but at this stage we're working with the universities and working through their audits. So we're not specifically speaking to casual staff at the moment. If there's litigation, obviously we want to look at witnesses. We want to talk to staff. But look, I expect that to be the case. Yes, in answer to your question, I expect it will be the case. Sorry, I'm not sure if I'm answering you exactly as you would wish. I think it's fair to say that many of these underpayments will go back many years. Is that what you were?
That's part of the question. Thank you for that. I appreciate it. Now, so if most of the wage theft at universities is impacting casuals, wage theft would be less prevalent if academics were in a more secure employment, wouldn't they? I'm not saying people don't. There are people that wish to be casuals. I fully understand that, but that doesn't mean a casual can't have secure employment.
Well, I suppose with the number of investigations we've been doing into corporates and others, we're not seeing a particular pattern that I'm aware of with casuals. I mean, any worker can obviously be underpaid and they're not necessarily casual. So I probably can't answer that question directly.
Can I just let's just tackle it a slightly different way. If the reports are that casuals are reluctant to talk about underpayments because of fear of persecution, intimidation, termination, where underpayments have occurred. And there are good companies out there, fully aware of it. This is talking about these companies and, in this case, universities that aren't doing the right thing. If those casuals were in secure employment, do you think they would have come forward earlier?
I don't, well, it's difficult to say, Senator. We don't necessarily describe casuals as being insecure. Not in the same way. Our description of insecure, well, it's not even insecure. We define sort of vulnerable workers, and in that category we would put, visa holders, young people, people who don't have English as a first language. I mean, I would hope that. I mean, we have a lot of people who contact us anonymously. If they have any fear, then they can do so without having to even identify themselves. We have not seen a pattern of university casual staff coming to the Fair Work Ombudsman for assistance. So as soon as we became aware of this issue through a few self-disclosures from universities, we started to look more systematically into the issue. But they hadn't come forward. If they felt they couldn't come forward, then that's disappointing. And I guess here's an opportunity for me to say that if you want to come to the Fair Work Ombudsman and talk to us anonymously and be comfortable in that, we really welcome the conversation.
Just of interest, I'd probably apply this both, and there may be a different answer for them. But to me, on the surface, there seems to be some consistency of problems. There's this high degree of wage theft that's going on for casuals in universities. There's also a high degree of exploitation that has been found by the Fair Work Ombudsman in horticulture, where people are on piecework in both circumstances. Would it be easier to actually pursue and calculate out underpayments if those people were on hourly rates?
Piece rates are complicated in horticulture, and I think it's fair to say. We've provided some guidance on how to do that, but it is crop by crop assessment to determine what the piece rate is, so it's more difficult. I think in the case of the universities, piece rates are not allowed under most of these are enterprise agreements that don't allow piece rates. So they are breaching their own enterprise agreement.
That's significant.
Whereas with the horticulture sector, they are allowed to have piece rates.
Thank you. And I've got no further questions, Chair.
Okay. Well, we'll take that opportunity. Thank you, Senator Sheldon. We will have a short break. We'll come back at 9. We'll come back at 9:30. That's the time it was. Okay. Suspended till 9:30. Senator O'Neill on teleconference remotely, so we are a quorum. We're ready to go. Good. Okay, we'll recommence with Fair Work Ombudsman and Senator Roberts. You have the call.
Thank you. Can you report on progress and uptake in regard to the Casual Employment Information Program you manage, including employment conditions? And has the education for both business and employees on their rights and obligations reduced complaints by casuals? And thank you for attending.
So, is someone able to answer that question? If someone wants to...
Sorry, Sandra, we can't hear you, so we don't know whether you're able to hear us.
Okay.
We heard something.
Sorry, could you repeat the question?
Yep, got you now. And so, Senator Roberts, could you just repeat that?
Sure. Can you please report on progress and uptake in regard to the casual employment information program you manage, including employment conditions, and has the education of both business and employees on their rights and obligations reduced complaints by casuals?
Would you like me to handle that, Ms Parker? Thank you. It's Kristen Hanna, the Deputy Fair Work Ombudsman for Policy and Communications here. Thank you, Senator. I'll give you an update on how our communication in terms of the casual changes has been progressing, and give you some information in terms of the number of people that we've received and the sorts of feedback and impact that we're seeing from that communication. As you know, we published new content on the 29th of March. We updated our casual employees webpage. We developed a new webpage with information on casual conversions. And between when that was published in April and the 31st of August, it's been viewed 77,000 times, which is quite an extraordinary number. We also published the new casual employee information statement and developed a new homepage for that. And since it was published on the 29th of March to the 31st of April, that's been viewed 1,610 times. 161,000 times. We've done 3 rounds of updates to that document. On the 20th of May, we took some feedback from stakeholders on clarity and made some changes to the document. We did a small change on the 9th of August after a user contacted us and gave us some feedback again on clarity. We did some user testing, and on the 26th of this month, of August, we updated the statement again. It's now being translated into 38 languages, and we'll be doing some promotion in language at that time as well. In terms of promotion, we did some promotion via stakeholders in April. We also sent a direct email to our database of 640,000 subscribers. In May, we did a paid digital communications campaign that went over 3 weeks. And that focused on accommodation and food services, employers and employees, retail, healthcare and social assistance. That was focused on Facebook, LinkedIn, maximising Google search and also digital advertising. And that was seen 5.9 million times, which is quite an extraordinary reach. So that's impressions. So that's the number of times the content was displayed on various screens. I've got some information here in terms of breaking that down into how many people looked at it through different channels. Just by way of example, in terms of Facebook, when we look at the Facebook component of that really broad campaign, which is quite a big campaign, we received 380 comments on the content. 1,124 reactions, so that's likes on Facebook, and it was shared 405,000 times, and that's just on Facebook alone. So that's compared to other campaigns, that's a really deep engagement in terms of that content. When the transition period ended, which was the 27th of September, we did another round of communications. On the 17th of September, we did some reminders on our website. On the 20th of September, we sent another email to our 640,000 subscribers. And on the 24th of September, we did another round of social media posts. And we boosted those posts so they appeared in people's news feeds again. We don't have any stats back from that campaign. They take a little bit of time to come through. But we're seeing that was very successful. So we're getting lots of engagement in the content, and we're reaching a lot of people. So we're finding that to be very effective. The sorts of comments that we're getting through on social media is that people are finding the content easy to understand, and it's really hitting the mark. And that's what our stakeholders are telling us too.
Thank you very much. Has there been, can you tell us the distribution over time? Was it a rapid engagement early on and then a falling off, or was it a gradual build-up, or was it increase and then flattened off? Just roughly.
Yeah, I'm just having a look at the stats here. It's pretty consistent, Senator.
Thank you. Could you please report on the number of requests for information and complaints, if any, received in relation to the new casual conversion provisions? And in short, is it working? And if it isn't, then what can be done to fix it?
Senator, we're not seeing a lot of disputes or complaints at this stage, and I wouldn't expect that we would be, because the transition period is just coming to an end. So it's a little bit early to be making any conclusions in terms of that. Also, that would take quite a long time to trickle through to us because there's a range of other dispute mechanisms in terms of resolving those disputes. So the first point of call would be people would need to look at their award or agreement and see what the provisions are to resolve disputes within those provisions. And if there's not a process, then the first point of call is the Fair Work Commission. So there's kind of two steps of processes before disputes would get to us. As I said, it's very early days.
Okay, thank you. We've been supporting casual workers getting a fair go for a while. What more can the Fair Work Ombudsman do to support casual employees, especially in regard to both understanding the impact of the recent change, improvements in pay and conditions, and to casual conversion? And if this is not violating the conduct of the Senate estimates, are you, in terms of not requesting an opinion, but can you see any pointers to improve industrial relations generally? Because some people go into casual work, both employees and employers, because of the problems with the industrial relations system in this country at the moment.
So, Senator, I'll just respond to that. In terms of how we can assist, I think our job is to continue to review our products and the information that is going to the community. And if we take suggestions on board at any time. So if there's suggestions on how we can get the information out more effectively, obviously we really want to hear it. And we'll keep consulting on that. We'll keep on talking to every stakeholder that we deal with. We'll keep on making sure people are aware that this exists. In terms of the workplace relations framework and improving it, Senator, we can't really comment. It's not a matter for us. The Parliament decides what the legislation is, and we.
Sandra, you've gone mute.
Sorry, Ms Parker, if you can hear us, Ms Parker. You there, Ms Parker? You've gone on mute. We've just lost the audio about 10, 15 seconds ago. Now we've lost your video as well. Are you there, Ms Parker?
Yes, I am.
That's better. We got you. So we only missed about 15 seconds or so, if you wanted to finish that answer.
Yeah, sorry, that we all seem to drop out. So I was saying that we will continue to seek feedback on the advice we provide, the resources we provide. We'll talk to stakeholders, and we're obviously very open to getting feedback on the way, not only the material itself, but that we have on our website, but also the way that we promulgate that material and get to more people. The more people that know about it, the better, obviously. And I did say that in terms of commenting on improving the workplace relations framework, we can't really comment on that as the regulator. It's our role is to regulate the law as it stands, and it is for the Parliament government to determine what that law is.
Senator, if I might assist you, you'll be aware from the passage of the legislation that there is a formal review requirement in relation to the casuals terms within the Fair Work Act. It's due to commence as soon as practicable after the 27th of March next year. But in relation to the questions around casuals and why they take it up and their views of it, earlier, in evidence earlier today, I talked about additional funding to the ABS to undertake further work, particularly in relation to gig. But in addition to that, the ABS has also been funded to undertake further work around casuals and more qualitative work in terms of actually why do people do casual work. So that process will hopefully lead to better information collected by the ABS to make sure we've got a good evidence base for that.
Yeah, I understand your point, Ombudsman, about the Parliament having the responsibility to identify and rectify problems with the industrial relations system. Sometimes, though, Parliament is sitting in a vacuum and doesn't really understand what's going on. And I was critical of the Ombudsman's office with regard to the Hunter Valley casual coal miners, because there were lots of issues flagged there that Parliament should have known about a long time ago. That's all. So I see the Ombudsman's office as a way of collecting those issues. If people come to you with them, it's not your responsibility to do anything about them, but it is, I would see your responsibility. I'm looking to Mr Hare for telling me whether I'm right or wrong, that feedback can come through to the Fair Work Commission and to the Industrial Relations.
Certainly, the Fair Work Ombudsman has a range of information collection tools in terms of where complaints and the subject matter of complaints, etc. And we certainly, as a department, engage closely with the Fair Work Ombudsman about that information. But the point I was making is that there's also other methods that we're looking at. So in relation to the information we're collecting on casual employees, the intent is we'll collect the information on the extent to which casual employees are converting to permanent employees through ABS data, and also at firm level and individual level, what barriers and incentives there are for that, and the reasons that people work as casual. So that project has started in terms of the work with the ABS, but I'd need to take on notice the likely timing for that information to be available.
Okay. Just a final question, Chair, a brief one. Just building on what I was saying a minute ago, Ombudsman, the Fair Work Ombudsman should be there to assist all workers, whatever they do. As you know, we think it's time for a review into the industrial relations system problems that led to abuse of casual coal miners, to some extent in Central Queensland and especially in the Hunter Valley. Are you able to support an initiative that seeks to close the gaps for these affected workers because they're still existing?
Senator, so we're certainly aware of the issues you've raised. I mean, what I would say is that part of the issues we've discussed with the casual coal miners is around their agreements. So I think, look, I'll answer generally, because probably all I can do really is to say that where we see issues, we're very happy to raise them with the department, and we are, as Mr Hare said, we are consulted when there's proposals for new legislation, when there's proposals for amendments. We're consulted on what the impact of that would be. So what would it mean for us as the regulator? What would be the flow on of that legislative amendment, and whether there would be unintended consequences, but also what information we have. So how many complaints do we get in that area? What sort of issues do we see? All of that we would provide. So we're more than happy, obviously, to be part of any of those consultation processes, and we'll provide the department and government with whatever it asks of us in that regard.
Senator Roberts.
Thanks, Chair.
Thank you very much. I was about to ask, so thank you. Senator Pratt, have you got some more questions?
Thank you. Ms Parker, last week it was announced that you had recovered a record $148 million in wage theft over the last year. Is that amount of wage theft that's happening in Australia, is it increasing?
Senator, it's difficult I couldn't comment on whether it's increasing. What I would say is I believe we are being more effective in recovering underpayments for workers, and we're doing that through taking a very targeted and intelligence-based approach to our compliance and enforcement. And as you said, we've put $150 million back in the pockets of 70,000 workers last financial year, and that's a record for the agency. And we'll continue to pursue that. So I think we're very focused on this issue.
Terrific, thank you. So that record number is a 20% increase on last year, almost 5 times the amount recovered 3 years ago. So in the context of whether it's increasing, or you're essentially stating that you think you're just recovering more of what the existing problem is, are you able to characterise the extent of wage theft that you think we're now getting to?
Senator, we've been asked this before in hearings about what do we see as the extent of wage underpayment. I still, despite being in this job and seeing a lot of underpayment for the last 3 years in this role and in my role in the department prior, I'm still of the view that the majority of employers are trying to do the right thing.
Absolutely, but you're still unable to say what you think
what the extent is.
So do you have data on the percentage of employers that represent the 20%, the number of employers that you've got to in that 148 million? Must be only a tiny proportion of the number of employers in Australia.
So, Senator, as I said before, the proportion of employers is, in my view, not the focus, and that is because we target our work, our compliance enforcement, based on intelligence. And by intelligence, I mean requests for assistance, our own research, information we get through working with stakeholders. We don't randomly choose employers to audit, because I consider that would be a very inefficient use of our resources. Absolutely. So to be a good regulator, we hone in and we target, and on that basis, it is just not realistic or useful, I guess, to say.
I guess that wasn't my question. My
I
question
apologise.
My question was really around how much wage theft is still out there that you're still not able to get to, and you've said essentially you can't quantify that. But in terms of but you've said that the amount of wage theft you think has been consistent. So in that context, did you have enough resources before, or have you just increased your intelligence? You've had a lift in resources to be able to do more on wage theft. What could you do with more resources?
Well, I suppose it's a difficult question to answer, because what we need to do is what we need to be is as intelligent as we can in how we use the resources that successive governments have determined we should receive. So I have never done an assessment of if we had X number of more inspectors, for example, that we would uncover X number of underpayments.
Could I ask you to take on notice, please, the quantum of resources that you apply to wage theft now compared to what it was 3 years ago?
So, Senator, I can talk to you about our resourcing and how it's, what we have and what's changed. I think the main thing here is that we use our resources as intelligently as we can. I mean, it's probably important to say that every request for assistance that comes to us, so in other words, every person who phones our info line or contacts us through our website material, through anonymous, we respond to them. So there's not a queue of people out there who are not getting assistance from us.
Has the number of
In
people
terms
reaching out increased?
I might ask Mr. Scully if he can answer that, if you wouldn't mind. I don't have the data in front of me in terms of the numbers of requests for assistance comparison, but he may have it if he's on the line.
Mark, you're on mute.
Mr. Scully, I think you're on mute.
How's that?
There you go.
That's better. Sorry about that technical issue. Apologies. Thank you, Ms. Parker. Mark Scully, Deputy Fair Work Ombudsman, Compliance and Enforcement. So what I can advise the committee is that in terms of requests for assistance for the 2021 financial year, that being the year ending the 30th of June 2021, we finalised 18,696 requests for assistance, that is formal disputes, which is actually a reduction from the previous year, but our intelligence and our information indicates that a large part of that reason is due to reduced numbers of visa holders in Australia due to COVID, and they represent a large proportion of people coming to us for inquiries and assistance. So, in direct answer to your question, 18,696 formal disputes completed in the last financial year.
And what was it 3 years ago in 17-18?
In 17-18, it was, based on the numbers I have, it was around 28,000.
Did you conclude investigations into those 28,000, or why, if there was 28,000 then, was there not as much money stolen, or did you not conclude all of those cases?
Yeah, so it was a different operating model that we had back then. So what we're doing now is we've tightened our enforcement posture. So we're doing more of the more detailed investigations into complaints that come into us. So, for example, for last year there was 22% of those requests for assistance that were completed through compliance and enforcement activities, notably compliance notices, infringement notices and the like, rather than through the provision of advice and dispute resolution services. Hence they can lead to increased recoveries also.
And can I ask, in terms of 28,000 in 17-18 and 18,000 this year, what's the dollar value that the Ombudsman has put into resolving those cases? Is it about the same across those years?
I would need to check that, Senator. I'm not quite sure what our budget was and our resourcing level was in 2017-18. My recollection is that for a while we were on a reduced resourcing allocation, but we are very appreciative of some additional funding that we've been provided by government over the last couple of years. So I would just need to check
with
what
more
the actual
resources,
numbers were.
if you were to revisit some of those 28,000 cases from 17-18, do you think you could recover money for those people if you applied the same procedures as you do now as you have this year?
I would need to look, Senator, at the composition of those 28,000 and compare them to what came through last financial year. One difference we do have is that included in our recoveries this year are self-reports, where we have a number of large corporates that are coming into us and self-reporting. So it would require a detailed analysis, and I haven't got that in front of me.
Okay, from a public policy point of view, that analysis is important. Could you take on notice, please, of the 148 million, how many of those are self-reports from employers?
I can, Senator.
Thank you. In terms of your annual report, it states you've got priority areas, and these have been touched on already: fast food, restaurants, cafes, horticulture, and soon to include contract cleaning. I note that all of those sectors workers are more likely to be engaged in non-standard forms of work, casuals, subcontractors or short-term contractors. Does the Ombudsman's Office have a view that there's a correlation between less secure forms of work and the likelihood of wage theft?
Senator, I think that's we would say there's more vulnerable workers working in those sectors, and yes, I
Sorry,
mean, whether,
is it the contract that makes them more vulnerable?
Well, it's a range of things. I mean, with cleaning, for example, you often find that they are operating in a supply chain, and there are many visa holders or migrant workers who work in cleaning businesses, and that
But if they were on a permanent contract and not as concerned for the longevity of their employment because they knew that they would have a job in 3 or 4 months' time or a year's time, do you think that would empower them to voice their concerns?
Well, possibly. There's a whole range of reasons why people might be reluctant to come forward. Our experience is that it's not one single factor.
Do you have
Visa
data
holders
on the type of contract that someone is under and the nature of the wage theft that takes place?
We have information on some types of work, so we've got some labour hire statistics. We've got data on. We don't break down each one of our requests for assistance though into that. They don't always tell us exactly, whether they are, on a visa, for example.
I'm not asking about visas. I'm asking about the nature of the contract.
Yeah, so you're asking me whether being casual or makes you inherently at higher risk. Is that what you're asking?
Yes, of wage exploitation.
It in some cases quite possibly, but it's not an absolute black and white question, Senator. It's very difficult to answer.
No, I understand that. I'm asking, given you've got $148 million worth of recoveries, whether there's data behind that as to the nature of those contracts.
So one of the $150 million is obviously record for the agency. Mr. Scully said quite a proportion of that was through self-disclosures. Self-reports were $81 million of that.
Can I ask the department perhaps, thank you for that $81 million. Can I ask, does the department have data on, of all the people working in Australia, if you've got data on the types of contracts they're employed under? We know that casual work's increased.
We have percentages.
Yep, you do? And do you have, so you've got percentages for the whole country?
Senator Pratt, just in the interest of time, we did cover this in quite detail this morning.
We did.
And just wondering how long.
Well, I'm asking I guess I'm trying to compare that data to the types of contracts that people are in if they're exploited. And from that point of view, the data the Ombudsman has is probably relevant to make that comparison.
What we have is workforce data. We don't have it against each one of the matters that we investigate, for example. Or if you're looking for the breakdown of the 150 million and of how many of those were independent contractors and how many of them were casuals, we don't have that data. What we do have is the proportion. Obviously, we have the proportion of casuals across the whole workforce, for example.
Okay, so you've got the proportion of casuals across the whole workforce, but not the proportion of casuals represented in your wage theft recovery or reports of wage theft.
No, that's right. We don't do that analysis.
Is that analysis possible?
And just to clarify, Senator,
no, I don't think.
The evidence we gave earlier was that proportionally the rate of casualisation has been consistent for in excess of 20 years. The statement that it's increased needs to be taken carefully. Proportionally, it's actually slightly lower at this point.
I'll go back to my original question, which is about whether wage theft is inherently attached is more likely to be attached to insecure forms of work. It's, I would assert that it is, but I'm looking for whether anyone's looked at the problem in government agencies or in the Ombudsman's office.
I think it's a difficult question for us to answer, Senator, because we don't define insecure work the way that I think you do. So being a casual is completely acceptable under the Fair Work Act, as is being an independent contractor, as is being a labour hire worker, as is being, all of those things are perfectly acceptable. So we don't judge them as being insecure.
Okay. What can you tell us about the nature of contracts that might make someone more vulnerable to wage theft? Is it because they don't have a contract, because they've got an abnormal contract, because they've got a contract that's not attached to an EBA or an award?
Yeah, if they're being defined as an independent contractor and in fact they're an employee, then clearly that is a vulnerability, and that is something that we look at. And one of the things that we investigate is misclassification or sham contracting. We have a sham contracting unit that looks at those particular issues.
Are you able to tell us of the 148 million, how much is attached to sham contracting?
We may be able to take that. If we could take it on notice, we'll certainly try to assist you, Senator.
Thank you. In terms of piece rates, the horticultural sector's been in a focus area. Can I ask, in terms of other factors like the prevalence of temporary migrants, is wage theft in horticulture more common in relation to workers on piece rates? We touched on this before. You said that it's not inherently, piece rates aren't inherently bad, but again, I'm looking to whether in terms of the kind of contract someone's under, it is inherently more likely to have wage theft attached to it.
Then other forms of arrangements, do you mean, Senator?
Both in horticulture and in terms of, yes, in terms of other arrangements. If you're on, what kinds of contracts are likely to be associated with wage theft? Is it more common in horticulture in the context of people being on piece rates?
We have identified priority areas that you indicated you read out earlier, and that's on the basis of our assessment that, yes, there's more vulnerability in those sectors.
In horticulture. So how predominant is a piece rate within horticulture as a form of a contract?
It's very common.
Okay, so in effect, when I ask, is wage theft in horticulture more common for workers on piece rates, are you essentially saying that horticulture is a target area because it has more piece rates and therefore it's more likely to have wage theft? Or is there something intrinsic about horticulture that makes it more likely to be subject to wage theft?
So the reason that we have highlighted these areas, these priority areas, is because they fit a whole range of characteristics. So it means they're areas that we have vulnerable workers where we get a lot of complaints usually. Although horticulture is interesting, we don't actually get a lot of complaints, not compared to some other sectors like fast food restaurants and cafes. But you're more likely to have people who are, as we said, on visas, less likely to come to us for help. There's issues running in the community about them, and we select them on a whole range of different bases, but we also consult with stakeholders. We ask them, where should we be putting our discretionary effort, I'll call it, our proactive effort? Because I said to you earlier, we respond to every phone call request for assistance we get. That's what I would call reactive. And then we have a whole series of work that's on proactive, and that's where our priority areas come into play.
I understand that, but I'm trying to drill into the data around the types of contracts people are in. Joanna Howe, who's an expert who's previously done work for your office, she said, the data from my research has supported a finding that piece rates are generally set at levels which means that workers who are on a piece rate don't earn at least award minimum rates. They're paid well below the award minimum, generally earning less than $15 an hour. Is Dr. Howe right in your experience?
So I might refer you off to Mr. Scully or Mr. Ronson to answer, because they dig into this quite a lot.
Thank you, Ms Parker. So I will pass to Mr Ronson in a moment, who is our expert in piece rates. But further to what Ms Parker was indicating, there are a range of reasons why horticulture is one of our priority areas, and that includes the nature of the work, which is often low-skilled and seasonal, the way
Sorry, that
labour is
wasn't my
procured.
question. My question is, are piece rates set at levels which make it difficult or impossible to earn at least the national minimum wage? That's not really a question of your visa status, it's a question of how fast you can pick a bag of fruit and whether anyone on average is, I understand that it could be rewarding for someone who's really fast, but actually if it's impossible for most workers to earn that rate, what's your take on that specifically? I don't think your ethnicity or visa status matters.
No, the Fair Work Commission has determined the piece rates for the different awards and determined that it is possible. And that would be our answer. Yes, it is possible.
Okay,
for
so
the average worker.
there's an application before the Fair Work Commission to amend the Horticulture Award to introduce a pay floor for workers on piece rates. If that floor did exist, what difference would that make to the kinds of issues you've seen in horticulture?
Look, it would probably make the regulator's job easier in that piece rates are, as I said, crop specific, and you have to work out what the average competent picker is, and obviously farmers are expert at doing that, and that's what they negotiate. It would probably make our job easier, but that's not necessarily why awards are created.
Well, no one wants lazy workers. Clearly you do want to get a minimum amount of work done, but equally you can't ask your staff to do the impossible.
No, that's why there's
I
an
can
average
imagine,
competent
yes, on
picker.
one hand it might be difficult to set an award, but surely it's just as difficult for you to work out whether a piece rate is fair in terms of the fact that, according to the data from the research of Dr. Joanna Howe, she has asserted that the rates are set at levels that mean workers don't earn an award even if they're reasonably productive.
Without going to the evidence in Dr. Howe's, I suppose it is important to note that in general piece rates are meant to be set at a level where a competent worker can earn more than the base award rate. I think in most instances it's 15% above.
So do you reject... I understand what you've said and that's enough. Dr. Joanna Howe said that her evidence shows that those piece rates are set well below the minimum award wage, generally earning less than $15 an hour. Are you asserting that those workers are unproductive or that her data is wrong?
I was very clear that I wasn't actually going to her data or her evidence. What I was going to was actually what the requirement was in the actual awards that allow for piece rates, that the piece rate needs to be set at a level where the average competent worker can achieve at least 15% above the award. If they can't do that, they're meant to be paid the award. So,
okay.
So so I'm not disputing the evidence at all. I haven't looked at it or considered it.
Does that mean the government will support an application in terms of the government putting in a submission to support the amendment of the Horticultural Award?
So, Senator, the only time that we would normally intervene in a setting of an award is where we've got additional evidence to provide. In our view, the parties in the matter that I think is currently adjourned before the Fair Work Commission are fully capable of providing the evidence. We're not sure we would have anything additional to
Okay,
add.
so you don't have anything additional to add, but you think that there's work to be done to assess whether the award minimum is in fact delivered in the use of piece rates.
I would absolutely agree that it's completely appropriate for this matter to be before the Fair Work Commission. The parties should argue it, and of course the Fair Work Ombudsman should continue to see whether people are actually being paid properly.
The Fair Work Ombudsman, I know you've previously conducted investigations into working holiday maker visas. Dr. Howe has asserted that visas holders are more vulnerable to exploitation than workers on the more regulated Pacific Labour Scheme or seasonal worker program. Is that in line with the view of the department or the Fair Work Ombudsman? So it might not be in the purview of the department, but you acknowledge it's regulated. How do they compare?
So, Senator, we regulate those programs, and we work really closely with the department that administers the departments that administer those programs. They're more formalised, and there's a lot more scrutiny of them. I mean, I would say the difficulty with individual visa holders, for example, working in horticulture is they are working individually. They can be nervous about coming to us as individuals. There is going to be inherently more protection in a program because they'll get more information as a group and they'll work together as a group and they can educate each other. Those are just things that occur, but we regulate all of that. So we have a horticulture task force in the agency. We work on seasonal worker, Pacific Labour. We do all of that as a priority.
So nobody's saying they're not legitimate forms of work. We're just worried that they're being abused so that employers can avoid their responsibilities and avoid paying the minimum entitlement. Can I ask if the Fair Work Ombudsman, if you've got evidence that demonstrates the rates of pay for Pacific Labour Scheme or seasonal workers versus the other horticultural workers that have come to you?
Well, those that are on those programs,
it's well regulated. So, how much below how much below those rates of pay are the workers that you see?
I'm not sure we can answer that specifically. I can talk about how much we've recovered for workers and how many investigations we've done across those schemes in terms of comparing the difference. I'm not sure we would have that information, Senator, but I can ask Mr. Scully or Mr. Ronson if they can clarify.
Steve Ronson, Executive Director of Enforcement. Hoping that you can hear me.
Thank you, yes.
And we would be able to extract some data from our system over, to try and compare rates, but that would be, it would be a difficult exercise to sort of draw any particular conclusions from it, because it really is, as Sandra, as Ms. Parker's been sort of outlining, it's going to be a case by case, crop by crop, season by season, what part of the, sort of picking cycle are you
but surely that kind of data would be useful to the application before the Fair Work Commission to create a floor.
I suppose the way I'd frame it, just in terms of the questions you've been leading, is the Fair Work Ombudsman's approach is that we say, and we've been saying for years, that piece rates should not be used as a cloak for exploitation. So the way the Horticulture Award and the Viticulture Award is structured, and has been for many, many years, is that parties have the option to broker and agree upon piece rates. That's just been the law for some time. And so the leading authority on this in terms of informing our approach is the case that the most recently decided case, the Fair Work Ombudsman against Hugh and others. And that sets out detailed prescriptions, if you like, or indicia in which we can follow to work out whether the piece rates have been set lawfully. And I think as Mr. Hare was describing, it all begins with the average competent employee. And so the test really goes to, and what the decision tried to shed more light on, was how does one conduct that average competent employee test? And it really is a case by case, crop by crop, and even then within a crop or a season, you're working sometimes on limited timeframes. So it could be 2-3 weeks for some crops, some for 6 weeks. Some, for example, go the whole year round, like mushrooms is an easier one, if you like, an easier crop to work out what is an average competent employee.
But all employers, you know, need to make a judgment as to the productivity of their workers.
Senator Pratt,
I'm nearly...
Okay, 'cause we've been going for half an hour now, but I'm happy for you to keep going, just noting the time.
Yep,
People
I'm
with
going to
questions
try
for
and whiz
Cole,
through this.
Service Lady.
Minister Littleproud says that the agricultural visa is an extension of the working holiday
Senator
visa.
Pratt, just a second, someone close that door.
Is that
Yeah.
given that
Could have been us.
the agricultural visa is...
Sorry, Senator Pratt, we might just, it looks like it's died down now. Over to you, Senator Pratt. Sorry.
Thank you. The agricultural visa has been described as an extension of the working holiday maker visa by Minister Littleproud. The program he's referring to is less regulated and I believe more prone to exploitation than the Pacific Labour Scheme. Does that concern you?
Senator, we prioritise protecting vulnerable workers, including migrant workers and horticulture. So we're ready to assist with the education, compliance and enforcement to ensure that holders of an Australian agriculture worker visa receive their minimum entitlements under the Fair Work Act. So we're prepared to take action if we need to, if there's any allegations of exploitation. So we encourage people to come to us if they believe they are being exploited.
Has the Fair Work Ombudsman done any assessment or analysis on the impact of this new visa on your enforcement activities?
I believe we were consulted on numbers. I don't actually have the, as in how many we expected to be coming in terms of that visa, but it is demand driven. So as I said, we will obviously monitor people in the we'll monitor it, and we will do what we do with other sectors.
Okay, in terms of the...
Can I ask a question there? Did you get additional funds? Because you indicated earlier in your evidence that when visa holders were unable to enter the country because of the COVID lockdown, you've got a comparative data about what you were able to recover and how many interactions you had to have. So you said it reduced to 18,000 from 28,000. And you noted that the absence of visa holders reduced the workload that you have. If this scheme's coming back in, or this new scheme is going to be implemented, and it appears to be a lightning rod for exploitative behaviour by unscrupulous horticultural employers, and I use that term loosely because I don't think employers exploit their workforce. How much additional resourcing has the government given you to make sure that the if I can call them the new crop of visa holders that are supposed to be coming in actually are not going to walk into an ambush where they are immediately exploited, because that is the reality for far too many people in the horticultural sector?
So there's already been multiple visa holders across a whole range of sectors for many years. Yes, our workload reduced in terms of visa holders accessing our services, but it didn't reduce when it came to people ringing us about COVID and vaccines and stand downs and everything to do with JobKeeper. So we redeployed our staff onto those areas. Now, hopefully, as we come out of COVID, that will reduce the need for us to deploy all our staff onto COVID-related inquiries will reduce, and we'll obviously move our staff around as we need to. That's what we always do, so we will respond as we need to.
Thank you, and I'm sure that you do manage your staff well, but my question was not about your staff movement. My question was about anticipatory behaviour, given what we already know and what we've had discussed over and over and over in this set of estimates sessions, that exploitation of people on visas in the horticultural sector is rampant.
But less rampant in the regulated Pacific Labour Scheme.
Correct.
So
what are you doing about the new one?
Were you consulted about the creation of this visa and what protections might be needed in the agricultural visa?
So we work with the department, Senator. So the department was obviously consulted, and we provide, as I said before, we provide data, we provide information, we look at what it will mean in terms of us regulating a new visa, and that's the extent of what we will do.
So in the context of these tens of thousands new migrants coming in who don't have the same safeguards as the Pacific Labour Scheme, I think you're intimating that you might need to step up enforcement and, look at the strategies for that. Might you be concerned that where shady labour hire operators bring in cheaper temporary migrants under the agricultural visa that's got less oversight, that they will move to the agricultural visa rather than the more expensive, more regulated Pacific Labour hire scheme?
Well, those schemes are those regulated ones, as you call them. More regulated ones are popular, and employers have liked to use them in the past. The seasonal worker program has been very popular with employers, and I don't expect that will change. I think what I would say is we'll continue our education, compliance and enforcement work in the same way as we have for other visa categories.
Okay, and will you require more resources to do that?
Senator,
Sorry, Senator. Sorry, just some of this. So Ms Parker's right. We have absolutely been consulting with her, but I might ask Mr Manning just to give you some information on the processes to date in relation to the announcements around the ag visa, and that will, I think, help frame it.
I've just got one more question on this topic.
So the questions were about what she's been asked for.
If you can answer that, then but I'll also just want to ask for an update on Harvest Trail.
Yeah, thank you. So, Senator, the government has announced its standards in relation to the agriculture visa, which is still being developed, will be modelled on those that apply under the Pacific Labour Mobility Schemes. So,
okay, so it won't really be an extension of the working holiday maker visa?
No, it's, as I said, the government's announced it'll be modelled on those Pacific Labour Mobility Schemes, which have that range of work that Ms Parker outlined before, but the flows involved in.
I'm gratified to know that's the case. Can I ask for an update on Phoenixing and Harvest Trail?
Steve Ronson, Executive Director of Enforcement. Senator, I can confirm that since our discussion about this matter at the June estimates, we have commenced our investigation, and it's quite advanced, but I wouldn't like to make any further comment while the investigation's ongoing. Okay,
So it's still ongoing. Are you expecting prosecutions? You can't comment yet.
I can't comment. Have you got a timeline? Yes, the timeline remains that which we discussed, Senator O'Neill, in June. So we're still on track within that timeline. If you recall, it would be over the course of 6 months that we would begin the that the investigation, the bulk of it, if you like, would occur, and we'll probably be around halfway through that timeline at this stage.
Thank you. We just got some questions now on the Commonwealth Bank.
Yeah, just a quick one if I can. So earlier this month you announced you were taking action against the Commonwealth Bank for knowingly engaging in wage theft of an amount of $16.44 million. Could you explain the nature of those allegations?
Yes, sorry, I'm just, I think I might ask Ms Carey if she's there to talk about this. And Ms Carey is heading up our large corporates branch and she's leading this investigation and this matter. If she's there, that would be great. Otherwise, I can give you some general information.
I am, thank you. Senator Michelle Carey, Executive Director of the Large Corporates Branch at Fair Work Ombudsman. Obviously the matter's before the court, so we can't say too much about it, but in relation to the allegations that have been made, I can take you through those. The allegations that relate to the knowledge-based matters are serious, we allege are serious contraventions, and they relate specifically to not undertaking reconciliations of whether employees would be better off overall under the underlying award, which was required to be done under the enterprise agreements. And the second, now I've gone dark. The second alleged serious contravention relates to failing to ensure that staff were better off overall under individual flexibility arrangements entered into pursuant to those enterprise agreements. We also allege that CommSec and CBA recklessly misrepresented to some employees that they would be better off overall under the individual flexibility arrangements, and there are further alleged contraventions in relation to failing to ensure that employees were paid under the enterprise agreement provisions, but we don't allege in respect of those that they were knowing contraventions.
So, in short, some of it was accidental wage theft, but some of it was carefully constructed wage theft.
Those aren't my words. I would say that under the Act, as I said, the way that we've characterised it is under the serious contravention provisions which were inserted under the Protecting Vulnerable Workers legislation. And in that respect, we allege that it was knowingly within the framework of Section 557B of the Fair Work Act.
It says something when a major corporate, or a couple of them, can think that it's clever to construct wage theft. We're talking about financially literate entities here, CommSec and Commonwealth Bank. It's not as if they don't know how money works and moves around in the economy when they're dealing with, billions and billions of dollars. Can I go to the individual flexibility arrangements? That appears from the allegations that you've described here and that have been reported in the papers to be a substantial factor in enabling the theft of wages. So why do you think, or why is it the case that people engaged through IFAs are more vulnerable to breaches of the Fair Work Act?
I don't think it would be appropriate for me, Senator, to express a view on that when the matter's before the court.
This isn't the only place in which IFAs, though, are being used. So if you can respond in general terms, what is it about an IFA that might be appealing to somebody when they're standing there ready to sign to take up a job, that they sign regardless? What is it in an IFA that makes a worker more vulnerable to wage theft?
Senator, I don't know that I would characterise it in that way. Obviously, what we look at is whether or not the entry to the IFA or the terms of the IFA comply with the Act.
So can we talk about knowledge and power in the engagement moment when somebody takes a job under an IFA? Do individuals negotiating IFAs typically have the knowledge and experience of the industrial relations system to ensure that they are not signing up to an IFA that's worse than an enterprise agreement?
I wouldn't be able to, I think, answer that without speculating, Senator. What I would say is that obviously IFAs can only be validly entered into after employment has commenced and are obviously subject to the Better Off Overall protections in the Act.
And I appreciate your caution in your response, but you actually are our eyes and ears as at the Senate, right? And I'm not sitting in a room with somebody who's come to me at the Fair Work at the Ombudsman's office and said, look, things aren't right, or when a union's identified an issue and brought it to me and says something's not going on. But our job is to raise awareness, and it sounds to me, from the action that you're taking, that these IFAs rather, are a dangerous way for somebody to agree to to agree to an employment contract? Should people be aware of IFAs based on the action that you're taking?
I don't think I can comment generally on that, Senator, other than to repeat the comments I made about the protections that exist in the Act, and obviously both in relation to the allegations that we've brought, in taking proceedings, we've made a decision that it's appropriate to litigate in relation to those contraventions.
So in case, because you can't take the risk of putting an opinion on, can I just say to anybody who's watching or listening at this time of night?
Well, Senator, can I just, I think the questions were bordering on asking for opinion, and then you've just actually explicitly said you were asking for an opinion in your question. So
I'm asking for information based on their experience,
Hang
Chair.
on. So, Senator, I wasn't going to rule the questions out of order, but I think it's well within order for the official to say that she didn't have that information because it was effectively asking for an opinion. If there were some factual studies or something she could refer to, fine. But
there aren't any.
Apparently, there are that she didn't have that information. That's perfectly reasonable. Her response, I think.
Yeah.
Any more further questions?
I just think people
we
should
do
be
need to move on.
very aware.
The last
Don't sign an
witness.
IFA.
We're done.
I've got more
Okay.
questions on another topic.
Okay. Thank you very much. Thanks everyone from the Fair Work Commission. I will let you...
Ombudsman.
Sorry, Fair Work Ombudsman. Sorry, it's been a long night. Thank you, Senator Pratt. So we are now after... Thank you. We're now after the Coal Mining Industry Long Service Leave Corporation. Are they... Okay, so we want to suspend? We might just quickly suspend. Won't be long, so don't go too far. And I welcome officials from the Coal Mining Industry Long Service Leave Funding Corporation. Thank you, Ms Parks. Do you have an opening statement?
No, we don't. Thank you, Chair.
All good. I will go straight to questions then with Senator Roberts.
Thank you, Chair, and thank you for attending tonight. On the 24th of March, in response to my questions, the Coal LSL revealed that casuals and permanent coal employees accrue long service leave entitlements at different rates, even when they work exactly the same rosters. What have you done to investigate and to fix this disadvantage?
Senator, evening. It's Darlene Perks, CEO of Coal LSL. Just to clarify the question, if I can, I'll just replay it back to you. I'm interpreting a question in regards to the legislation. And if that's correct, I'd refer the question to the review that has been announced by the government, and that has been led by KPMG Australia to look at the legislative frameworks that underpin the Coal LSL scheme. If your question was in regard to the legislation, the actions that have been undertaken are linked to the review that has been announced by government to assess the legislative frameworks that are in place for the scheme.
As I understand it, there were some guidelines that Coal LSL, as I remember it rather, there were some guidelines that Coal LSL had made up that were wrong.
Senator, I don't have that information to comment. Our guidance notes have been drafted with legal review. So we're confident our guidance notes that are published on our website are accurate and informative in regards to guiding employers and employees in the industry in regards to our legislation.
Sorry, Senator, I might just be able to help. So it was my recollection from that set of hearings that Ms Perks outlined that the legislation did set different methodologies for the calculation. And indeed, she's correct that part of the coal long service leave review is intended to have a look at that and to see whether recommendations need to be made to address that. And that review is on track to be delivered later this year, Ms Wang?
Lace Wang, Assistant Secretary, Safety Net and Branch. And yes, Mr Hare is right. And the terms of reference require KPMG to complete the reviews by the end of this year, and they're well on track and to deliver that outcome in 2021.
Okay, thank you. Many casual black coal miners have been abused by the industrial relations system and by Coal LSL for its part has not paid them what they are due. You'll remember the abused casual coal workers in the Hunter Valley that we stood up for. Have you resolved all of their claims? What is outstanding, and why have you and the board not helped them until we got involved?
Senator, there's several questions there. The first one I would answer is Cola Lascelles, as the manager of the scheme and the regulator, are working within the legislative framework that underpins our activities. The effort since the last Senate, I would focus on the review that has been commissioned, and that has been led by PwC to review the calculations of a number of employers who employ casual employees in the scheme. So that is work that has been undertaken and is still continuing.
Ms Perks, as I understand it, as I remember it, you had casual coal miners individually complain to you and to Coal LSL, and Coal LSL did nothing. They just took the word of the employer, and those employees were later found to be correct. Have you found any more errors, and what have you done to investigate them to fix them up quickly? Why wait for a review?
Senator, I refer to previous responses to this question. The 8 individuals you're referring to, I think, date back to a Senate hearing in 2020, where 8 of those employees, we responded to their inquiries. 6 of the employees' records needed to be updated, and those hours were impacted in the range of 1 hour of entitlement through to 12, and that was 5 of the employees, and the 6th employee had an entitlement adjusted by 28 hours. And that's the work that happened, has been conducted and completed for those individuals. Those individuals were employed by an employer called Program Tessa, which I've updated the Senate in previous hearings in regards to, and the work is continuing with Program Tessa to resubmit the adjustment levies that are required to rectify those records that need amended.
I'm looking at an issue of governance here, Ms Perks, because surely Coal LSL admitted that they didn't do anything. The employees persisted. We got involved. Then Coal LSL admitted that they were in error. You mean to say you haven't done any investigation to see if there are more than 8 involved? What about checking the other employees on your books?
Senator, as I answered previously, a review is in train to assess the records that have been submitted from employers of casual employees in the scheme, and that review will help inform the appropriate next steps that need to be undertaken by the organisation.
Are you saying you haven't done anything other than the 8 employees? You haven't investigated for any further breaches of your entitlements? You're just waiting for the review?
Well, the review is the investigation tool, Senator. Outside of that, if we receive inquiries from individual employees, they'll be handled in the normal business operations, as we will with any inquiry coming into the scheme.
I might just clarify that there's 2 processes underway. So there's the KPMG, which is doing a review, and then Ms Perks also referred to a process being undertaken by PwC, which is looking at that much more individual grain level.
Okay. So just to be clear, the PwC one is undertaking basically as a subcontractor to you a review of the issues that Senator Roberts is referring to now. Is that the PwC one?
No, that's the KPMG.
That's the KPMG one.
Sorry, Senator, your question is to Mr. Perk, Ms Perk, and the review into the companies and Senator Roberts referred to, that's a PwC reviews. That involve, my understanding, and Ms Perk can correct me, involving looking into the data collected from the employers. And the KPMG review is the Government Commission, the review announced by the Minister.
Yeah, great, okay, yeah, that's
I
what I thought.
understand there's a third review underway, and that was a review panel was established to oversee office space. Is that correct?
Sorry, Senator. can
Was
you-
there a review panel assembled to review or to oversee office space? Your office requirements?
Senator, that is correct. There was an RFQ that was progressed late last year to look at office premises to accommodate our incremental workforce. And a new lease has been signed, and that was disclosed in our 2020-21 annual report for an office premises to accommodate the incremental workforce.
In any office space expansion process since the start of 2019, did you, as the Chief Executive, either directly or indirectly at any time, sit on, participate in, contribute to the decisions of the group, change membership of the group, influence or take over all or part of the management of this review process on office space?
Senator, as the Chief Executive Officer, I have been at several points in that process played a part in these the team. The decision in regards to the lease resides with the board.
What part was that, Ms Perks?
Senator, I was brought into the review at the final stages of assessment, and that was in March this year. The board asked me to be involved to do the final review. There were certain parts in that review which I was not part of, and that was led by another executive in the organisation. The recommendation to the board was from the team that was put together, and the board made the decision based on independent report from an organisation, Rambry Consultants, on what the right premises were for our organisation going forward.
Senator Roberts, I might just indicate that if you could try and wrap up in a minute or so, because that's about half the time we had. And I will go to Senator O'Neill if you're not finished, and then we can come back if there's time.
Can you confirm, please, Ms Perks, if your partner was a party in one of the groups that expressed interest in, tendered or submitted an application for this office space process between 2019 and 2021?
What you're referring to there, Senator, is one of the premises that was part of the assessment. My partner was not the developer of that premises. However, in his work, he has previously done or provided work to that developer, and as good governance, I was removed from the assessment process where that premises was included as an option. I was brought back into the process when that was removed from the process.
Final question, Chair. Ms Perks, why is Chandler McLeod no longer registered with Cole LSL? Could you please explain the reason for you dropping their registration as employer at a time when you're now prosecuting fiercely Tier 2 and Tier 3 companies about being registered?
Senator, Chandler McLeod is still a registered employer of Cole LSL. I have nothing of evidence to inform me that they have deregistered and aren't continuing to pay levies into the fund.
Senator, General Manager Legal of Cole LSL. Senator, they may be that Ready Workforce is the name that Chandler McLeod trades under, so that's what they're registered under, so that might be where some confusion.
Could you repeat that, please?
Ready Workforce.
They've changed their name again.
Well, as long as I've been here, that's what that's been their registered name, yes.
Thank you, Chair.
Thank you, Senator Roberts. Senator O'Neill.
Thank you, Chair. I've got 6 questions I'd like to sort of prosecute this evening, if I could. The Coal Mining Industry Long Service Leave Scheme currently has about 53,000 active worker accounts, and that means that there are 53,000 coal miners and their families in regional Australia that directly benefit from the scheme. Given the importance of the long service leave scheme to workers engaged in the tough and dangerous vocation of coal mining, what guarantee can the government provide coal miners that there will be no reduction in their entitlements as a result of the current review?
Take it that's a question
For government.
For the government,
Yes. Look, thank you very much for your question, and I can understand why any kind of review, I guess, gets people a little bit nervous. Change can be hard for people to cope with, but my recollection of the terms of reference of the review is that it expressly ensured that people would not be prejudiced by the review, but instead the purpose of it was to make sure that people weren't being disadvantaged.
So can you guarantee that the government is committed to making sure there will be no reduction in entitlements as a result of this review?
That's what it says, isn't it?
Yeah, so again, the terms of reference are also clear that the review will not consider any proposal, that would result in a reduction of long service leave entitlements for eligible employees or other policy issues in the industry outside of long service leave.
So that's a guarantee from the government, no reduction in entitlements.
That's the terms
Well,
of reference.
the terms of reference are very clear.
So in 2011, Parliament passed the Coal Mining Industry Long Service Leave Amendment Bill 2011. The bill was passed then with bipartisan support. The legislation introduced a number of important reforms, including enshrining the entitlement to portable long service leave in legislation and establishing the scope of the scheme on the basis of a defined industry rather than respondency to a particular award. Now, in moving support for the new reforms, the member for Dawson, Mr Christensen, made a speech where he indicated broad support and union support for the legislation. His support for the bill associated himself with the Minister's remarks, and a fair outcome was what he said it delivered. In contrast, the submission of the Australian Chamber of Commerce and Industry to the current review of the coal long service leave describes those 2011 reforms as a rushed and botched approach to addressing unintended consequences at a point of transition to modern awards and the National Employment Standards. Similarly, the ACCI submission goes further and calls for the effective abolition of coal LSL as a portable industry-specific scheme and the return of its funds to employers. Does the government share the views of ACCI? In particular, does the government intend to resolve from the important improvements to the coal long service scheme introduced in 2011 with the coalition's then, at that time, fulsome support?
Look, the terms of reference don't contemplate the things that you have just pointed out. Our position, I think, is made very clear on the terms of reference. This review is about sorting out the bugs so that it works for everybody, and in particular the people who have casual employment, making sure they're not prejudiced. It's not directed at anything beyond that very narrow scope.
So, to be clear, the government does not share the views of ACCI, which I just quoted to you, that this is a rushed and botched approach.
I don't. I'm not inclined to sort of quote on extracts taken on a line, from a big submission that I haven't read, right? But what I am prepared to do is say that what we contemplate by the terms of reference here doesn't sound like it's in that ballpark at all. And of course, we won't prejudge it. We'll wait for the report.
Right, and if there's anything you want to put on notice after that, Senator Stoke will be happy to receive it. Up to half of all coal miners are employed on a casual basis. This means that they have no access to personal leave or annual leave. However, casual coal miners do have access to long service leave if they accrue sufficient work hours due to those legislative reforms that I was just mentioning of 2011. What guarantee can the government provide to casual employees in the coal mining industry that their rights and entitlements will not be diminished as a result of the review of the coal long service leave scheme?
I've already answered the question. The terms of reference already say that casual workers are to be assisted, not diminished by this review.
So,
and to the extent that other entitlements of casual workers have been identified by you in your question in relation to sick leave and annual leave and the like, those are covered by the casual leave loading that is supplied to people who are casual workers, and indeed that many casual people prefer to receive.
well, we have had many discussions about the claimed 25% and the reality of what people actually get in their pay packet, and that's going to take longer than the few minutes that we have returned. So I'll just go on to, let's just say that the rhetoric is not matched by the dollars in the packet.
Please.
At present, many casual coal miners do not receive the entire value of their long service leave accruals due to the nature of the roster, the particular roster that they work. In other words, they actually work full-time hours, but those hours are often compressed in 1 week and shortened in others, as their roster averages ordinary hours over the roster cycle and not a calendar week. Now, the main industry parties have proposed that the solution to this inequity is to allow the Coal Mining Industry Long Service Corporation to calculate these workers' accruals by reference to a monthly average. Does the government support this proposal to protect the entitlements of casual coal miners?
I don't cavil with the problem you've identified. We understand that there is a certain bugginess in the way that casual workers' long service leave reporting seems to occur under the current regime. I'm not going to preempt what the report is going to advise us about. That may well be one of the options that's suggested, but we'll wait till we get the KPMG report, look at all of the options presented, and then the government will respond with all that evidence in front of it.
And it is proposed that it would be by the end of the year. Do we actually have a date when that report's likely to land, and will there be a sufficient chance for us to interrogate that in the Parliament before we rise?
My understanding is it is truly the 31st of December, is that right?
It's certainly late December.
Yeah, it's late December.
So there's going to be no scrutiny of it. It'll land on.
There'll be a beautiful New Year.
New Year's Eve. Okay. Well, I hope that there's a no penalty for casual coal miners embedded in it. There has been intense lobbying by some maintenance contractors and their representatives to exclude their workers from the coverage of the Coal Mining Industry Long Service Leave Scheme, even though these workers are permanently based on coal mines and perform work that's integral to the operation of those mines every shift over months and years. What guarantee can the government give to coal miners who are employed by maintenance companies that you will not introduce legislation to take them out of coverage of the Coal Mining Industry Long Service Leave Scheme?
Senator O'Neill, beg your pardon? Senator O'Neill, I don't know how many times you'd like me to slice and dice this, but the terms of reference are pretty narrow, and they say what they mean and they mean what they say, and I think we don't have to sort of confect every possible example under the sun when it's pretty clear what the terms of reference say.
I do remind people we're past time now, so I presume we haven't got 2 minutes.
Sorry, I didn't mean to speak over you, Ms.
And we're right with hands
Just a
down?
clarifying one on that, and then just on to the last question. So,
All right.
Ms. Wang, did you want to add?
No, I think the Minister's covered as well.
Okay, so can I just respond by saying we can talk about slicing and dicing, that's part of the problem, that there will be parts of what is currently captured in the long service scheme that will end up outside of it as a result of this process. And I'm particularly concerned about the maintenance contractors there.
This is a scare campaign, Senator O'Neill. The terms of reference
Well, I hope that
narrow.
that's all it is.
The terms of reference are narrow. It is just about sorting out this one problem that has been identified in relation to the casual workers under the scheme. It's not a grand conspiracy. It's gathering the evidence and making a sensible, well thought through solution to a practical problem. It's not a conspiracy.
Last question. Thank you, Chair. The submission of the mining union to the current review of coal long service leave argues that deliberate non-compliance with the scheme is a significant problem amongst a minority of employers in the industry. The non-compliance issues range from the late provision of mandatory employer returns through to an outright refusal to recognise the scope of the coal mining industry scheme and therefore to contribute the employer levy. The effect of this non-compliance actually is twofold. Workers miss out on their rightful entitlements, but complying employers also end up losing because they carry a heavier financial burden than they otherwise should. Having regard to these matters, what confidence can coal mine workers and complying employers have that the government will provide the Coal Mining Industry Long Service Leave Corporation with the support and powers it needs to effectively tackle non-compliance?
Well, non-compliance of the kind you just described is already a problem under the current regime, in the sense that if those things are done, they contravene the existing regime, and there are processes and penalties that exist for those who don't comply with the already existing regime. But the process of actual enforcement lies with the agency itself, and so it might be prudent for Ms Parks to comment at this point.
Can I just...
Of course.
Is that right? Okay. Sorry, just to want to also add that the terms of reference also specifically state and asked the KPMG as an independent reviewer to look at ways can enhance the compliance and enforcement framework and underpin the legislation. So that's part of terms of reference as well. So the other thing, if I may just add, Senator, you were saying as a part of the 2011 amendments and the maintenance workers coming, if they work on the coal miners, coming under these schemes, and certainly as the Minister has indicated, the review, it is out of scope of this review to reduce any of the entitlements.
Thank you. Ms Perks, did you want to indicate the processes and penalties and how effectively they're being implemented for breaches?
So, Senator, the breaches you talk to, the avenues that we're able around enforcement to look to really, it's litigation if people don't want to register to the fund. But what we have found is that the vast majority of companies come on board through the engagement process once they realise the obligations. But there is a cohort, I suppose, of companies that have decided that they won't sign up, and that the only option we have is to litigate, and that's what we're doing at the moment in regard to some of those companies.
So the current review, do you have any hope that that will aerate the problem that you've just described and move the government towards providing a better solution than forcing you to litigation?
I think, as Ms Wang just pointed out, it is certainly one of the issues that's been raised during the consultation process around the KPMG review. So hopeful is a good word.
And if you could, on notice, just provide a sense of the scale of that problem. So I really haven't got a good oversight of that. That would be helpful. Thank you. Thank you, Chair.
Thank you, Senator O'Neill. Thank you. Oh, you're testing me, Senator Roberts. Very quick.
Senator Stoker, there's a lot of distrust in the Hunter Valley in particular, to some extent in Central Queensland, because miners have been injured seriously, totally and permanently disabled, told if they report their accident, they'll be fired, then fired anyway and not even given notice. They haven't got their entitlements through Coal LSL. They haven't had their workers' compensation payment. They haven't had accident pay. They've been underpaid relative to miners doing the same job next to them, right next to them, but permanent employees. They've been employed illegally as casuals when they should have been under permanent award, starting in 2014, 15, 16. These people don't trust. They've been to the Liberal state government. They've been to the Liberal national government. They've been to their local Labor Party members, and no one has helped them.
Okay, Senator Roberts, we'll leave it there.
I'm
Take
just
that as a
explaining.
comment. And it being past 11 o'clock, I'll conclude today's proceedings. Committee is due to continue supplementary budget estimates tomorrow. I do thank Minister Cash and Minister Stoker and all the officers of the Attorney General's Department, also any other officials that have provided evidence, and thank you also to Hansard Broadcasting and the Secretariat. Good night.
And the Department for great snacks.